7.
Item 1, my lord, for extension of time to surrender. Item 1.
I'll take it up. You want
My
that?
lord, my lord.
Anybody who wants an
Page 2, item 8 to 20. Page 3, item 21 to 32.
Item 29.
Yes.
Can you, after launch, after vacation, my lord. Interim order to continue.
press matter entry mode.
Okay.
Yes.
Page 4, item 33 to 43. Page 5, item 44 to 56. Page 6, item 57 to 66.
Item 57, compromise matter. Time taken.
Parties have come.
Yes, ma'am.
I'll take it up.
Okay.
Once the party comes, you just tell me so that immediately I get it.
Aye.
Yes.
Page 7, item 67 to 80. Page 8, item 81 to 88.
Yeah.
Page 9, item 89 to 94.
I'm sorry to my lord. Item 79, my lord.
Yes.
I want to take more time, but there is a compromise is going on.
Okay. Then counsel for the petitioner submits that the settlement process is going on. Adjourned.
After that,
Item
after
93.
long.
Item 93, my lord.
93.
I paid for after vacation, there is no increment.
Okay.
Page 10, item 95 to 104.
98, my lord. After vacation.
Why?
My lord, 202 statements required, my lord. No interim order is there.
Pardon to mention, my lord.
Yes, sir. Yes.
Item number 101, my lord.
Yes.
Kindly be taken, my lord, after vacation.
It's a revision.
My lord, no, my lord.
CRLMC.
Huh?
CRLMC.
Press admission.
Thank you.
Yes.
Pardon to mention, my lord.
1 minute.
Page 11, item 105
Sorry,
to
sorry.
110.
My lord, 20, item 21, both party come to.
They are there.
Asichanti ଟିକେ ଦିଟା ବେଳକୁ ଆଗେ ସାର।
No problem. Anytime you bring them.
My lord, I have no pass କରଲା ବେଳକୁ ଟିକେ ଡେରି ହଉଛି।
All right, no explanation. Let them come at 4 o'clock.
21, item 21, 21।
No problem.
ladies ଗୁଡା ଅଛନ୍ତି ଟିକେ ଡେରି ହବ।
Yes.
ତେଣୁ ଦିଟା ବେଳକୁ।
I'll wait for you.
Thank you.
Yes. Yes.
CRLMC 2097 of 2023. 311 of service minor. I have given several memo, but still on listing minor.
There must be some problem. That is the reason. Anyway, once again, we'll see.
Fix
Today,
it.
please persuade
Any
me.
date, my lord.
Please just see. Yeah?
My lord.
Several memo means how many memos?
Uh,
Several has
4 to 5.
4 to 5.
My
Eh? Every day you give memo. Anyway, we'll see. Okay. Yes, sir.
My lord, appeal against conviction, vigilance case. The appellant is in
I
custody.
told you the old case you have to argue, not the new one.
New, what mistake? Old.
Mr. Maran has an objection for this.
No,
Always
old-
he is interested in arguing the press matter. One day you have to dedicate for it.
Appeal against conviction, my lord. 4 years conviction. The appellate face conviction. I pray to.
Tomorrow.
Another matter,
He
my
is in
lord.
custody.
He's in custody. 4 years conviction. after-
Tomorrow. Okay.
My lord. Another matter, my lord. Once CRLMC 41 complied with, but the duty, the
Give the
NBW.
memo, we'll see that. Give the memo, we'll see.
Tomorrow.
How can we? Not tomorrow. That parliamentary is enough.
Of 2019, my lord, pleadings have been completed. The matter was specifically adjourned to 4/4/2004, but it has not come.
Give all memos, we'll see.
Belgium.
All give all memos, we'll see. Yeah? Give the memo.
But I have filed 2 memos, CRLMA, cancellation of bail. After releasing on bail. by-
People are struggling to get bail. You are
They
interested.
have mercilessly beaten me to the,
After
after releasing on bail.
you have filed any FIR for that.
Yes,
The cancellation go to the same court.
my lord,
See, bail condition is violated. You go to the same court.
this Honorable Court has made observation that if They have violated any.
Which court has given bail? This court?
Have
Then
given.
see, take it and see. Huh? Ninth.
May I be pardoned to mention, my lord?
Okay.
There's an urgent matter, my lord. It's a CRLMC. My lord, we being the advocate had sent a legal notice to the IIC Mahanga for harassing our client, my lord. What happened thereafter is, my lord, instigating another person, he has instigated that person to file a 1cc against us and got it registered as an FIR, my lord, against the advocate and as well as my client, my lord, without any basis whatsoever. And
Then what is the urgency about
the
it?
urgency is, my lord, that I am apprehending arrest, my lord, that has been registered as a GR and absolutely a false case and without following the principles laid down in
If
Priyakash.
you are apprehending arrest, you have a better remedy.
I understand, my lord, but my lord, the entire case is, my lord, we being advocates.
Okay,
my
you
lord,
keep the memo.
ma-
See,
ma-
how can we add this? Huh?
tomorrow day.
I want to mention, what
Yes.
is CRLMC 1582. It is about issuance of non-valuable warrant dated in the court of
Tomorrow. Okay, tomorrow. Take it.
One five-
NBW. NBW.
Sir.
Tomorrow.
Item 47 permitted to withdraw.
47 withdraw. 47 withdraw. Yes.
Item one.
Item 1, huh?
Yes, special.
Specialist. Special.
This
One
matter,
special.
Mr. Mahapatra.
Yes, my lord.
See, there are some problem. I'll tell you. When I gave the dictation.
My lord, I found it. The problem is with me, my lord. I have given the Xerox copy. The original is in my file, my lord.
But in the process of this, you lost boarding the train.
No, my lord. I understand. I was second time.
That is one problem. See, you have not filed the Wakalatnama. This is one thing.
No, yes, my
And
lord.
there are many discrepancies I found in the.
Permitted to file better application and appropriate time, my lord.
You better do that. Don't do.
Yes, my lord. It was in a hasty manner.
Photocopy you have filed.
The original inadvertently missed. I have tender apology, lordship.
And see the affidavit, all the affidavit you have attested, the date is today. Yesterday you have filed the petition.
My lord.
One problem is there, one can ignore.
Yes,
But
lordship.
a page by page, every page is a problem.
My lord.
And I dictated the order. I took up the matter at 6 o'clock. I called Mr. Ragada.
I know.
I gave dictation. Then
My
while
lord,
correcting, I
the
saw.
best thing is that my lord wish is complete. He is giving exam. The VC has permitted. So ultimately, my lord order is wish is completed.
And the God is always there.
Yes, lordship.
with
That is
the
what
right
lordship.
people. But don't even do that.
No, my lord. This is not intentional, lordship. Never.
See, it is inconvenient to the registry. It's inconvenient to the staff.
Yes,
Inconvenient.
yes,
6 o'clock, I in the chapel
No,
took up the
I understand.
I
lordship.
gave dictation in front of you.
Lordship, I am grateful, lordship. I'm extremely sorry. But the mistake is mine, lordship. I was just discussing with sir also.
Maybe you are, may not be you are deliberate, but it is very disheartening.
Yes, I'm sorry.
You withdraw it.
I'm withdrawing it to file a better application in appropriate time.
Mahapatra led counsel for the petitioner seeks to withdraw this petition to file a better one. And a better one. Now, why don't you apply there?
I'll file better application when appropriate time, my lord. No,
At the appropriate day. If cause of action.
yes, lordship. My lord, my world Wakalatnama may be replaced.
Mr. Mahapatra has also replaced the Wakalatnama.
Yes,
Original Wakalatnama.
Yes.
I know this Wakalatnama, it should be there on the record. Otherwise,
Yes, lordship.
take it on record.
My lord, that photocopy is there also. That is what I'm.
But we couldn't help the boy, but God has helped him.
Yes, no, my lord has helped me because my lord wish has complete one.
All right.
Oblige, lord.
Okay. But please be careful in the future.
Certainly.
Don't do that.
No.
And if you have any problem, fair enough, you come to the court and say that this is the problem. That is the problem. I dictated the order when I saw. Then I had a lot. Every page there is a problem. Then I asked Mr. Ragada, how can you proceed with this matter? He said that it is your discretion. I say that my discretion means I'll list it tomorrow. Okay. So,
no.
Item one.
My lord, I pray for extension of time to surrender by 2 weeks.
2 weeks.
2 weeks time will be granted to surrender.
You are supposed to appear.
On 2/4/2024, this order was passed.
Currently before the court within a period of 2 weeks.
2 weeks.
Where is your application?
I have 1121.
Lucky.
Acha. Taking into consideration the contention raised by the petitioner in the application, 1121. The period for surrendering before the court is extended for the period of 2 weeks. I'll give a date. You when do you want to surrender?
2 weeks.
On or before I do?
My lord, honor.
When? You tell me. So that you need not come once again to the court.
And I will never come. I also ordered.
No,
2 weeks.
15th June I'm giving.
It will be too much. My lord,
Okay, 15th
15th
June.
June. Okay.
On or before 15th June.
Yes.
So that you need not come to the
In the
court.
meantime. In the meantime.
Yes.
Item 2.
Extended till 15th. Yes.
Item 2.
May I please, Lordship.
Yes.
My lord, here the petitioner is asking the order of the learned additional session judge
Okay.
dated 27/3/2023, my lord. Here my limited prayer is to the confiscation proceeding is pending before this 49/2020,
Right.
my lord. My limited prayer is to approach before the confiscation authority.
The application moved by the petitioner under section 457 CRPC. Yeah.
Yes, ma'am.
Where is the order?
My lord, order is on running page 20, my
In order, sir.
page number 20.
Annexure.
Annexure 4, my lord.
Annexure 4. It is rejected saying that the confiscation proceeding is pending.
Yes, my lord.
Then you want to participate in the
Revision order, my lord.
You want to participate in the confiscation.
Yes, yes, ma'am.
Right. The petitioner had moved an application under section 457 CRPC seeking release of his Hero HF Deluxe motorcycle bearing registration number OD 07D 3168. The court of JMFC Calicut
Yes, ma'am.
by order dated 11/6/2022 rejected his application, and he filed a revision being criminal division number 2 of 2022. The court of additional
2 of 2020.
Calicut by its order dated 27 March 2023 rejected the revision as well. Hence, he has approved this court. Then counsel for the petitioner submits that both the courts below have rejected his application under section 457 CRPC on the ground that the confiscation proceeding is going on. He seeks liberty to withdraw this petition and participate in the confiscation proceedings. With the enforcement liberty, and liberty is granted to the petitioner to participate in the confiscation proceeding. In view thereof, the present petition is disposed of with the liberty as granted. Go and participate. Yes.
Item 3.
Yes.
3 Lordship prefer Passover.
Paso.
Item 4.
Item 4, Lordship.
Yes.
I challenge the order of against Lordship. And as per direction of Lordship, 2 times postal issue sent to the informed opposite party number 2, Lordship. But it is unsolved, Lordship. Lastly, Lordship directed to send a copy of the miscellaneous petition to the Mithali Thana, PS, Lordship. I already supplied the same, Lordship.
He supplied the copy, my lord, on 2/5, my lord. That day case had not reached, my lord, did not reach. My lord, again, my lord, direction were given to send serve the copy through the IS.
So then
On 6/3, they have not supplied the copy, my lord. Later on, supplied the copy.
the extra copy of the brief was supplied to the State Council.
On 2/5/20.
State Council on
2/5/24.
Therefore, no instruction could be obtained. Mr. Ragada seeks 1 week time for seeking instruction. Urgent.
Lordship, my prayer lordship, let the interim order be passed, lordship.
How can I pass the interim order? If you wanted interim order, you should have given the copy. I have given the intelligence. You immediately let him get the instruction.
Let him fix it.
Yes.
Fix it.
He will give it.
Item 5.
The point. Huh?
Item 5.
Urgent. Yes.
Item 6.
Fix.
Item 6.
Defects are removed.
No, my lord.
19.
There are 1, 2, 3, 4, 3 adjournments.
See, he
And he has also filed the
12th January.
appeal that
12th January, he took time to cure the defect. He has not cured the defect. Huh?
Minor defects.
Huh?
Minor defects. Copy.
Whatever, but he taken time thereafter to
there are 2 defects.
hearing has taken place. Anyway, pass it over, we'll see. Otherwise, you dismiss it. Okay.
Item 7.
Yes, sir.
Notice was issued, but nothing is neither AD nor postal has returned back. No one has also appeared.
Receive service.
The office noting is neither neither the postal document nor the AD has come back.
Subsidy?
Another
Outing service.
awaiting service. Entry order to continue.
Service sufficient.
Service on the opposite party number 2 is sufficient. However, none appears. In the interest of justice, urgent to consider the interim order to continue.
Obliged.
Yes.
Item 8.
May I please your lordship, here I have challenged the order of cognizance at annexure 3 dated 10/1/2022. Kindly have a glance to the 10/1/2022.
Yes.
Kindly have a glance to the FIR my lord at page 8.
Yes.
It is a civil in nature. There was an agreement between the accused and the complainant for sale of a piece of land, for which it is alleged that the complainant has advanced 90,000 rupees to the accused. Thereafter, accused has not registered the sale deed.
Why don't you do it?
So, my lord, they have convenes a meeting, the accused agreed to execute the sale deed. But the complainant has lost this.
You have taken the money.
Yes, that is the allegation, my lord.
But have you taken or not?
Not the total money, my lord.
How much you have taken?
50,000 rupees.
No.
Out of 90,000, 50,000 you have received.
Advance is given.
Advance
Show me
is-
the agreement.
Agreement is the oral agreement.
Who is going to believe it?
And my lord, it is civil in nature totally.
That's right, but you are saying you are telling 50,000 rupees. He has
50.
paid 90 lakh rupees. There are a lot of difference.
And my
I
lord,
was
it is.
just thinking that it can be sorted out.
My lord, and
opposite party opposite party
just a minute, my lord. It
Opposite
is
party
already.
have not
It is already 3 years over, my lord.
It's all right. You implead opposite party. I'll issue
It's
notice.
a-
Let us see.
Okay, my lord. Very impediment.
Implead.
Just now I am
If,
impeding my.
if there is something can be worked out, why not?
Yes, my lord.
Right now, then counsel for the petitioner seeks the leave of this court to implead the informant.
Informant.
The opposite party number 2. Let him do so during the course of day. Issue notice to opposite party number 2. Returnable this side of the vacation. Let us see. You bring them. Bring
Yes,
them.
yes, my lord.
We can sort it out.
Yes, my lord.
Sir is sitting just up. Which matter?
Sir.
Item number. Item number.
30.
Fresh matter, sir.
No, it is a matter.
Is after notice or fresh?
I'm for the other side.
Okay. Then not.
For the other side.
Yes.
Item 9.
Yes. Do it now and file. Just see who is appearing for the other
Sir.
side. When
So,
sir,
sir, 30.
if he is there, I'll take it up that matter.
Tushar
Tushar
Ansar.
Ansar. Okay. The moment he comes, then tell me. Yes.
The Belgium matter, my lords. NBW was issued on 18/4/18, my lords, and he was released on bail on 16/11/2015, my lords.
Okay. 500. Yes.
Item 10.
Yes.
May I please, your lordship?
Yes.
Your lordship, in this case, the petitioner prays for the questioning of the entire criminal proceeding as well as the questioning of the entire criminal proceeding. Your lordship, this.
Cognizance order also. Huh?
Yes.
Is there any cognizance order?
No, your lordship, for questioning of the entire criminal proceeding.
Yes. Cognizance has been put. Why? On the what ground?
Your lordship, this alleged offense purportedly happened way back in the year 2000 under section and the police turned up fast. Your lordship, in this case, there are two affairs. First of all, the Khordha police station lost affair under section.
All right. What are the grounds, you tell me?
Your lordship,
Why washing at this stage?
your lordship, the case dates back to the year 2000, and after 24 years, there is nothing happened in this case, and trial is yet to start, your
In
lordship.
2006, the cognizance was taken.
Yes, your lordship.
Where-
Cog has taken on the on 8/1/2006, my lord.
Huh.
From 2006 to till now 2014, 24, my lord. 18 years. So within that.
You show me the proceeding, why it is delayed. If it is attributable to you, you can't take the benefit.
Your
If
lordship.
it is attributable to prosecution,
Yes, my
we'll
lord.
see.
Yes, my lord.
Show me the proceeding, if that is the ground.
Your lordship, the case was registered in the year 2000.
That's everything. Is correct.
Then again, your lordship, the police went into hibernation mode, and for 6 years, nothing happened. Your lordship.
Where from I'll get in this record that the delay is attributable to the prosecution. You have to file the proceedings of the court below.
Yes, my lord.
Because 2006, the cognizance is
Cognizance
taken.
has already
Charge
been
was
taken.
framed thereafter. What happened thereafter? Let us see.
Your lordship, charge is yet to.
Charge has not yet been framed.
No, your lordship.
That means the petitioner may be abated to the court. The court proceedings of the
No,
court.
will not make. No, you get the proceeding. It's a good case where it can be quashed.
Yes.
You
Your lordship may call for the LCR from the.
I will not call because it is your petition. You have to substantiate. I'm just giving you one opportunity. Next week, you get the certified copy. Bring the proceeding. If the proceeding indicates that is delay is because of them and charge has not yet been framed, I will straight away quash it on that note. Okay.
Yes, your lordship.
Next week.
Item 11.
Get the photocopy of the proceeding also. No problem.
Yes, your lordship.
Come with the proceedings.
Yes,
Let us see the proceeding.
Your Honor, this is the story of a family who are friends.
Sorry.
The accused was given money of
Item
11.
11.
Then
Yes, sir. What is this matter is about?
It's a family friend matter, Your Honor. The accused, as per the story of the prosecution or the complainant, he had filed a complaint case before the magistrate, which was directed to IU for investment under 156(3), and charge sheet was submitted against him. This
my lord, I'm sorry to say that copy has not been served to the state, my lord.
No, I think this is, I don't understand what is this meeting about.
State hospital. That is 11.
Discharging the petition.
6, then different number 6.
420.
Different number 6 is there, my lord.
Huh?
Copy notes. Copy notes.
Mr. Chabra,
Sir,
you have not cured the defect. You have to give a copy to the state council.
Your Honor, I will send by email.
Do you have email ID for the state council?
No, here in the local ADM office, we are submitting them and they are submitting to the AG office.
No, this is a very circuitous method. That never comes. That's the problem. Do you have any junior here who can give a copy to them?
I'll look to it, Your Honor. And
I'll put it next week. You please do it. Okay.
Sir, Monday will shoot, Your Honor.
Okay, Mr. Chavra, Mr. J.S. Chavra, constitutional petitioner seeks 1 week time to comply, to cure the defects pointed out by the registry. Release the matter. Yes.
Item 12.
Item 12, my lord. I lost the complaint. My complaint has been accepted and sent it for lodging of FIR. FIR has been lost.
I heard that I lost the complaint. I thought that you lost your brief.
Yes, Lord.
Yes.
And the prosecution has submitted the report insufficient of evidence. The learned magistrate, my lord, sent the notice on 6/9 to submit the answer to about that insufficient of evidence under Annex 3, your lordship, page 37. Page 37.
Yeah.
Where the processor was given the report, I left for Raipur. Again, they have without any.
You are agreed by which order?
Order passed by the learned magistrate under Annex 5 at page 40.
5. Let's see what is this order is about.
The answer that the case record is put up for acceptance of final report submitted by IO. Notice was issued to the informant and served upon him. He has not appeared to protest against the final report.
Running page 41, my lord. Your lordship.
And there is less chance of appearance informant, hence final report.
You are for
accepted.
informant.
I am the informant. I have been cheated by 50 lakhs.
That's right.
By-
When was the charge sheet filed?
And charge sheet has been filed, my lord, on dated 10/5/2022.
22.
Yes.
Yes, Mr. Rahul.
my
He has a right to file protest petition. How can it be closed like this?
My lord, your lordship
And subsequently, I prepared
yes,
the
the
review.
record is put up for the acceptance of a final report submitted by IO, my lord.
Right.
Notice was issued to the informant and served upon him. He has not appeared to protest against the final
Now he
report,
is,
my lord.
now he is here.
So, my lord, if my learned brother is interested for his counsel, a petitioner, that petitioner may again maybe
That's right.
able that right,
You have
no
right to
problem.
do-
Any date,
But-
any date.
There is no limitation prescribed, as said.
But my lord,
You have a limitation for protection.
No, because the
my lord, but the
Yes,
according to
exactly.
your lordship can have a glance that this is a one
set
CC case.
I'll set aside and leave it to him. Whether he files or not files, that is his problem.
OP, my
May
lord,
pray only
without
one.
hearing the OP, my lord, that may be the
No,
question of
he has a
liberty.
right to file protest petition.
Yes, my lord.
2022, the charge sheet was filed.
Yes, my lord.
Okay. Somehow the notice could not be served upon him. And ultimately the court closed the entire right
My lord,
to file protest.
here in this case, my lord, also my learned friend should make a party to the opposite.
No, there is clear case has been made and FIR has been
Because
cumulated
already-
insufficient of evidence.
Nice, clear case or not, no case, we are not deliberating on that.
Yes,
We are only on this page 41.
yes, madam.
It is apparently, according to me, it is against the law. Against
And that has been confirmed by the revisional court.
Yes, my that has been confirmed by the revision.
And the same finding, it is there is no necessity to filing. But I have a right to file.
where is that?
Your lordship may kindly see page 45,
40?
45. And operative from the above discussion, this court is consider view the impugned order supported by cogent evidence for which it is liable, not liable to interfere with, and the criminal division is dismissed on contest.
From your defense, the court is consider view that the MP not has been supported by the consent reason for which not liable to interfere. What is the reason given?
No reason has been given.
Right.
Only upheld.
Petitioner is agreed by the order dated. Where is the order, sir?
12/11/22, page
No.
41.
Revision court order.
Revisional order, my lord.
29/8
Yes, ma'am.
2020.
29/8.
20, passed by the second additional district judge, Judge Rahul Kela, in
Rahul.
criminal revision number 3 up to 2022. 2022. Full stop. The grievance of the petitioner is that he was the informant or the complainant in the FIR number
348.
file number, ये देखो PS case number.
PS case number 348 of
Plant side PS case number 348 of 2023 under section so and so. After investigation, police filed charge sheet. Police filed closure report on 10/5/2022. 10/5/2022. Notice was issued to the petitioners, information by the court below before accepting the closure report. It appears service could not be effected for various reasons. Eventually, on 12/11/2022, the learned trial court passed the following order. This is 41. The said order is bereft of any reason. Next one. The petitioner essayed the said order by filing the criminal division before the court of the additional before the court of second additional sessions at Raulkela. The revisional court has passed the impugn order. Dated 29/8/2020. The petitioner is actually the said order. By way of the impugn order, the petitioner's right to resort to the remedy to file a probate petition, file a protest petition against the closure of the case by the investigating agency is taken in. The said right is a statutory right bestowed upon every complainant. And the same cannot be taken away without any basis, I have perused the impugn order and consider the documents placed before the court. I have to consider the view that the impugn orders are devoid of merit, hence it is set aside. The petitioner is given liberty to file protest petition before the court below if such petition is
My lord, I may pardon, but in the revision, my lord, that has been displayed by the magistrate judge, my lord, not within an endorsement on thus much by that complainant petitioner of this revision, Mr. Pavan Kumar Agrawal, has denied to receive the notice.
Anyway, it was granted to the petitioner to file protest petition. If such petition is filed, the same shall be considered in accordance with law. Yes.
Pardon to me. The affair dated, your lordship, 23. It is 2018. 348 of 2018.
Yes.
Item 30 minutes. If I'm not here, maybe adjourn to next week.
No. With the other side, I'm rather waiting for the other side.
Notice has been issued.
Notice not.
Yet been issued.
You are seeking an adjournment.
Yes. Next week.
Gaurimana Ratha.
Achanti.
Gaurimana Ratha.
The name is Chief.
And he's there. The gentleman is there. Please come. Item 30. Yes. Yes.
Yes, your lordship. We were also senior.
You agree for this?
Yes.
I'm a little awkwardly placed.
Yes.
Obliged.
I want to mention one. There was a defect of non-payment of the OP. I've already paid that, given the. Yes.
Cure the defect, no, already. Yes.
Item 13.
13.
30.
9.
1-3. What is this petition?
13 a prayer for extended period for surrender, but no is there.
Extension.
My lord.
No, where is the application? Nothing is there. 13, 1-3, na? Defect number 6 as per SR is not cured.
Copy.
Copy. You got the copy?
Only IA copy, my lord, yes.
IA is not there. There is no IA.
Only simply one page IA.
Right. Registry has pointed out certain defects. None appears for the petitioner. Registry has pointed out certain defects. By way of last opportunity, 1 week time is granted to cure the defects, least also. Yes.
Item 14.
Now the offense is 419 and 420. And we have been summoned by the Lord and Court below under Annex 3, page 26 for appearance loss.
Yes.
We are not in bail. And in the meanwhile, the financial transaction 1,20,000. And part of the payment is already returned from one of the informal lots. I pray also you may be directed to be charge sheet submitted. You may be directed to surrender, regularize and bail also.
Your Lordship may kindly have a glance to the running page of the petition, page number 2, my lord.
Petition?
Page number 2 on the London Council's declaration, my lord.
Yes.
Yeah.
Can I suppress the
No. Sir, that's only I am
Your
trying
bail
to
applications are rejected.
bring the knowledge of our learned
Not
honorable court.
For the changing circumstance there, your lordship, a glance. Page 24.
How many bail applications? 1, 2.
The 3 application petitioners are there. They file independently file.
3 bail applications are rejected. You are making the case so simple.
Independently they have been filed. Your lordship, but it's a case of 2014. Your lordship. Now it is a 2024. Substantial justice will be benefited if your lordship, the record will be regularized. Your lordship. One of these persons neither they are surrounded.
They are absconding.
Yes, ma'am. May be permitted to surrender or regularize the remedial lordship available under the law.
That's right. but-
Yes.
Where is the FIR? What are the allegations?
The FIR
Why
also
this-
plans.
419,
FIR
420,
application
34.
Yes, FIR application there were rupees 1,20,000 has been taken by accused Sandeep to provide job in Tata Power Limited LLC. And later on lordship issued a fraud engagement certificate. They found that it is not genuine by the authority. Then FIR has been lost.
It's not money, it is something else.
The money lost.
No, money, you have taken the money to
provide job.
Create a false document and all. That is the reason bail is.
Yes, my lord.
But
And
how
not
the
only
lordship
this
summons
petitioner, my
has
lord.
issued to me and also not that warrant.
What is the
summons-
stage of the investigation?
Only summons lordship issued after submission of charge sheet page 26 annex of 3 series lordship have glance.
Or then you appear, I
Summons-
record all these things.
Yes,
Much
ma'am.
time has passed in between.
Yes, ma'am.
And record it and go and surrender.
Yes, ma'am.
Right up. Petitioner is agreed by the order dated.
The not in the order of lordship, I asserts the summons lordship.
Summoning order date you don't have.
That is a lordship 5/9/2023.
The summoning order dated 5/9/23, whereby the court below has summoned the petitioner to face the trial in FIR number so and so. It is contended by the petitioner that the FIR was lodged against the petitioner inter alia, alleging that how much, what is the money you are taking?
1,20,000 euros.
You have taken 1,20,000.
Out of which 35,000 is already refunded.
1,25,000 rupees from the informant with a promise to provide him a job. Thereafter, a false appointment letter was also given to the petitioner, given to the complainant. Therefore, the FIR was registered. Mr. Das, and accounts for the petitioner, submits that out of 1,20,000 or 20,000.
20,000. 35
his clients have also returned a substantial amount to the informant. After investigation, charge sheet was filed showing the petitioner's absconder. Therefore, the court below has issued summons.
30,000 return करचंती देचन 35,000.
Mr. Das further submits that Mr. Das on instruction further submits that his clients would surrender before the court below on or before 15th of June or 25th of June. 25th of June. 25th of June and avail remedies available to them under law. Hmm? And
35,000 check though they chanti learned senior. No, no, there is a cancel. Annexure
I'm
number.
recording his statement only.
Only one.
Uh,
Hmm. That is your submission.
subject to petitioner, petitioner surrendering to the court below on or before 26th of June. So, the summoning orders issued by the court below, post court below, shall be kept in effect. Execution of summoning order shall be kept in effect. If any such application is moved, the same shall be considered on the same day. So I have recorded everything. I think that serves the purpose. I can't do it because you have burned your fingers by moving repeated applications.
I pray before this is substantial justice. Everything has been turned
And
down.
petitioner also, Mr. Das also submits that in the year 2000, the FIR is of year 2014. And in the year 2014, the petitioners have approached this court for grant of bail, which was rejected and rejected. Much water has already flown under the breeze by now. Therefore, he seeks indulgence of this court. Since I am not considering the bail plea of the present petitioner, I prefer it to relegate the petitioner to the court below to raise all these points at the time of disposal of his application for grant of bail. You will get it, please.
Yes, yes, sir.
Indirect granting bail.
And here there is not only this person affected, there are other 6
I
members
know.
also.
But 2014,
Yes,
nothing has happened.
Yes, ma'am.
Yes.
15, on behalf of Mr. Saurabh Tribhuwan, I pray for an adjournment. We will remove the defects in.
Council, the petitioner seeks time to cure the defect pointed out by the registry list also.
Okay.
Item 16.
Yes. Yes.
Item 16.
What is this matter?
Arjun.
16.
16 Arjun.
16.
Then Arjun.
मागिए की adjournment मांगतो
Done.
पास और करें
Pass.
17.
Defect नहीं तो defect
ahead.
number 6.
Government copy.
Copy, you got the copy
Yes, ma'am.
in item 16.
Item 16 I have.
Yes. 17.
17, it's a modification of order. On 23rd to April, my lord, your lordship has quashed this case as well as the counter 2 cases. And as because all the petitioner belongs to one family and there are 6 to 7 female members, my lord says directed to deposit 2,000 per case, but it was reflected in the order sheet 2,000 each. Dipali Mahapatra was arguing that case, my lord.
How much it comes through?
My lord, 7 plus these 4, 11 persons are there. Belongs to one family.
11% means
22,000.
oh, it's not a big money you are giving to the bar.
My lord, your lords, because Ms. Dipali Mahapatra requested your lordship, they are female members and unemployed. Lordship has put 2,000 per case. Because there are 3 cases.
They can afford to engage you people, they can't afford to pay bar.
We are taking less money.
Cost of 2,000 rupees each.
Yes.
How many petitioners? Let us see.
My lord, here, my lord, 4 in my case.
4.
In their 2 cases, 2 male, 4.
You talk about this case. You have moved the
4.
application here.
Here 4, 2 female, 2 male.
4 means 2,000 into 4, how much?
8,000.
8,000 টাকা দেবেন?
আরো কেস রে বি আছে
আরো কেস রে দেখিও আরো কেস I am not this talk about this matter. You have moved application in this matter. It is only 8,000 rupees.
There
when that matter will come, we'll see. When that matter will come, we'll see.
They will definitely file, my lord.
Hmm?
They will definitely file miss case.
Let them file. We'll see.
Because as per your lordship's direction, myself, my lord, have given 6,000 in bar.
Okay, make it 1,000. 1,000 each.
Oh, bless.
Why to you are elected to give to your own bar? Okay, 1,000 each kar dena. 2,000 kila 1,000 kar diya. ठीक है. Yes.
Item 18.
May I please, Lordship? Lordship, in this case, the petitioner and the opposite parties were the husband and wife, and their marriage was solemnized on dated 18/5/2020.
Yes.
And after that, a dispute arose between them, and a case was registered by the opposite parties in the Cholong police station.
Right.
And under section 498A 323 34 IPC, Your Lordship.
But
Thereafter, Your Lordship, dowry case, divorce case was filed.
So what do you want?
Your Lordship, my little submission is to pass the proceeding.
My lord, there is a
On what
noting,
ground?
noting is there no such address in Mason. Notice has not been served to the OP, my lord.
And I have served in.
No,
Service.
Yeah,
yes, yes. They
Just service.
सर्व कर देचंदे आएगा
Notice was issued.
कर देचंदे दोनों
Notice was only issued so that he will come.
नोटिस तो पोस्टल
Come and
जायचे
appear,
ना
then we could have, sorted out. Let's see.
notice to be sent in permanent address.
No such address.
Huh?
No such address. Brother.
You have not given proper address for what to do. Give proper address.
The address which was mentioned on the.
Unless he is served, nothing can be done. You have to give fresh address. Find out fresh address.
लगे से पहले अपन को सुविधा हुआ मैं
Response
चाहूँ
for the petitioner
पहले अपन को कुछ नहीं
needs to file the fresh addresses of opposite party number 2. If such address is furnished, fresh notices will be issued to the opposite party number 2. Adjourn to so and so, interim order to continue. Yes.
19.
May I please, lords?
Yes.
So the order of cognizance, that is lordship annexed to page 12 to 13 has been challenged. Sole ground is that 307 is not made out. I respectfully submission that I may be permitted to approach before the court course of framing of charge.
Let account for the petitioner seek to withdraw this petition to raise this point before the court below the stage of framing of charge.
Reconcile.
With this limit.
No, we are on bail, lords. We are on bail. No, we are on bail, lords. Lords, we are on bail. We are not asking for bail. We are on bail, lords.
Generation of proceedings from one litigation. Okay. Withdraw.
Item 20.
Lords, we have glanced. My friend said that we are not bail. Page 13, order 11 to 8 to that.
I have already
disposed we are on bail.
disposed of. No problem. I have given the liberty. You argue that.
Yes.
Item 20.
That is in fact the right proceeding, whether this provision is made out or that.
Because this scope of assessment of the document is not here, that can only be assessed by the court.
Can't be done.
Correct, lords.
Yes. 20. Who is appealing 20? Extra copy to Mr. Maharaja.
No copy.
Dekho, January, 2nd January 2023, this order was passed. Thereafter, the matter was reached on 10th January. Thereafter, again, 29th February. Today, none appear.
No copy.
Madam, on 2/1/2023, the petitioner was directed to serve copy on the council for the state. The copy has not been supplied as yet. The matter was again listed on 10/1/2024 and 29/2/2024. None appeared. The matter was simply adjourned on request. Today, when the matter was called, nobody. Nobody appears. It seems the petitioner is not interested to prosecute the matter, hence the same is dismissed for non-prosecution.
21 minutes for compromise.
এটা বির এবং
Detailed question. Detailed.
22.
It is same thing. Copy not solved.
Copy already solved.
Yeah.
6. Copy already solved. 22.
Somebody is appearing.
Sir.
Somebody is appearing. Yes.
The annexed one mailer, the cognizance taken mailer under
Yes.
section 13(2) and 13(1) of Prevention of Corruption Act mailer
Yes.
against the petitioner mailer. The sole ground mailer, petitioner is not a public servant, he is a mere NMR employee mailer of Subarnapur in a municipality mailer. But he was entrusted the work of a collection of taxes.
NMR are not public servant.
And they are not public servant because as it is defined mailer, they are not on payroll mailer. They are master who are just drawing the remuneration, daily wages. So that apart mailer, even though regular employees were there mailer, but the petitioner, as it has been alleged mailer, has been given the duty of a collection of taxes mailer.
The cognizance says, how will I go into all this thing?
Mailer,
Do you think that is the right stage to go into all these things? Whether NMR is a public servant or not, whatever. I think you should withdraw. Let us
here, but another aspect mailer, the person, those who are interested, as per the FIR mailer submitted for the subordinate of police Hon'Ble mailer, the letter was given in which 3 persons were given appointment, given entrustment of a collection of taxes. They were not examined mailer by the SP police.
That's good for you. You will be acquitted.
ଏଥିରେ
But
କେସ୍ ହଉଛି admittedly he has taken the receipt, collected the money, not misappropriated.
no,
Not
not
deposited.
admitted, not admitted.
8 ଲକ୍ଷ ଟଙ୍କା deposit
That
ନେଇଛି.
is tested in the trial only. I can't.
As far as public servant is concerned, he was discharging public duty, whether NMR or not, that's he's in public servant.
Madam, Councilor, the petitioner seeks to withdraw the present petition to avail his remedies under law at the appropriate stage of the trial. With this liberty, the petition is dismissed.
No, may I period mailer, Lordship, may direct to the for expedient disposal of the vigilance case mailer.
No, that can't be, sir. See, now the FIR is very recent.
No, and it is mailer.
The courts are overburdened. There is
It's a charge. Your lordship kindly see the order sheet. 2022 ରୁ charge ପାଇଁ ପଗଡୁଛି ସେ ଆସୁନାହାନ୍ତି.
ଆପଣ ଯାଆନ୍ତୁ ଚାର୍ଜ କରନ୍ତୁ ଫଟାଫଟ କରନ୍ତୁ.
He himself is not cooperating.
Next.
23.
Yes.
23.
Yes. Yes, sir. Ma'am.
Has gone. The opposite 23 appear.
Move it to I am for the bank.
Yes. Notice was issued to opposite party number 2. What is this case is about?
For opinion to I am appearing for the IDBI bank.
What is this matter?
His account has been freeze, my lord.
Freeze?
Pursuant to a criminal case. The
He is accused.
Yes, the police director, I am for the bank. The account has been freezed and he has approached his lordship court to revocation of that freezing of the bank accounts.
Yes.
Dowry provision. That is why
304B, charge sheet has been. But my difficulty is, my lord, the cash credit loan has been granted. So there is outstanding is 10 lakh. In view of the freezing of the account, the balance of account is bank is 68 rupees. So I'm not able to realize my account money also.
What will you do with 68 rupees? And only 68.
68 balance, but the
Why
outstanding
are
is 10
you so
lakh.
keen to get it defreezed?
Unless it is deep
So he is saying that I'm willing to pay that my instruction. Unless a freezing account, I can't deposit.
my account has been seized.
68 rupees.
68.
Also 10 lakh.
At least if you defreeze, he'll deposit the money, the bank will get back its money.
Yes.
Charge sheet is charge sheet is.
Just be.
That's it. And 498, 302 is there.
304B.
304B.
304
The rejection of the ground in the
rejection. Where is that rejection?
yes, that is on page last of it, page 19.
Yes.
Page 19. After release on bail, he has filed the present petition.
Where are you reading? After
Page
release on
19.
bail, yes.
Yes.
Filed with
It reveals from the copy of the letter, SI town case available in the case record that the accused had taken cash of rupees 5 lakh and other gold articles as a dowry and has not returned the same.
That has already been
Government
returned.
counsel for the accused, those submitted that the articles given at the time of marriage has been returned and in this regard has filed a photocopy of an agreement stating to has been executed by the father of the deceased and himself, but the said document does not speak of returning any cash. The trial of the case has not been completed, so at this stage I am not inclined to allow. That is the ground.
But in the meantime, he has. Can I record your statement that only 68 rupees is there in that?
Yes, ma'am.
In fact,
in my further affidavit, I have given the account statement.
No, that is not important. Important is this.
Bank is saying.
Yes, bank saying.
No, I am not objecting. We'll also discuss. What is the fact I brought to the notice of the court?
Exactly. That may be taken on board.
Your application today. The application of the petitioner for defreezing. The defreezing the savings account number, page 18, yeah? Account number so and so, in IDA so and so, has been rejected by the court below on the ground that against the petitioner there is a allegation of dowry. Allegation of taking dowry of rupees 5 lakhs and other gold ornaments. It is alleged that the said on the ground that the petitioner is involved in the offense under section offense for taking dowry. The account. The subject account of the petitioner has been freezed. This court issued notice to the opposite party number 2, opposite party number 2 and 3. Opposite party number 2 is
the IDBI Bank.
Opposite party, the counsel for the petitioner, counsel for the opposite party number 2. The bank submits that in the bank account there is only the balance is only 68 rupees.
And the outstanding is 10 lakhs, more than 10 lakhs.
The 10 lakhs for what?
A cash credit loan, my lord.
The petitioner had taken cash credit limit of 10 lakhs and the outstanding due is about 10 lakhs.
Oh.
Because of since the account has been freezed, the bank is unable to recover the amount from the petitioner. Therefore, the opposite party number 2 has no objection, for defreezing the account.
The cash, my lord, I'm sorry. Cash credit loan of 5 lakhs. You have taken loan 5 lakhs.
5 lakhs. 5 lakhs. 10 lakhs. 5 lakhs. What is this?
In the meantime, opposite party 1, opposite party 3 has already taken the rupees of 5 lakhs. We have given a check.
What is this you are giving?
Further affidavit, my lord. So he says that he has already paid 5 lakhs, returned 5 lakhs.
The petitioner has also filed an additional affidavit. Enclosing the statement of account. Up to the bank account in subject, which indicates that what is the amount now in the account?
On 9/9/2022, he has taken 5 lakhs, my lord.
Huh?
No, the other bank.
What is the account? What is the amount now there in the?
No, he has given another bank account, Punjab National. He has paid 5 lakhs to the informant. That's what he's saying there.
Oh, this is not relevant. Why are you bringing it? I don't know. It's always the account statement. You are completely leaving the focus. You have asked for defreezing. You are bringing something else. taking into consideration the fact that the bank, fact that the fact that the account, subject account has only 68 rupees balance. And the bank has no objection for deepening the same. I am of the consider view that with the appeal order rejecting the application of the petitioner for deepening the aforementioned account is liable to be set aside. Accordingly, the order if the order is set aside, the account number so is decreased.
Right.
Yes, allowed.
24.
As for your lordship's direction, I filed the requisites. The postal tracking report is
Just see.
has come. Flag B.
What is this case?
Case my lord, passing of affair on the ground that the as per allegation made in the affair, the offense is not made out. And in the last occasion, your lordships.
Service complete. Let us see.
No. He has prayed on the prayer of compromise, on the ground of compromise, they pray for person. That is reflected in paragraph 9, page 5 of the petition.
Oh, that perhaps the reason the notice was issued.
That only because of that, not that the primary case is not made up. That is not.
No, your lordship at page 5, paragraph 9, what my lord friend is submitting, my lord, that is in respect to the affidavit shown by the opposite party number 2 regarding marriage. Because they both are married, both are major, both are married, fled away from their village. After 1 month, my lord, this
Where is the charge sheet?
No, I am questioning of affair, my lord.
Where investigation is going on, I will not.
So
What persuaded me to issue notice? Whereas the reason that it can be settled.
Yes, my lord. That is why, my lord, last occasion, since my lord, they have already married. So last occasion, I have submitted before your lordship if there is a chance of reunion. On that basis, your lordship has been pleased to issue notice to the opposite party number 2.
Service is complete. Let us see. I'll put it next week. Service on the opposite party number 2 is sufficient. However, non-appears for the opposite party number 2 in the interest of justice adjourned to next week. Next week, whatever order, one opportunity has to be.
May I play one thing, my lord? Till that date, my lord, I may be integrally protected, my lord. Because in the last occasion, your lordship has pleased to issue notice
I understand it, but
on that ground, my lord.
I try to appreciate one thing. It is at the investigation stage.
Yes, my lord.
Am I exercising 438?
No, my lord.
How
No, I am not praying for bail, my lord.
Then?
I am not praying for bail. I only pray, my lord, interimly protected, my lord. I am not praying
What
for.
is the meaning of that?
I am ready to cooperate with
What
the
is the
investigation.
meaning of that?
Meaning of that, Lord, since my lord, if my lord, I will be arrested,
I
my
can't
lord.
say the-
I will be arrested, my lord. Then
See, I can't say the investigation.
no,
Okay.
I am not praying for that, my lord.
Okay. And what else you are asking?
I am only praying, my lord. I may be interimly.
What is that? That is anticipatory.
Till next date, not for the long time, my lord.
That is anticipatory bail.
No, my lord, that is not anticipatory bail.
What is that then?
Only, my lord, police will not arrest me.
So
That
why-
is not
Police will
anticipatory
not
bail.
arrest. Police will not arrest.
In the last
You are
occasion,
apprehending arrest.
in the last occasion,
Are
your
you not
lordship,
apprehending
your
arrest?
lordship. Yes, my lord. That is why I am coming, my lord.
On apprehension of arrest, provision is 430.
Like 430 is always there. That remedy is available for me. In the last occasion, your lordship has observed that is why your lordship.
To so much.
So, your lordship.
I have issued notice only to see that if that lady will come, we will try to find out a way so that you will come out of this problem. That was the whole idea. Notice is sufficient. One opportunity has to be given. So I am putting this the next week.
Next week, till next week. I am not praying for a long time, my lord. Till next week.
When the FIR was lost?
FIR was lost, my lord, on
April.
4/4/2024, my lord.
Till today, nothing has happened. Within 1 week, nothing.
No, I am.
You could avoid so much, then you can avoid for 1 month. 1 week.
That is why, my lord. That is why till next date. Till I am not praying for a long period, my lord. Till next
I
date.
may not interfere.
Till next date, my lord.
I may not interfere in the matter itself because investigation is going on. Bring him. Bring her. Somehow, sir.
No, that is why notice has been issued, my lord.
Notice issued means it is not my responsibility. You have to settle it so that you have to also persuade her to come.
How can if my lord, I will. Since my lord,
your wife.
since my lord, the
She is your wife.
no, since my lord, the sword is in my head, my lord. I cannot. That is why I am praying for interim protection till next date. I am not praying for long period, my lord. Till next date.
24.
My eye is pending, my lord.
I can't do that, sir. Please appreciate. Please appreciate. I can't do it because it is a 482 petition. 482 petitions are not to be used like this.
No, because
Why
my
can't
lord,
you go to Sessions Court to file 438?
but that remedy is available. I know that, my lord. That remedy is available, my
Who
lord.
stops you? You will get, definitely you will get protection.
438.
Don't,
So my
see,
may I pray, my lord?
have you read?
Since notice has been
Day
sufficient.
before yesterday, there is a judgment of Supreme Court.
Since notice has been sufficient, I pray for 13th, my lord.
13th. Okay.
13th.
Okay.
1-3, my lord.
One. Day before yesterday, there is a judgment of Supreme Court. If there is an alternate remedy, please don't resort to other remedy and get it.
No, I am not praying for bail. I am not praying for bail.
What is that then?
That is not bail, my lord.
What is that?
Interimly protected, not bail, my lord. If I have to go on bail, then I have to file the bail bond. Other criteria is there, my lord. It is not a bail.
It is superior than bail.
No, my lord.
Yes.
25.
Cancellation bail of the opposite party number 224, my lord. Like kindly initial the condition of the bill, page 7 of the petition, my can see the condition. They shall not commit similar type of offense while on bail. They shall appear before the so and so. They shall not tamper with the prosecution evidence in any manner.
Yes.
Thereafter, subsequently, my lord, the present petition filed the 1/6 case, my lord, page 9. 1/6 case number of 66 of 2021. You can see page 11 ଯିଏ ତା ପାଇଁ ସାକ୍ଷୀ ବାହାରିବ ଲକ୍ଷ୍ମୀ ନାଗ ଭଳି ତାର ଅବସ୍ଥା କରିବ ୟାର ସତ୍ୟାସତ୍ୟ ଜାଣିବା ପାଇଁ ଲକ୍ଷ୍ମୀ ମତେ ଥାନାରେ କୋର୍ଟରେ ଦେଇଥିବା କାଗଜ ପତ୍ର ନକଲ କପି ଦେବା ପରେ କଥାକୁ ବିଶ୍ୱାସ
Who has imposed this condition?
the London court below, my lord.
You go to the land court below that tell the court that the condition which you have imposed he has violated. So recall the order. There is 482 for that. I am giving that liberty to you.
Yes, ma'am.
Right on. The petitioner has challenged the order dated 4/2/2022.
This much liberty also may not be given.
Not required, but
because your lordship may kindly see 1cc case number 66 of 2022. Yes. But till today, no cognizance,
let him go.
nothing else.
I will record it and let him. I am giving liberty if at all it is there.
Bail मिलूनी खरार जो असुविधा है तो bail cancel करता हो तो
ସେ ଆମକୁ ଧମକ ଚମକ ଦଉଛି ଆଉ
ଲୋକଙ୍କୁ ମିଳୁନି ଯେ ଆପଣ
ଆମ ସାକ୍ଷୀ ଧମକ ଚମକ ଦଉଛି ଆମକୁ
ମିଳିଛି ତାର କ୍ୟାନ୍ସେଲ କରୁଛନ୍ତି
cancel କରିଦବ cancel
ଲୋକଙ୍କୁ ବେଲ୍ ମିଳୁନି
କିଛି ନାହିଁ କେସ ରେ କିଛି ନାହିଁ ଆଉ
ସାକ୍ଷୀ ଧମକ ଚମକ ଦବ ନା
order dated 4/2/2022 passed by the learned DMFC Dasapala in GR case number 94 of 2021 whereby the court below has granted bail to the opposite parties with certain conditions. Then consequently the petitioner submits that the condition imposed by the court below while granting bail has been violated by the opposite parties. Hence,
opposite but not two
opposite parties, private opposite parties. Yeah? Hence, he seeks cancellation of the bail. I'm not inclined to entertain this petition. However, I'm granting liberty to the petitioner to approach the court below in case the bail conditions are violated by the opposite party. The same may be appraised to the court below.
In accordance with law.
And if such application is moved, the same shall be considered in accordance with law.
Under my lord section 437 sub clause 5.
Under section
437 sub clause 5. 437 sub clause 5.
Sub clause 5.
Move application, appropriate application under section 437 clause 5. Move the right. Yes.
26.
Disposed of. Yes.
Talk about page 11 that the order of granting bail by lordship at page 13.
13.
Yes, my lord. The petitioner shall comply with the undertaking by making payment. Page 13, my lord.
Yes, which para?
Hence the petition released on bail
by the Honorable Court in section of the matter in the aforesaid case one so and so, then the petitioner shall comply with the undertaking of by making payment. Last line of the paragraph, my lord. The middle paragraph.
Subject to the further condition that they shall what? Which paragraph you are?
That was page 13, my lord, the middle paragraph, my lord. Page 13.
Hence, the petitioner is released on bail by
Bail.
the conversation about the matter, aforesaid case on the terms and condition as it may deem fit and proper, subject to further condition that he shall not tamper with the evidence of in manner. The petitioner shall comply with the undertaking
By
given
making payment.
making payment.
Yes, you can talk about the page 12, my lord. Paragraph 4. On counsel for the petitioner on instruction submit the petition is ready and willing to pay the total amount taken by him in lieu of selling of a piece of land. Then also kind of the order passed on at court below, my lord. He has not furnished the he has not furnished any cash security, my lord, and he has simply released on bail, my lord. Without, my lord, complaint with this condition, my lord. Can count about annex of 4, my lord, page 31, my lord.
30.
Page page running page, my lord, order dated 16/24, page 33, my lord.
Yes.
No cash security was furnished, my lord. No cash security was furnished, nothing. Simply was released on bail.
Which page?
Page 33, my lord.
33.
Annex of 4, page 33, my lord.
Let us see once again the order. What are the undertaking you have given? According to the content of the petitioner on instruction submits that the petitioner is ready and willing to pay the total amount taken by him in view of sale of the land price.
5,50,000 was taken by the open number 2 by the from the
Ready and willing at what time it is had to be given, I don't know.
Minute?
It's not in the condition.
Yes, it is the condition, my lord. To the condition, my lord. The petitioner shall comply with the undertaking by making payment.
Petitioner shall
Comply with undertaking by making payment. And told him the page 12, the undertaking was given, my lord.
Right, I understand it. I noticed that.
Yes. And also, my another ground, my lord, he has involved in another case, my lord. I've also annexed the, my lord, annexed.
I issue notice.
Noticed.
Because see, ultimately the money has to be realized.
Yes.
That's the idea. Yes. Yes.
But only he has given the undertaking notion kindly similar. I will pay the, my lord, at page, my lord. Page page 37.
Okay, let him come.
That is there. That is there.
Let him come.
ସେ କିନ୍ତୁ ମାନ୍ୟବର ହାଇକୋର୍ଟଙ୍କର ଆଦେଶ ମତେ ଟଙ୍କା ଯୋଗାଡ଼ କରି ଫେରସ୍ତ ଦେବି.
He has shown me that is the reason I have recorded that. Okay.
27.
Opposite part.
OP number 2.
OP number 2.
May it please be your lordship, item 27, I may be permitted to appear through VC, my lord.
Yes.
My lord.
Yes.
This is an application seeking kind consideration of this honorable court to waive the condition imposed by learned lower court below while granting him in bail. The condition, your lordship, is at page 8, annexure 1, your lordship. It is cash security of raise 10,000. Your lordship, the petitioner is in granted bail since 27/1/2024. However, due to impediment in paying this cash security, he's
cash security of rupees 10,000.
10,000.
Yes, my lord.
10,000.
Not able to give.
His father is an auto rickshaw driver and he is unemployed. So
the cash security 10,000 waive court.
Yes.
The condition petitioner is agreed by the order dated 27/1/2024, whereby although he was enlarged on bail, but with the condition that he shall furnish a cash security of 10,000. 10,000 waived, and the rest of the order, rest of the condition imposed by the court below while granting bail to the petitioner is
Well, remain all.
Not remains is not very.
Yes.
Not very.
Grateful, my lord. Item 28 also similar accused in same offense. He has also been 15,000.
Say, এটা 15,000.
15,000, huh? 15,000.
15,000.
Okay,
Grateful,
both
my
the
lord.
petition
Grateful.
allowed.
Grateful, grateful.
Two PM. Two PM, okay.
31.
31.
Item 31, your lordship. Item 31, your lordship. I pray your lordship can taken after launch, your lordship.
No,
After
I
2
have
PM,
some
your
problem.
lordship.
Your lordship, remember this matter, 81 mother, the son has lost the complaint. Your lordship
lordship,
supposed to pass the proceeding. Your lordship supposed to
For a-
pass the proceeding.
for a moment,
81
for a
son
moment.
mother-
1 minute. One after another.
Last occasion, the matter was, last week, the matter was there. Your lordship is going to supposed to pass the
Yeah.
proceeding against the mother. Oh, just wait. Lordship was supposed to pass my
Your son filed.
Yes,
case
yes,
in-
Your
son filed a
lordship,
complaint case.
kindly,
According to
kindly
what son?
consider.
Huh. What considered? Mahapatra?
Yes, yes, your lordship. Yeah, lordship was on.
No, I will quash it because see, your mother is 81-year-old.
Yes,
For the property you are fighting with your mother.
Only,
And you keep on fighting with your brother,
only-
sister, no problem.
Your lordship, only
Yes.
as for my duty, your lordship, I place 1 minute only, your lordship.
Yes,
So
yes,
I
of
pray your lordship can taken at 3 PM. I will be there, your lordship.
I have some problem.
Yes, your lordship. Kindly
Honestly,
consider,
I'm
your
saying,
lordship.
I am
I
also
will be there.
intimated him. Yeah, I have some problem after the launch, my lord.
Okay, you lease it tomorrow day after anytime.
Obla-
Okay.
Let
Let
it
it be
tomorrow-
tomorrow day after anytime. Yes,
Tomorrow,
you can-
oblige. Yes, yes, yes.
Ninth.
Highly obliged.
9th.
9th.
9th, huh?
Your lordship has directed to, he has asked for time to take
Highly
instruction.
obliged.
Your lordship remember, my lord. Now he's seeking time
Yes,
for.
yes, sir.
He is not seeking, you are seeking.
No,
I-
because of
After launch, my lord. After launch, though he's in
Okay,
BC,
9th, let us
but
see.
seeking time, my lord.
I made up my mind clear that in so far as
No,
the
no,
mother,
no.
I can't allow you to prosecute your mother for property. She is 81-year-old.
Yes, I understand your lordship. Only I will place 1 minute only. So I am not taking adjournment.
Okay, it's 9th,
your lordship.
9th.
I
Come on,
just I will pray before your lordship. Just kindly highly obliged.
9th. 9th.
32.
Entry what to come?
32 your lordship. Pass over your
Deep
lordship. Of the opposite party, Sumitra Mansi is on just 2 pass over your lordship.
Pass over.
Just is come.
What do you want? You want adjournment? What? What? Pass over.
33.
Your lordship, this is the case arising out of 1cc case, and also the case is pending since 2017. Now there is petitioner is the retired teacher, the senior citizen. Getting difficulties for financial crisis, and this is the subject matter is that his daughter that is was kidnapped by opposite part number 1. And she was rescued in when they returned back from Calcutta, in Lakshmanath station, she was rescued. There, when she was rescued, the opposite party now, who had kidnapped, he lost the FIR because he's the SC category, scheduled caste category. FIR against the father and mother, and thereafter the could not be registered. Once this case was filed, thereafter the case was registered. There now the charge sheet has been filed. Now this is 2017, and now is 2000. Your lordship see, every day he's taking time absent. Your lordship page 13 to 14. So finally this order
1-3.
only one, that is only I pray this may be targeted reminder, because he is suffering from the financial crisis, not getting money because a retired teacher, and falsely your lordship also see that is the daughter filed a suit under section 12 of 1 which to annul the that is a marriage has been also decreed. Your lordship see that is page, your lordship see the order part 45.
Yes.
45 last part here, this is a civil proceeding.
Who is Santosh Behera?
Mind out?
Who is Santosh Behera?
Santosh Behera is the informant. Santosh Behera, your lordship see, this Santosh Behera is the informant. That is the complainant. Complainant is she who had kidnapped the daughter of the petitioner. Only I pray this may be targeted. Otherwise, you will be facing only because RCT hasn't filed it. I am not trying to pass this proceeding.
Yeah, I don't know how many witnesses there.
Your lordship see page 12. Your lordship see page 12. This is order that is 13/9/2022. Accused as Jana is present. Please the
Page 12 is something different. Page 12 is your complaint.
Minor?
Page 12 is your complaint.
No, complaint petition, your lordship see, that is the opposite partner 1 complaint is Santosh Behera. Page 17. This is the court of additions, complaint petition was filed.
No.
Santosh Behera against.
Your paginations are different from my pages.
Reading.
Yes. Just check it up. It's not matching. Your annexure 1 is something.
Annexure 1. Annexure the FIR.
Annexure 1 is a inquiry report.
Annexure the FIR, no? Inquiry report. Inquiry report. The joint inquiry is done, and also this is the charge sheet submitted, everything. I don't mind only my simple prayer, target the case. Since the case is pending and this is been suffering, I'm not praying for passing, nothing minor. Only target the case.
Target unless I know how many witnesses are there. How
No, not your lordship see. There is a page.
Show me number of witnesses, how much time it takes.
Yeah, lordship say page 12. Come to page 12.
12. 1, 2.
12, 13/9/2022. Accused as Jana is present and filed Hajra. Other accused.
That's what I'm saying. Your paginations are different than mine.
Page,
you are saying, showing something, it is a complaint case.
Pagination of Guliji. Kindly declare. Sir, it is special case number 250/17. Order sheet no koi.
No order sheet nahi. It a complaint. It a complaint. There is no order sheet. I don't have the order sheet at all. You file some judgment. You file some High Court judgment. So many things you have filed, but there is no order sheet.
Order sheet.
You are filing something different. You cure the default. It's altogether different. Your brief is altogether different. I'll put it next week. Just check it up. Your file with our file. କିଛି ନାହିଁ ସବୁ confusion ଅଛି। ଆପଣ ଯାହା ବି ଦେଖି ଦିଅନ୍ତୁ ପରେ ଆରାମସେ ଦେଖନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ। After court hour, just check it up and same copy you give it to him. We have 4 copies now. He has a different file. I have a different file. You have a different file and compare the file. ठीक है 34 yes 34 34 what is your record taken up what is One, two, three, four. Nobody comes. Pass out for the class. They may not be interested also. Yes. 35.
Last occasion, I was directed to have the matter after exemption of the victim. Victim has not been exempt. Tomorrow is the date in deposit.
But how many days you have taken? 1, 2, 3, 4, 5, 6.
Last occasion, the interim order has been vacated. But you lost the desire for hearing after exemption of this.
Okay. Yes. Next. 30.
36.
36. Yes, Mr. Chodani.
36.
You have won. You are opposite party. There is no opposition from you. What is this?
Last occasion, interim order was vacated.
Then you achieved your goal. Therefore, silent consent for adjournment. Yes.
I please your lordship. One petitioner before your lordship is the husband and working as the assistant teacher.
Service is complete on opposite party. You are appealing? Yes. What is this matter?
Matter relating to the opposite party number 2 and the petitioner, the both are wife and husband and wife.
Why don't you settle it, ma'am?
Yes, ma'am.
I'll refer it to mediation. Wife and husband, why don't you settle unnecessary?
Since 7th day of marriage, I have been tortured, my lord.
That's why your lordship can turn to charge sheet here.
1 minute. Don't fight here.
No.
We want to settle, don't fight.
No. Madam, I am fighting.
Whatever she says, tell yes and tell sorry and everything will be sorted out.
Section 9 application.
Start fighting then.
My lord, the thing is that matter to know, even the learned counsel for them say sorry.
I'm sending it to mediation. Go and try. Yes, otherwise you see. Notice was issued to the opposite party number 2 on 19/1. First is to the said notice. What is your name, ma'am?
It's das.
It's that.
I'm on record.
But you are Okra now, Anu Kumar.
Is my senior and I'm on record. It's das.
Your name is not there. That is it. Yes. This is the there is a probability that we can join request. I got yes, why not? You tell me the date when you are not okay. Both of you.
More time.
but I have to take
When
insurance.
after interception, you appear before police, mediation cell, then we will take it
I'll talk to.
on the, but it's directed to appear before the mediation cell on, ninth, 9th at 4:30. You appear, but yes, yes, 9th at 4:30. 4:30. The meeting is diploma, and you lost. Immediately after registration. Yes, entry on.
37.
37 also I am for the opposite.
Same story.
No, no.
That is a- 47.
147 proceeding.
My God. Page 20, only page 23. How do you get it?
Yes, yes.
22.
22.
This is the report submitted by the police, inquiry report.
Yes.
We will question incoming things ascertain that Khatar number 255, plot number 201, area 16, stands recording in ancestor of first party and second party member. The first party member is residing on her share on the eastern side of the church. For a second party member prospective on the share on the eastern side of the church. As there is no direct passage, the first party, a passage measuring 30 feet left for the first party to invest in outways to public road from our plot. Though the second party member is continuing construction work and her building is facing towards the eastern side towards the main road, but she has opened two number of windows and one door facing towards the passage road first party. Of the first party.
He is blocking.
I'm not blocking. They are blocking. That's why I tried 147 proceeding.
Communication that neither second party has struck any house on the common passage nor has obstructed the passage in any way. That is a report submitted by the police. So that is no case at all. However, the let me 1 minute. The judgment of the first party in the proceeding on 47, proceeding on 154 CRBs. The case was according order that the allowed construction by the district court. The third division, the district division of the dismissal. They are highly civil suit.
No, no.
This is
This is on observation side.
let me thereafter the husband of the had filed civil suit. Civil just and this is pending in declaration of road. And that is status order also granted. In this situation, the 147 proceeding is before the district court. The running, the widow having small child is running. So mind that maybe director for expedient disposal of the targeted case or was the one. Only they are.
My little thing is that the 147 proceeding is going on because it was about to dispose on the last deadline. But since the civil suit was filed by husband and the 147 filed by the wife of the same property, my lord, the court took time to verify whether the property is same or not. That is the today's matter is posted and it is about to dispose of this 147 proceeding. You are not.
Last occasion, my friend, Jonathan, said this.
No, no.
Tomorrow we go to tomorrow. Chetal ko ite tomorrow go che. Chini bomi chini ko target for the
I
What he says is the last time also you made the same statement.
My lord, last time I submit the status order. I have this order. You are
This last order of the case.
Yes.
When counsel for the opposite party states that the proceeding initiated by health writer under section 147 CRPC before the court below is fixed for final disposal on 18/4/2024. What happened in that case?
18 because the court was trying to verify.
Anyway, after 18/4, It deleted tomorrow.
Okay, my lord, it was there because the court.
Come tomorrow and tell me. I'll be.
My lord,
What happened today? Just inform me tomorrow.
my lord,
Kali mein rakh diyo.
my lord, one thing I need to submit the criminal.
Nothing is dispute of tomorrow.
My lord, you not to tablet the proceeding to.
No, why it is, if it is disposed of tomorrow, today it is gone.
Today
Why
is about
target?
to dispose of.
Why target? You tell me.
Yes, my lord. The matter will use this matter tomorrow.
Tomorrow. To tell me exactly what happened.
Yes,
my lord. My lord, number one. Is appearing. I am. Lots of consultation.
One 133 for proceeding is not maintainable because it is purely private dispute, your lordship. Dispute.
There is a dispute, private, government, whatever, there is a dispute. And the courts are there to resolve the dispute. And mediation is also there to resolve the dispute. Go there, that's what is not a problem. Go there, explore on joint case, symmetry, which in the High Court or somewhere in. You go, why don't you go to district, which case, which area is it?
That is why you go to
the.
That will be better.
Better why? This is this is called Baripata. Now what do you? Yes. But this one you have to make it through the Baripata. To explore whatever, 48 right. It goes to Nilatan. Waiting here. One second.
39. That's item 39 on behalf of Mr. Portman, my lord, I prefer pass.
In this case, I am for the opposite party number 2 and 3, madam. We are waiting for some document that the judgment of their case number 865 of Missouri, the opposite party number for the opposite party number, my very first representative.
Well, so it's been ordered to the party.
There will be one improvement.
Sorry?
There is an improvement.
Huh?
There is an improvement.
Yes, I know what that means.
May I please, my lords? I'm appearing through VC. I'm appearing on behalf of opposite party number 2, my lord.
I am for the petitioner, your lordship. I beg pardon, due to personal difficulty, I am appearing through virtual mode, your lordship.
It's all right, no problem. Tell me.
I am for the petitioner, your lordship.
Yes, yes. What is this matter?
The brief facts of the case is, your lordship, that the petitioner lodged an 1cc case under 138 of the NI Act, your lordships. The allegation was there that he had given 8 lakhs rupees in case of need of the opposite party number 2, your lordships.
Yes.
And she did not repay. And she gave 2 checks, 4 lakhs each. That was bounced, your lordship. Thereafter, the petitioner lodged the 1cc case number 270 of 2018.
Right.
On the self-same allegation, your lordships, there was the counter allegation by the opposite party too, that she has repaid all the amount through case, but she has not mentioned any particular date. She only stated that she has returned that through case, and the petitioner has falsely filed the one case under 138 NI Act. The present opposite party number 2 has filed the 1cc case number 296 of 2018, your lordships. In that case, your lordships, under 156 clause 3, the learned magistrate directed for police investigation, your lordship. Am I audible, lordship?
Yes, yes.
So after proper investigation, your lordships, it was found to be false case and FRT was filed.
Yes.
Thereafter, the learned magistrate kept that matter for filing a protest petition, your lordship.
You come to the point.
Lordship.
Why you are narrating the entire thing? You just tell me what is wrong in it, that cognizance order.
Because, your lordships, the brief facts is needed, your lordship. Because when
you come to the real point.
Real point is, your lordships, when that 1cc case was filed by the present opposite party number 2, and that the FRT was filed, that was kept for filing a protest petition. After that 150 clause 3, the present opposite party number 2 did not file any protest petition in that 1cc case number. Rather, she filed another 1cc case number for the same cause of action. That is 1cc case number 1 of 2024. And in the meantime, the previous 1cc case number 296 of 2018 has already been disposed of, your lordship. So as per section 300, your lordship, CRPC, it's amount to double jeopardy, your lordship. Means once a person has been acquitted or...
Yes, Mr. Ansari.
Yes, my lords. My lords, I'll answer the contention raised by the petitioner in point-wise, my lords. Allow me to do that. My lords, the moot question here is whether the action of the OP number 2 is backed by law and whether there exists serious tribal question of fact and law for the Honorable Trial Court to address. If the answer to this question is in affirmative, my lords, then the prosecution of the petitioner is legally tenable and needs no interference. Now, their contention of double jeopardy, my lords. The entire case of the petitioner is wobbly, my lords. They have approached this Honorable Court with wrong facts. I'm trying to place correct facts before this Honorable Court. My lords, according to them, the OP number 2 has not filed any protest petition. According to them, when that particular GR was posted for filing protest petition, I'd like to take your lordship's kind attention, to draw your lordship's kind attention to their own annexures.
Now you just answer one thing.
Yes.
Instead of filing a protest petition, why you file a separate complaint?
It was a protest petition, my lords. That is what I'm trying to inform this Honorable Court. I'm trying to take your draw your lordship's kind attention.
What is the issue here?
To annexure number.
That's my
Annexure number 8, my lords. Kindly
completed and justified, saying that it false things.
Then the option is you file a protest. He has not filed protest. He has filed on the self-evident.
No, my lords.
After taking to inquiry, cognizance of the taken. So
My lords, it was a protest petition.
This should not be. This should be protest petitions to be filed. It is to be taken note of by the
Self-same ground, you can't file a complaint.
My lords, I don't agree. I'm sorry to say this, but it was a protest petition. I would like to draw your lordship attention to Annexure 8, page 47, my lords.
47, huh?
Page 47, my lords.
Yes. Yes.
Look at the cost title, my lords. 1cc case number 01 of 2024, arising out of GR case number 2503 of 2018. It was in the shape of protest petition, my lords, and it was entertained by the learned court below. The witnesses, including the petition OP number 2, was examined at length, and the documents which was submitted by the OP number 2 was taken into consideration, and only after that, by a reasoned, justified order, cognizance was taken. So they cannot say that it was not a protest petition. It was a protest petition. And this protest petition was filed, my lords, if your lordship will see, on 2nd of January 2024. And their case is that the case against the petitioner was disposed of on 28th of February 2024.
Okay, I understand. Mr. Pradhan,
Lordship.
come to page 47.
47. Lordships.
47 and 48.
Lordship.
Do you have that?
Lordships.
C, at the top, cost title is a C.
Lordships.
1cc case number 1 of 2024.
Lordships.
It is written arising out of GR case number 2503 of 2018.
Lordships.
Next come to page 48.
Lordship.
48 6.
Lordship.
Column 6.
Lordships.
And 7. Read it. It is in fact a protest petition.
It is in protest petition.
Lordship, kindly have a glance to the order sheet of that previous 1cc case, your lordships.
Oh, some typo somewhere, and this is a protest petition.
Fine, my lords. Fine, my lords. My lords, give me one more opportunity.
That's not a direct complaint. G, see, 7 would be made more clear. Yes, G, whether any case has been filed before the before any court, or if so, what is the result?
Yes.
Yes, by order it is so and so, everything is given.
Yes, it is a protest petition.
And prior to that, page 6 also it is given. So I don't think you have a case.
It is a protest petition.
This is protest petition. Let counsel for the petitioner seeks to withdraw present petition to raise all the points before the court below at the appropriate stage of the trial.
My humble contention, your lordship. Kindly bear with me, your lordship.
Yes, sir.
The NI Act was filed on the same cause of action, your lordships.
I have given that liberty. You argue this is no case is made out.
Exactly, your lordship. That case is this case is based on the same cause of action, the 138 case, your lordship.
So therefore, you have to go to that same court to point out all these things. No 482 here. Your only contention is instead of filing a protest petition, he has filed a separate complaint altogether.
Lordship.
Without resorting to the procedure established.
Lordship.
So therefore, we have examined it so that this is a protest petition indeed.
Correct, my lord.
So therefore, I am giving you all the liberty. You go and argue all these points before the court below, moving appropriate application.
Correct.
But if that parallel proceeding is on the same cause of action, your lordship, this is a parallel proceeding, your lordship.
That is 138.
Yes, my lords.
Lordships, that is one, but the cause of action.
Separate offense.
But your lordship, the cause of action is the same, the allegation is the same, there is the argument is the same, your lordships. So if the opposite party too has got the opportunity to defend in that case also, by lodging this 1cc,
you can very well move an application for taking both the matters, and both the matters will be tried together.
Lordships.
You can move application.
Grateful, my lords. Correct.
So if this case is your lordship, that case is proceeded 138. All the
don't say this case. This is the 1cc case number 1 of 2024. Where is the other one?
The other one is your lordship 270 of 2018. Your lordship annexure 1.
Mr. Pradhan, let me counsel for the petitioner further submits that on the same complaint. Two allegations, self-same allegation. 2 complaints indeed has been prosecuted against the petitioner. The 1cc case 1 of 2024 and 1cc case number 270 of 2018 are based on the same cause of action. Therefore, he seeks liberty to approach the court below to tag both the matter and try the complaints analogous.
May submit one thing more, your lordship. Just playing here. That is on the final hearing, your lordship. Final argument. The first case is has come to the stage of final argument, your lordships.
No problem.
all the trials has come, all has trial has been completed in that
No
case.
problem. You move appropriate application. Let the court say that.
Lordships, I will approach another.
Yes.
If your lordship would permit.
So, that my humble prayer is, Lordship, let that first 138 be completed. Thereafter, this case
Anyway,
may.
I have observed that you move appropriate application. Tell that.
Lordship,
I think that's
May I be allowed to submit something, Lords?
Yes.
May I be allowed?
42.
Also, here what happened, my motorcycle has been seized on the allegation of transportation of forest produce also by the opinion number 3. So I filed an application for 50% before the court below, it has been allowed. After allowing such a also when I moving before the opposite number 3 for release of the same motorcycle, it's not releasing. So I filed this application.
Because there must be a confiscation proceeding.
So there nothing else. As in today, no notice has been. If you are not, I am not in there so far the confiscation proceeding part is concerned. It is an order of the court, your lordship. If he do not agree to release the same, then he can file an application for modification or set aside of the such order. No application filed.
This order, where is that order?
That order also glance annex 2. Relevant portion also page 17 also may glance. Only page 17. Hence, the Eye of Forest Range of Jodhpur Wildlife Range is directed to release the vehicle bearing number such and such in favor of the petition on execution of Zimanama in presence of witnesses after due verification of identity of the petitioner and ownership of the person.
Have you filed revision?
My lord, revision petition pending, my lord. Not pending, my lord.
Revision.
My lord,
revision.
My lord, and before the sessions court, my lord, revision filed by the opposite number 3, my lord. What happened, my lord, it was listed on 11/8/2023. Thereafter, matter has not been listed, my lord. I have to take further discussion on what happened to the revision, my lord. Criminal revision, my lord.
Let if your lordship revision is filed, definitely I have been noticed. I have not received any notice at all, your lordship.
Revision number you have?
My lord, my lord.
Yes.
Criminal revision number 43/2023.
Petitioner, the only grievance of the petitioner is
43
that,
by?
despite the fact
43.
that his application under section 457 CRPC was allowed by the court of JMFC wide JMFC Jaleshwar wide it's order dated 21/6/2023. The same has not been complied as yet. Next further. Mr. Ragada, Land Counsel for the state submits that against the order dated, impugn order dated 21/6/2023, passed by.
Let my lord and friend has to clarify the revision where it is in pending, your lordship.
JMFC Jaleshwar in 2B
Mujani.
CC.
I have no knowledge about independence of revision.
A revision has already been prepared, being revision number
43/2023.
Criminal revision number 43 of 2023.
Also, court name I'll mention so that I will appear, your lordship.
District and Sessions Judge Balesar.
In view of the aforementioned development, the Land Counsel or the petitioner seeks to withdraw this petition to participate in the proceeding before the revisional court. With this liberty, the petition is yes.
If the revision is live, my lord, can after year.
I don't know, let him go. He'll find out if his revision is not there again, he'll challenge it in 482.
My lord.
But so far my knowledge is concerned, I have never been noticed. I have no knowledge about pendency of a revision at all, your lordship. Now lost I am getting it. I'll verify, lordship. Can withdraw with it is not withdrawn with such objection dispose of, your lordship.
This is disposed of, huh?
Huh?
Not
43.
43, my lord. The lordship may call this matter after vacation. I have tried to take instruction. Instruction has not.
Okay. Okay.
44.
Item 44, my lord. Pray for a short adjournment, my lord. Some case law is required in this case.
That is the request. That is the request of petitioner. Yes.
45. 45.
Is there? Pass over.
May I please, your lordship? Your lordship, in the present case, we challenge the order of cognizance passed by Learned JMFC Balesar, order dated 24/2023, at Annexure 2, your lordship.
Yes.
The factual background of the present case, your lordship, is there are altogether 3 accused persons. In the present case, as per the recital of the FIR, the petitioner has only obeyed the official command of the branch manager, that is Horinara and Andia.
Where is your charge sheet?
We have not annexed the charge sheet, Your Lordship.
You are challenging cognizance of.
Yes.
Charge sheet has to be seen.
We'll file it, Your Lordship.
That constitutional petition seeks time to
We'll also implead the opposite party, Your
additional
Lordship.
document and also seeks leave of this court to implead the informant opposite party.
Yes, Your
Opposite
Lordship.
party. This is the matter. Liberty is granted. Yes.
Your Lordship, only interim order. Okay.
You file, first of all, you file an incomplete petition. Second, you are seeking time. And third, you are asking interim order.
Complete
the file immediately. This side of the vacation we will list it.
As
List it in this side of the on 20th.
Oh, bless Your Lordship.
Second implead my lord. Second implead the informant as the opposite party too.
You have it.
No,
no, no. 80 कर दे implead कर दे.
ये कर दे.
दे दे.
But charge sheet, at least you file charge sheet 161 statement and all.
Yes, Your
Whether
Lordship.
case is made out or not, we have to see. No?
Yes, Your Lordship.
Yes. 40?
48, sir.
Yes. 48, no? 49?
48, sir.
48, yes.
49 approvals.
Now this is 49.
48, sir.
Yes, 48. Yes.
May I please, Your Lordship?
Yes.
Your Lordship, this is a case of 42034, Section 20 of COPT Act. Learned JFC has rejected 457. For
48. 47. 47 Arjun, sir.
47, huh?
Udra. 47, sir.
Udra.
This is 48.
This is 48.
Yes. Withdraw, should I withdraw you? Yes, 48.
48.
Yes, tell me.
Last occasion, state has already instructed for a CE report, chemical examination.
Chemical analysis report.
One more time is required, my lord. As well, I have after the case diary, my lord. That will mention case diary.
Mr. Ragada seeks one more opportunity to file to seek instruction. Urgent.
Lordship, may I submit one thing? Already 8th month cross. Till now, police has not submitted any charge sheet or a C report. I have written all the manufacturing documents. Falsely, police has
You are
lost
on
them.
bail or you are in custody? Bail or custody?
No, release of seizure. 41A.
You should be happy. If they take more time, it is good for you. Yes.
50.
Oh, like
55.
49 approvals, sir.
50 may I please, Your Lordship. Your Milord, on the last occasion, Lordship directed me to file the deposition copies, which are filed, my lord. The case is like this, my lord. Here, my lord, I have challenged the order of cognizance on the ground that the principal accused husband was faced trial and acquitted from the charges on the ground, and therefore, Lordship, I have annexed the
mother-in-law.
I am mother-in-law, sister-in-law, my lord. And so far as the FIR allegations are concerned, all the allegations are omnibus in nature.
See, Mr. Ragada, husband faced the trial, 498 and all. He acquitted. And the mother-in-law and
they are absconded, my lord.
Absconded, but if evidence is there, it's all right.
And they are highly anticipated well. First
Yes,
not given,
that
my lord.
was,
In spite of that, they have not appeared.
Yes.
And here, my lord, what I found, my lord, the family members, all the family members of the deceased, my lord, father, mother, sister, but they have implicated the accused, my lord.
No, yes.
And
what about the husband?
Husband.
Omnibus allegation.
Since the independent witness supported, my lord, for that reason he has been acquitted.
No. All the, my lord, what happened, the informant and other family members supported the prosecution case. Your Lordship may kindly turn to PW, deposition of PW 10.
It is a case of 304B.
304B, 302. Born injury.
100%.
Born injury. And
In spite of that,
Husband was there in the spot.
my lord.
Huh?
no, not on spot. They came later.
Why are you arguing against yourself?
Imagine.
What happened in this case, my lord? Though the doctor's evidence there, my lord.
If husband was not there, therefore court has rightly acquitted him.
No, husband was there. Very much there.
But
wait.
Husband there, the doctor's evidence is there, my lord. 100% born injury. But the trial court, my lord, while accused my lord not taken my lord reasonable grounds my lord. Only because the independent witness they are not.
Have you challenged this acquittal?
No, my lord, I have not no instruction to that effect, my lord. But in fact, my lord, it is a case of conviction, my lord. How the learned trial court
Why don't you challenge him?
But whether
I don't know whether
it has preferred an appeal. I have
they
no
might have preferred revision also by
Right.
the informant.
I have no instruction to that effect, my lord. I will take instruction. Second time listed it. Second time listed. 100% born injury, my lord. Evidences are there, my lord. With all the family members. This is told his when come to his parental house. She stated the everything, my lord, and demanded dowry, everything, my lord.
What is the reasoning of acquittal then?
Acquittal, I have filed the judgment copy, my lord, but annexer 3.
1 minute.
Annexer 3, the lordship may kindly turn to. The learned trial court come to a conclusion that entire prosecution will be based on suspicion and and therefore the lordship at page 54 also there is, my lord, there is second para.
For DP option as
Defense plea no the. It a court finding at page 20.
55 page. In the present case, neither the informant nor the supporting family members have stated anything in their evidence about the demand prior to the marriage.
Yes.
That is the ground.
Demand is
Or time of marriage or of the accused.
Also
My lord,
prior
even
to
if, my
that.
lord,
that will entail you to for an acquittal under 498A.
my lord.
But
Yes,
whatever
but
304
prior to that, my lord, 302 ravi diya hai. Now coming to the second aspect, that is regarding death of the deceased. Your lordship may kindly turn to page 50, para 18.
But for that in this one, my lord, just Hansaria when they are here, my lord. He has, my lord, thrice, my lord, named dowry, and dowry. That means before marriage, at the time of marriage, and after
Yes.
marriage. Here, my lord, the learned trial court man stated that prior to marriage and at the time there is no such demand of dowry.
I would only request you to evaluate the evidences he has filed, all the witnesses' evidence he has filed. Please evaluate it.
But
I'm just adjourning it. Please evaluate it. We'll see on 20th. I'll take it up on 20th.
20th of this month, please.
Okay. Let him read, Mr. Ragada, please. Read.
I have also supplied all the copies.
Yes, no problem. 20. Yes.
Till then, my lord, some interim protection now, so they are.
You are absconding, sir.
Absconding nahi, but someone is.
Highly acceptable application. And here, my lord, this one could direct them to appear before
ମୁଁ ତ ସେଟା disclose କରିଛି ମୁଁ ତ ସବୁ
disclose କଥା ନାହିଁ ଆପଣ
ମୁଁ ଏଟା ଅଲଗା ground
ଗୋଟେ order ଆଣିବେ comply କରିବେ
since 2019 they are avoiding, my lord. After acquittal they came forward here, my lord, settled that
from 2019 you avoided.
No. First, my lord, initially preliminary charge sheet was filed against
Your
husband.
clients are very smart. They can avoid till 20th. No problem.
So,
Nothing will happen. Yes.
51. My lord, petitioner challenging the impugned order of Annexure 4, my lord.
Yes.
That is running page 20, my lord.
Annexure 4.
My lord, running page 20, my lord. Married, my lord.
311.
Same thing, my lord, 33 suppose 5.
The case record is further put up for order. Lord and Defense Counsel submitted in his petition that during cross-examination of the PW4, some material facts are stated by her regarding the version of alleged occurrence before her mother.
33, 5. The court also writes it. What to do?
My lord, what is the ground Lord and court has rejected?
And a questionnaire has not been given.
Yes.
With some order, with some corrections.
Same petitioner, same informant, my lord.
You give all the numbers. All the numbers.
I have already last occasion.
922 there.
ସବୁ ଜାଗା number.
ମୁଁ ଦେଇଥିଲି ଆଜ୍ଞା last occasion court master left this, my lord. One number 922.
Now you give.
I am giving, my lord.
Now you write in.
Yes, my lord.
ସେଟା ଫିକ୍ସ ହେଇଛି ପରା ନୋଟ
ଏଇଟା କରେକ୍ସନ କରିଦିଅ ସେମ୍ ଅର୍ଡର କରିଦିଅ 52 53 ଲେଖା ହେଇଛି ଆଉ ବାକି ସବୁ ଜାଗା
ଆଉ ଗୋଟେ ସାର୍ ଅଛି 922
ଏଭ୍ରିଥିଙ୍ଗ ୟୁ ଲିଷ୍ଟ
ନାଇଁ ସେଗୁଡା ଗୋଟେ ଡେଟ୍ କୁ ଫିକ୍ସ ହେଇଛି ଅନ୍ୟଗୁଡା ଯୋଉ ବାକି 6ଟା ଇନକ୍ଲୁଡିଂ ଗୋଟେ ଡେଟ୍ କୁ ରହିବ ଆଉ ଗୋଟେ ଫ୍ରେଶ ମ୍ୟାଟର ଅଛି ଯୋଉଟା ଲର୍ଡସିପ ମେ କାଇଣ୍ଡଲି ଡାଇରେକ୍ଟ
52, 53 ରହିଲା.
It is numbered.
It is number.
9
all the matters I list.
That will come on one day, my lord. Unless that comes, your lordship issues notice because in it
that matter tomorrow.
Yes, my lord.
922
କାଲି କରିଦିଅ ଆଉ ଏଇଟା କରିଦିଅ ଆଉ ବାକି ସବୁ 922
ଏଗୁଡା ଡେଟ୍ ଫିକ୍ସ ରେ ସାର୍ ଅଛି
ଡେଟ୍ ଫିକ୍ସ କରିଦିଅ କୋବେ ଡେଟ୍ ଅଛି ଆର
ବ୍ୟାକ୍ ସାଇଡ ଭାଇ
31/7
ସବୁ ଗୁଡା actually ସାତ
31/7 କରିଦବ ଆଉ କାଲି ଯୋଉ ମେଟର ଆଇବ ତାକୁ ବି ସେୟା
ମାଇଲର।
କରିଦବ 31/7 ଗୋଟେ ଜାଗାରେ ହେଇଯିବ ଠିକ ଅଛି
I already supplied my load number.
give you entire
Yes, ma'am. I already given.
ठीक है
कर दो
So I am standing on behalf of Mr. Kishore Kumar Mishra.
Sorry?
Mr. Kishore Kumar Mishra. This interim order will be continue and get a date from after vacation.
You want an adjournment?
Already interim order has been passed.
And the case
They will
has
be
been
continue.
disposed of also.
Yes.
Again, what for? Earlier it has been disposed of. Not disposed of, right?
Disposal of any. So actually two accused has been left from this matter. ଆପଣ କହିଥିଲେ ଯେ ତାଙ୍କୁ ନେଇ ଆସନ୍ତୁ ଆମେ କରିଦେବୁ complainant
You
already
said that you have settled the dispute.
sir
Dispute is settled.
dispute is settled. Complainant has been submitted affidavit in honorable
So
court.
why do you want adjournment?
Interim ଆମେ ତାକୁ ଡାକିଦେବୁ ସେ ଦି ଜଣଙ୍କୁ ଡାକିଦେବୁ ଏଠି ସ୍କ୍ୱାସ୍ କରିବା ପାଇଁ ଆପଣ ବି ସେଇଟା କହିଥିଲେ ଯେ ମୁଁ ଜଣ ସେଇଟା ଥିଲା ଆମର 4th ମେ
ଏବେ କେବେ ଡାକିବେ
4th ଏପ୍ରିଲ
ଆପଣ ଷ୍ଟେ ନେଇଛନ୍ତି ସେଟଲ ହେଇଗଲା ବୋଲି ତାପରେ ବର୍ତ୍ତମାନ adjournment ମାଗୁଛନ୍ତି ସେଇଥିପାଇଁ ମୁଁ ଷ୍ଟେ ଦିଏନି ଷ୍ଟେ ନେଲା ପରେ ଆଉ କମ୍ପ୍ଲେନ୍ ଗଲା ଆପଣ if you have settled the dispute why don't you bring them I'll quash it
yes sir ନାଇଁ ତାର ଜଣେ ଆସିଥିଲା ଦିନେଶ ପାଇଁ ଜଣେ ଆସିଥିଲା ଆଉ ଦିଟା accused
when do you want you tell me
I am wanting to my petitioner is my
when do you want the date
I want to interim order has been continued after vacation.
No. Then I'll be vacate the interim order.
The next week.
Don't
my senior has been
employ this ploy by taking an interim order and seeking it adjournment after adjournment. You have said that you have
actually my senior has been
on that ground. I have issued notice, pass some interim order. Now you are asking for adjournment every time. I'll vacate the interim order. If it is settled, then there is no threat.
Next week, sir.
You tell that is a better idea.
Because my senior has been
20th you bring, otherwise I'll vacate.
Okay, sir.
Since you have settled, you bring it.
Yes.
Yes. 20th, huh?
Thank you.
55.
Yes.
55.
Mr. Amitabh Tripathi. Also, 56.
56.
Yes.
May I please? This is the compromise matter and the parties are present here, Lordship.
Sorry?
This is the compromise matter, Lordship, and parties are present here, Lordship. And I filed the compromise affidavit for your Lordship.
Then what?
It's in Annexure 1, Lordship.
Joint affidavit.
Joint affidavit.
147, 148.
I already filed the joint affidavit, Lordship, in Annexure 1, Lordship.
Injury, show me injury report.
No injuries, Lordship. Page now, Lordship, kindly have a glance on page number 55. Annexure 4, Lordship. There is no injury.
55.
Lordship.
See, Mr. Maharaj.
Yes.
55.
55 and 56.
55.
55 with 56 is there?
Yes.
Not.
Is there any connected matter which is adjourned to 4th of July?
Lordship, आर गोटे कनेक्ट मैटर थिला जोटा कि लॉर्डशिप ए मैटर से टैग करबा पे कहतिले बट भूलले रेकॉर्ड ठीक से पानला टाइप इन होला सेति
What is the connected matter?
कनेक्ट मैटर इज लॉर्डशिप 1197 लॉर्डशिप.
But how many cases? You have another cases.
एटा जगह लॉर्डशिप पिटिशनर सेम अछंते कंप्लेनेंट हला एटा हस्बैंड सेलर वाइफ सेम मैटर
FIR number 620 ଗୋଟେ 621 ସେ କେସଟା ତାର CRLG କେତେ ନମ୍ବର 1197 ସେଟା ଆସିଛି ଆଜି ଆସିଛି
This is cross case.
not cross case
No.
ଦିଟା ଅଲଗା ଅଲଗା ଥାଏ ଗୋଟେ ହଜବେଣ୍ଡ FIR
Separate FIR.
separate
This FIR
55 ଅଲଗା
same item ଗୋଟାକରେ ଟ୍ୟାଗ ହେଇଯାଇଛି
with ହେଇକି ଆସିଛି 1197.
What about in the second case? What about the injury?
no injury lordship page number 63 lordship
63.
yes
307, no injury.
No
That is
injury.
1197.
That is no
1197 by 2024, there is no injury. The report has been annexed. That is page 63. That's what it?
Yes.
Page 63.
Yes.
That is 1197 of 2024, CRLs. Page 63.
Yes. I got
That is the
it.
injury report, no injury.
No injury.
No.
In the other case also no injury.
Other case, with the
55.
Yes.
It's showing 55.
that injury report has been filed, that is also no injury.
No injury. No injury. No injury found.
And 164 statement has been recorded. That is, have you got that 164 statement? 164 statement. As it shows.
Offenses. What are the offenses?
offenses are
Offenses,
lordship
147, 148, 323, 307, 354, 294, 506, 149.
Writing and all.
Only 307 is there. That is
What are the allegations?
ଲର୍ଡସିପ ଆଲିଗେସନ ଲର୍ଡସିପ ଗୋଟେ ଜମି ଥିଲା ଜମି ପାଇଁ ଟିକେ ଝଗଡା ହେଇଥିଲା ଗୋଟେ ଫ୍ୟାମିଲିର ହିଁ କକା ଆଉ ପୁତୁରାଙ୍କ ଭିତରେ ତ ଏବେ ଲର୍ଡସିପ ସେମାନେ ମିଶିକି ଏବେ ଅଛନ୍ତି କିଛି ପ୍ରୋବ୍ଲେମ ନାହିଁ ସେଥିପାଇଁ କମ୍ପ୍ରମାଇଜ କରିଦେଇଛନ୍ତି ଲର୍ଡସିପ ଫାର୍ଷ୍ଟ କେସ୍ 1185
First case.
ଅପୋଜିଟ ପାର୍ଟି ନମ୍ବର
They are relative.
55
They are relative. Family member.
yes lordship
Okay. First case let us watch it. Second case report ଦେଖିବା. First case ରେ who all are present?
first
Jinima Paiko.
Lordship, in this case, there are 7 petitioner lordship and 5 are present here, and 1 person is present in VC lordship, and another person is out of state. So
Who?
Lordship, the person Prastuta Paik is petition number 5 lordship, is out of state lordship. So it, out of state lordship, labor kind of person. So says what there.
Who is Poncharana Paiko? Of course. He just asked their family dispute or something.
Panchanan Paiko.
First matter, I'm talking about first matter.
Yes, Panchanan Paiko.
He is standing behind you.
Panchanan. ବାପା ନା ସୂର୍ଯ୍ୟକାନ୍ତି ପାଇକ କି
ଜିନିମା ପାଇକ ଆପଣଙ୍କର କଣ ହବ? ଭାଉଜ କଣ ପାଇଁ ଝଗଡା ହେଇଥିଲା? ଆଉଥରେ କରିବେ ତାପରେ ନା ଏଠି ସରିଲା ପରେ ଆଉଥରେ କରନ୍ତୁ।
ଆଚ୍ଛା ପ୍ରବଳ ପାଇକ absent.
ପ୍ରବଳ ପାଇକ ଅଛି
ଥାଇପାରେ।
ଆପଣ ନା ପ୍ରବଳ ପାଇକ?
Yes, sir. ପ୍ରବଳ ପାଇକ
yes କମ୍ପ୍ରମାଇଜ ହେଇଯାଇଛି
ସାର୍ କମ୍ପ୍ରମାଇଜ ହେଇଛି ସାର୍ ମିଶିକି ଅଛୁ ଆମେ
ଇନଫର୍ମାଣ୍ଟ ନା କଣ ଯେ କେସ୍ ଦେଇଛି ଆପଣ ଯେ କେସ୍ ଦେଇଛି ତା ନା କଣ?
55 ପାଇକ
କଣ ହେବେ 55 ପାଇକ?
ଦାଦା ହେବେ ସାର୍।
ମ୍ୟାଡାମ
ଆଚ୍ଛା ଆଉ ଗୋଟେ ଖାଲି ଦେଖିଦେବା ପବିତ୍ର ପାଇକ
have been registered against
ସୁକାନ୍ତ
petitioners.
ପ୍ରସ୍ତୁଲତା ପାଇକ petition number 5 absent. Just mark it. Sukhil Paiko, Ismail Raita, 1 absent. Don't have to be checked.
on on 29/4/2021 at about 8 a.m. when the informant and his wife was working in their plot. The accused persons unitedly came armed with the sword, knife, and lathi. To threaten the informant, abuse in the obscene languages, and assaulted by Mr. Fist when the wife of the informant tried to rescue him. They assaulted her and outraged her modesty by pulling her sari.
Yes.
Pulling her sari. On the basis of which the FIR was raised. The petitioners and the opposite party number 2 belong to the same family, and the dispute is arising out of the cultivation of land belongs to the joint family, belongs to the joint family. The petitioners are all the petitioners are present except petitioner number 5. Petitioner number, what is his name? Who is appear on VC?
Prabala.
Petitioner number 2 was appeared before this court in VC mode. The other petitioners are present in person. Opposite party number 2 is also present in person in the court. All the petitioners in opposite party number 2 are represented through their respective counsel and identified by them. That's why. Okay. Right on. Where is the joint affidavit? Joint affidavit. What is that?
Annexure number 1, Lordship, that is page number 12 to 31.
The petitioners have filed a joint affidavit. The parties have filed a joint affidavit dated 21/3/2024 inter alia, stating that since they belong to the same family and due to the dispute regarding the cultivation in the joint family property, the FIR was lost. They have now settled the dispute and maintain peace family. The opposite party is not interested to prosecute the petitioner, who all are the relatives. Mr. Maharaja, I think for the state and submits that since the disputes belong to dispute is arising out of a family discord regarding the property, and the parties are related. Opposite party who is appearing in the court on the query from the court has already stated that he is not willing to prosecute the petitioner anymore in the present case. Therefore, there is no legal impediment to quashing the FIR.
Yes.
You need to consider the answering and quash.
Yes.
And how much cost will you pay? 7 of you are there. Pay something to the victim.
5,000.
How much?
5,000.
5,000. Subject to petitioners, all the petitioners paying rupees 5,000 in total to the complainant. To the complainant of the informant of the opposite party number 2 during the course of the day.
Charge sheet has been filed. Charge sheet has been filed.
Charge sheet in this case.
Yes.
Next case.
Next
case. The house.
1197. 1197. Suryakanti Paiko.
11?
1197.
Okay.
CRLMC 1197.
1197.
Right. There are, my lord, 7 accused persons.
Yes.
And one is informant, opposite part note 2. Suryakant Paiko. It yes.
Is
wife, husband ki?
yeah, same. Wife filed one petition complaint, husband
Yes,
filed one
yes.
complaint. Same thing.
Yes, sir.
Right on.
Same. Kali
Same.
other ki asini?
Opposite party. Huh?
Sir, the same accused person.
No. What about
No.
Ismail Raita?
Ismail Raita. Lots of same accused person, same 7% other accused person.
Same.
नहीं ସେଥିରେ ଆମର ଜଣେ ନଥିଲା ନା ହଁ ଏଇଟାରୁ ସେ ଜଣେ ହିଁ ନା
କିଏ ନାହିଁ
ପ୍ରବଳ ପାଇକ
ପ୍ରବଳ ତ appeared through
ପ୍ରବଳ ଅନଲାଇନ ଅଛି ଏଣ୍ଡ ପ୍ରସ୍ତୁତ ନାହିଁ
ନାଇଁ କି ଜଣେ ନାହିଁ କି ତା ନାଁ
ସେଇ ଯୋଉ ଜଣଟା ନାହିଁ ସେ ତା ନାଁ ପ୍ରସ୍ତୁତ ପାଇକ ପ୍ରସ୍ତୁତ ଏଟା 5 ବାହାରେ ଅଛି
6 petitioner 6 except petitioner 6
First 6, yes.
All
6.
of them appeared and petitioner number 3 appeared
yes.
Yes.
Also,
and here also you have to pay something. 2 cases. Duitra marcho. Wife ko marcho being the what you call the nephew and niece and everybody and attack the uncle. You paid little
3,000.
3,000. 3,000 you will have to pay. आप मारा जाओ कोई दिन तो 8,000 rupees they'll get it today. Just now give the money. Because they have attacked, they should feel it, the pinch of it.
Yes.
That is the reason. Yes.
My lord, sir. 63
Amara 63 my lord. Your lordship may not be burdened for that because we have done everything in mediation. Mediation report is there. Only 10 lakhs draft I will give, it may be cost. Everything we have done in
Was it 2 o'clock? Exact 2 o'clock. I'll take it.
65 ଆଜ୍ଞା ଅଛି my lord and friend Maharaj document verification କରିଦେଇଛି compromise
ଆଜ୍ଞା ମୋର ଆଉ affidavit ବି ଦରକାର ନାହିଁ ଆଜ୍ଞା ମୁଁ mediation report is
Mediation report
ଆଜ୍ଞା
Yes, Mr. One matter, my lord, CRLMC number 1682 of 2024.
Yes, that matter I have dictated, but there are some queries, you know. You have referred to some SLP.
SLP order I have got. That has been dismissed.
See, once you refer to some SLP,
yes,
you have not given the number.
Number I have given in my application. That is there.
I asked Mr. Ragada also. What is this?
That is there. Number is given.
We'll just clarify.
My lord, item 104.
Matter to coach is compromise compromise ହେଇଯାଇଛି ପାର୍ଟି ଭିତରେ family court ରେ ବି ସେଟା drop ହେଇଯାଇଛି on the basis of compromise. ମୁଁ last week Friday mention କରିଥିଲି. It was allowed, but the office is not listing it. My lord, criminal miscase number 1682. My lord, I have told both the parties to come tomorrow, my lord, to the court, my lord. If your lordship list.
What is the offense?
Offense is 376. 2N.
They've settled.
They have settled their dispute, my lord. ସେ 376 2N ରେ ଗୋଟେ କରିଥିଲେ ଏପଟେ ଗୋଟେ ଫ୍ୟାମିଲି କୋର୍ଟ ରେ ମେଣ୍ଟେନାନ୍ସ କ୍ଲେମ କରି କରିଥିଲେ ସେଇଟା already that has been dropped.
Wife and husband.
No, not wife and husband. My lord, subsequent, my lord, this lady is a divorced lady. There are some affair between two, my lord, as per the allegation, and thereafter they have compromised and she doesn't want to proceed with the case, my lord. One CRLMC has been
day after.
My lord, ସେମାନେ କାଲି ଆସିବେ ବୋଲି ତାଙ୍କୁ already ମୁଁ କହି ଦେଇଛି. ସେଟା କାଲି କି ଲିଷ୍ଟ
your lordship 100
CRLMC 1682 of 2020 हम देख दो
my lord 104 your lordship may call it after vacation. Nobody has appeared for the opposite party. My lord has issued notice 104
Entry model.
there ଆସିନାହାନ୍ତି ଆଜ୍ଞା ଆସୁ after vacation
How do you know? ଦିଟା ପରେ ବି ଆସିପାରନ୍ତି.
ନାଇଁ ସେ ତ ନାହିଁ ନୋଟିଂ ରେ କିଛି ନାହିଁ
देखी दो दिटा पर अर्जेंट कर नो स्वीकार करियो कोन एंट्री मॉडल विल कंटिन्यू नो प्रॉब्लम
your lordship may adjourn it to after vacation. One date may be given.
Item 6 I'll just see at 2 o'clock because in many matter what happens is so many date you are not complying the order. ସେ ବାତ ନାହିଁ unnecessary pending ପଡିଛି ନା defect cure କରୁନାହାନ୍ତି ଚାରିଟା ପାଞ୍ଚଟା ଡେଟ୍ ନେଇସାରିଲେ
File the manual running, that is done.
ମୁଁ ଏଜେଣ୍ଟ କରିଦେବି କିନ୍ତୁ ଦେଖନ୍ତୁ ଆପଣ
এটা ଗୋଟେ লিস্টিং item 63
63 na
madam
the parties are there
parties are there and the mediation report I have annexed
yes where is that
according annexure 2
63 huh
63 madam
it was referred to mediation by this court
referred to mediation in the by another bench coordinate bench of this honorable court
yes
matter was settled and the terms conditions have been fixed and it was agreed that
Page number.
the parties are there
page 14
parties are here
parties are there
okay there
Yeah.
where is the mediation order
that is page 14 annexure 2
no 14 is the mediation
mediation
in,
report
in bail application it was sent
bail application that order I have got here
you have filed the bail huh?
my lord
anticipatory bail
my
it
lord
was referred to mediation
mediation
and you now
settled
petitioner petitioner had filed an application seeking anticipatory bail being ABPL number 761 of 2024 do you have the date when it was sent to mediation
my lord I have the
by the order dated so and so the coordinate bench of this court has relegated the matter to the mediation cell of this court. The parties have participated in the mediation, which came out to be successful. The Orissa High Court Mediation Center has submitted a mediation report dated 19/4/2024. Inter alia enumerating all the terms and conditions of the settlement. The same is taken on record and made part of the present order. At the instance of opposite party number 2, FIR number so came to the magistrate, the petitioner. The parties have settled their dispute through mediation. Opposite petitioners and opposite party number 2 are present in the court, being represented by their respective counsel and identified by them. They have also filed self-attested copies of the Aadhaar card to establish their identity, which are taken on record. If Mr. Maharaja appears for the state, let's submit that since the dispute has been settled through mediation at the instance of the court's this court's order.
Yes.
So there is no legal impediment in quashing the FIR.
Yes.
Taking dancing into consideration and so on so was.
my lord obliged
My lord, item 63, my lord.
21 was also there.
63.
63.
Yes.
63 I am in
Sir, 64. 64, my lord.
Yes. Yes, 64. What happened?
You are not visible.
Pura.
64. What do you want?
My lord, in this case, my lord, your lordship has quashed the entire criminal posting on the ground of compromise, my lord.
Yes.
But if your lordship will glance to the annex 1 under page 9, my lord, the learned court below says after the complete of 4 months, after the appeal period is over, the seized article will handed over to the accused persons.
Now, why are you mentioning? I'll take it up when it comes.
My lord,
I'll just.
it was
No. 63 was out of turn. I have taken. It's all right. Please wait. It's okay.
21.
my item 21 can be taken
21, huh?
my lord
Yes.
Maybe compromise both the parties present before the summary.
Yes, Mr. Maharaj, just see.
Yes, I have already verified and I have seen, I am sorry, my lord, let other accused person those are present, let their personal appearance be dispensed with and that will be recorded in the order sheet. So far the injured is concerned, he has not made the party. And this is very serious state of law because looking to the age of the accused persons.
It is the offense is under
307.
I am implicated the injured in this case.
What I'll do is whoever is present, I'll record their presence.
I have not implicated the injured. Sir.
Whoever has appeared today, I will record their presence.
Right.
And exempt them from appearance.
Right.
And you implead the
Yes,
injured,
ma'am.
bring him.
Bring him. And file affidavit, ma'am.
Okay.
Okay.
Who all are there? I don't. 19 people.
Yes,
Well,
19 people. This side.
well, one person may not come. He operation, I operation. How समस्त असते. 18 जन असते.
Petitioner seek leave of this court to implead the injured in this case as opposite party number 2.
Upon 3, my lord, 3.
As opposite party number 3.
Injured Kavindra Bharati.
Whoever. And he may implead the injured as opposite party number 3 during the course of the day and during the course of the day. Okay. Next. At the instance of opposite party number 2, FIR number so and so came to be registered. Petitioners. The allegation in the FIR, where is that prosecution story? Para 2, page 4. Page 4, para. Okay. Charge sheet was filed?
Yes. Charge sheet filed on 27/9/2014.
After investigation, charge sheet has been filed in the case on 27/9/2020, 2014.
14.
What is the stage of the trial?
Trial ଟା କଣ ଅଛି?
Trial ବର୍ତ୍ତମାନ ଆରମ୍ଭ ହେଇଛି ତ. ସାକ୍ଷୀ ଆରମ୍ଭ ହେଇଛି.
Trial court and
The trial is proceeding. At this stage, the parties stated to be, the parties have settled their dispute. All the petitioners are present. All the petitioners are present.
Except one.
Petition number 8.
8.
Except petitioner number 8. All the petitioners are present in the court today. The opposite party number 2 is also present in the court. Affidavit?
Affidavit on Monday or Tuesday, madam. Coming Monday, Tuesday.
Appear in court.
ଏବେ ଯୋଉ affidavit
Affidavit already final.
affidavit ଦେଇ ଦିଅନ୍ତୁ।
Sorry.
Joint affidavit? A joint affidavit has been filed today in the court. We should take note of it. In the affidavit, the parties interiorly have stated that they have settled their dispute amicably on the intervention of well-wishers, and the opposite party number 2 is not interested to prosecute the petitioners. Petitioners are represented, petitioners and opposite party number 2 are represented by their counsel and identified by them. They have also filed the self-attested copy of the affidavit. A self-attested copy of the other card will be taken on the court to establish their identity. Mr. Maharaja agrees for the state and submits that although the parties have settled the dispute, since the offence under section 307 is involved in the case, the injured is a necessary party.
Yes.
Injured is a necessary party. Therefore, till the injured is heard in this case, in the FIR and consequential proceeding cannot be quashed. In view thereof, the present petition is present matter. In view thereof, matter is adjourned to further
Coming Monday.
Monday. 30th. The personal presence of all the petitioners and opposite party number. The opposite party number 2
Yes.
Petitioners. But petitioners have to pay the cost.
Yes.
My lord.
How many of you are there? 19 people.
19.
You pay how much you pay? 1,000 each. Pay to informant and victim and informant.
Informant को दे दे informant
ଆଜ୍ଞା ଆଜ୍ଞା ସେମ୍ ଫ୍ୟାମିଲି ସେମାନେ ବି ଆଣିବେ ତାଙ୍କ ଦାୟିତ୍ୱ
receipt ଟା ଦେବେ ନା
Photo ଦେବେ ନା?
Exempted for the next date appearing. The petitioners are directed to pay 1,000 rupees each. 1,000 rupees each to both. No, both are double each, na? 20,000. 1,000 20,000, na? 20,000 total. Petitioners are directed to pay 20,000 rupees in total to the informant and the injured. Leave the matter for. Informant injured action 20,000 rupees देगी पूरा action pass करता. ठीक है?
57.
Yes.
57 is a matter has been compromised and they have already married.
57.
57.
Yes.
57.
Yes.
57.
506, 34 are read to section 31X of SC/ST Act.
65. How many? Why have you implemented so many respondents?
Respondent is the informant is the opposite party number 2.
Yeah.
Opposite party 3 and 4 as the son and daughter of the informant.
They are injured.
They are the
1 minute. तमरा होची 1579
अच्छा
एतरे गोटे सीआरएमसी फाइल हितला 4149 of 2014
Can you withdraw?
1 minute. There also the compromise on the ground of a compromise that application has been filed and state was directed to take instruction regarding the genuineness of the affidavit.
Okay.
When state has taken instruction on the next day, then the case was listed on 19/11/2018. It was withdrawn on behalf of the petition. What is the reason behind it? Number one. And this is the second application for compromise. I don't know if they are.
We will follow the same procedure. Again, let them present. Present doesn't mean that we will pass it. If you file the first petition when the state was trying to ascertain the veracity of the affidavit, you withdrawn it because there is doubtful. Then
I am appealing for the
Informant.
maybe we don't know.
Let's just pass it over and calling my senior, my lord.
Senior will not change the scenario. I am just
Just pass it over.
I am just asking the state to verify the factum of the present petition is filed on the ground that the parties have settled that dispute. Mr. Maharaja, consequent the petitioner of state submits that earlier the same petition, the same petitioners had filed a CRLMC number
4149 of 2014.
2014 on the ground that the parties have settled the dispute. When the court issued a direction to verify the veracity of the settlement, the petitioners have withdrawn the petition.
On 19/11/2018.
On 19/11/2018. In view of the aforementioned. In view of the aforementioned. The state council is directed to verify the veracity of the settlement through the IIC.
Chaudhar.
IIC Chaudhar and place a report on the next date appearing. Next week, love it. Next week.
Specific date, Monday.
Specific date.
Yes, ma'am.
I am filing the compromise.
The petitioners and opposite parties are present in the court and represented by their respective counsels.
Item 3.
Here, allegation of rape has been made against the petitioner. He is the sole person who has raped the minor girl, resulting pregnancy. And thereafter, after the delivery of a child, because she was pregnant, and after delivery child, DNA profile was conducted. Now it has been found to be negative. That is the sole prosecution case. That is the present petitioner who has come to be the author of the crime. Now after this DNA report comes, now the entire thing goes.
So if I will take note of this aspect, so no case law of this nature will be there.
No, what was the offense?
376(3).
376(3), but that has
Pokso is there, my lord.
Pokso is there, that has to be tested.
Main case is 376(3).
Who the defect?
Mine.
Okay, tell.
16.
1 minute. We'll dismiss it now. 16 defect kete achi?
16.
Non-appeals for the petitioner. 16. Non-appeals for the petitioner. Where he has pointed out defect which has not been cured. In the interest of justice, urgent to this side of the occasion. No, I do dismiss from now. Okay. Yes.
And then give.
Next.
32.
Also same it same. Yes, madam.
Madam, on 10 January 2024, Honorable Court has directed both parties.
Speak little louder. Yes.
On 10 January 2024, Honorable Court has directed both parties for mediation. Already joint affidavit given that.
Mediation is going on.
Your Lordship, may kindly see a mediation report dated 7/2/24.
7/2/24.
What happened?
A joint affidavit has already been filed for settlement.
Full and
That
final
this
settlement.
petition was filed. I am for the wife. She's for husband.
Husband.
But this was filed challenging the interim maintenance in 125 petition.
Have you participated in the mediation? Mediation is successful or not? You tell me.
My lord, successful.
Successful. Now on the ground of that, can it be quashed or not?
Yes.
Where are they?
नहीं ସେମାନେ ଆସିନାହାନ୍ତି ଯେଟା mediation ପାଖକୁ ଯାଇଥିଲେ. If your lordship permit, then I will. But today they have not come.
They have not, but they
Bring
have.
them tomorrow.
Tomorrow ସିଏ ତ
Not
ଏତେ ବାଟରୁ
possible.
ଆସିପାରିବ କଣ୍ଟାବାଞ୍ଜି ଟିକେ ଟାଇମ ଦରକାର.
Online?
ଅନଲାଇନ ମୁଁ ତ
But,
କହିଦେବି
it
ତାହେଲେ
is
ଠିକ ଅଛି କରିଦେବି.
Next week ରଖିଦେବା online.
ହଁ ହଁ next week ଅନଲାଇନ କରିଦେବି.
Online ରହିଯାଆନ୍ତୁ.
ଏଇ your lordship.
My
Your
lord.
lordship.
ଆଧାର କାର୍ଡ ନେଇ ଆସିବ।
Online.
ଆଧାର କାର୍ଡ ଯଦି ହବ ମୁଁ ନେଇ
My lord,
ଆସିବି
already
WhatsApp.
matter has been
14th,
decided.
huh?
My lord.
14 your lordship.
ଆପଣ online
ହଁ ମୁଁ କହିଦେବି ଅନଲାଇନ.
Item 40.
ଅନଲାଇନ ରହିବେ ସକାଳୁ ସକାଳୁ ଆପଣ ମେନସନ କରିଦେବେ ଆସୁଛନ୍ତି 10:30 will do.
125 main petition is pending before JMFC.
125 pass ହବ।
Quas no, ସେଟା close ହବ.
ସେଠି ବି close କରିଦେବେ।
ସେଇଟା direction ଦେଲେ ସେଠି
direction
ହେଇଯିବ.
ଦେଲେ close ହେଇଯିବ।
ତାହେଲେ ହଁ yes you should go.
ହଁ ମୁଁ ସେଟା
125
because they were
What
first.
about divorce and all?
Divorce ଟା ଗୋଟେ ହେଇଥିଲା expertise ସେ challenge ସେଟା ସାଙ୍ଗରେ compromise ହେଇଗଲା.
କେତେ number? Number କେତେ? Item
32.
32. I'll just dispose it up to and ask you to go and appear before the the matter was referred to mediation by the coordinate bench. Coordinate bench? Which court is referred?
Justice nursing.
Coordinate bench. Don't take the name of the judges. All the judges are high court.
Your lordship, coordinate. କିଏ ବୋଲି ମତେ ପଚାରି.
All the judges are high court.
Your lordship, your lordship. It's kind. ଇଏ କହିଲା.
Which order? Which is that order?
Your lordship, that is order dated 15
November
11/23.
Where is that? In that order?
That interim matter is to be continued. Both parties will obtain instructions with regard to financing, then you're directed for
Annexure 4.
Good.
Which is that order by which you are relegated to mediation?
Say order to Mahari.
Mediation order.
Court
Lordship, lordship. My lord, MC.
Is that order?
In mediation report, my lord itself it is mentioned.
Right. By order dated.
By order dated
10/1/2024. The parties were referred to mediation. Parties were referred to mediation. And after mediation, both the parties have appeared before the mediation cell and successfully arrived at a settlement. By the mediation report dated 7/2/2024, the High Court Mediation Center has submitted the report. Report which is taken under court. Since the present matter is arising out of a proceeding under section 125 CRPC, the parties are directed to appear before the concerned court and apprise the fact of the settlement, on the basis of which the proceeding initiated by the petitioner against the respondent under section 125 CRPC can be dropped. With this observation, the petition is disposed of. You go, then 125 will be dropped.
I dispose of your lordship dispose.
This I have.
125 lordship, may 125 is initiated by wife, opposite party.
Opposite party, yeah?
My lord.
Initiated by opposite.
Obliged.
Yes.
40.
I pray for next week, my lord. Mr. Panda will be arguing the case. Mr. Devasis Panda will be arguing the matter. He's in a death reference in another court. I pray for next week, my lord. My lord, may I pray that?
Next week, July.
My lord, in the meantime, my lord, the report from the FSSL be called for.
Huh?
In the meantime, the report from the State Forensic Science Laboratory has maybe called for, my lord.
Chalo, next.
45. Item 45.
Vice Sergeant.
And nobody comes. The matters are there. Defect of 45.
What about defect nine? Defect nine, twice urgent.
The matter was earlier urgent twice. In the second call, none appeared today. In the interest of justice, urgent two. Reside of vacation. Dismiss.
Urgent.
Last opportunity. Yes.
49.
Last topic, Lordship directed call for the record, my lord, because it is year-old case, basing on the report of the.
Yes.
This item may be taken up on 14th.
96 matter. I have collected in the meantime.
Aji paiyechan record.
Lordship, my lord has that.
Instruction আসছে না photo আমার
The
কাছে
status report was called for by your lordship because 99 matter.
দেখি দিন
96 matter.
96
96 instruction. Cut
96, no?
A case of 96.
96 are 6 months punishment. Thomas the maximum punishment. Our informant himself is the accused in charge sheet, my lord. And in commission report.
Almost like question.
What is the report?
Report la side achi kon?
Flag C, madam. Report received from the SGM Bhubaneswar.
Flag C.
Now pending before the JMFC 2. JMFC 2 has final report. Status report has come. Before questioning, a lordship has wanted to know the status of other.
For production of accused, it is listed on 4/7/2024.
जाओ ना से appear करना.
अम्मा पाई नहीं sir. Because
यहाँ पे तुम्हारे को लिंक होता है ना.
Informant, your lordship may see. In this case, who is the informant? In charge sheet, he became the accused. And lordship kindly see the annexure 2. Commission report.
You are only
I am for the 2 persons, my lord.
I understand. Your only grievance is this case is up for 2000.
1996.
Yes, my lord. And maximum punishment for 6 months.
6 months. So therefore, I wanted to know why it is
status
prolonged.
report. Yes, my lord. Your lordship may see.
Any report your lordship received?
That report is neither here nor there. What is the report? It is listed on such. Just see the report. That's the whole difficulty. Just
item 42.
1 minute you see the report. पढ़ो ये रिपोर्ट रे कौन करिया
नहीं एटा मगैथिले बिकॉज़
आपण पढ़ो
कमिशन
पढ़ियो Reporter किसी ने
There must be two cognizance. Has already been intimated to take necessary. I will give you
नहीं किसी ने report.
He did.
देखो तो flag भी है. It's the flag.
Report is there.
Flag B. Flag B. Flag.
And posted on 4/7/2024. We are not means we are for it is अच्छी sir.
It is अच्छी. I would
B
say
अच्छी.
flag B.
এটা अच्छी 4/7/2024 for production of the accused persons.
Why it is delayed? I'm asking.
Yes.
से लिखा था ना आसुनांदी किसी से लिखा
कौन पे डिले लगे 96
Plus ଆମ ପାଇଁ ହଜୁର commission report page 42.
That's what I'm saying. It is only written that it is listed on July.
Listed on July.
It is pending means it will be listed only someday. But why from 96 is pending? That was the
Yes, sir.
But you have to get the report.
Yes, sir. Today I have already received the record.
My
As per my
42 page से
14 जाए रहे जानते 14
सर आज रेकर्ड मिली जाइए हमरो
रिटायर माने हमर तो रिटायर जने सरलानी पेंशन पाउ
96 रोले बे
हजूर आप also have taken the view basing on this commission.
I stick to my
washing of the
I stick to my view. If they are not able to, if I'm taking very seriously the report which has been given by the judicial officer. He should have understood what is the idea of giving a report. What is the report?
Detailed report दवा ना.
And I can understand if a police officer gives this kind of report, a judicial officer is giving this kind of report, what to do? So let us wait for police now.
Yes.
Police may be wiser than the
informant himself became the accused in charge sheet.
Wait.
And commission report also charge against the
14th I'll quash. I'll not wait for
obligation.
If you don't get it, I'll quash it. What is this? 96.
Commission section 9
offense.
Question paper leakage.
A maximum punishment 6 months.
And there is a report.
Yes, commission report. Yes, my lord. Justice.
Yeah, so say 14th.
G. Gopal Swami.
14th I'll quash it. Don't worry. There is a report. What is this?
Next Tuesday.
Yes.
14th.
55.
Oblige.
55. 55. Nobody is there. At the request, please the matter on 7. Request. How many requests are there? At the request of learned counsel for the petitioner, the matter was adjourned on 22/4/2024. On second call, nobody appears today. In the interest of justice, urgent to. Available. ठीक है?
58.
Illegal or similar. My lord, honor, annexure 1 is the impugned order. My lord, kindly see the page 11, order dated 22/1/2019, my lord. Charge sheet has been filed under section 341, 323, 294, 324, 506, 307 by 34 IPC, my lord. Initially, my lord, the FIR was registered under section, my lord, 341, 294, 323, 324.
Where are you reading?
My lord, impugned order, my lord, kindly see.
You have challenged the
Order of taking
cognizance
court.
order.
My lord, on page 10, your lordship, see.
Okay, sir, all right.
Page 10, my
But
lord,
neither the FIR is there, nor charge sheet is filed.
charge sheet, I've asked for charge sheet, but your lordship, see the order, my lord. My humble submission before lordship, my lord. Initially, 307 was not there, my lord.
How do I know?
The impugned order, you have case 10, my lord.
In
Page
that
10.
regard, you did not file a injury
Page
report.
10.
Not file a
Injury report is not there.
FIR, you have not filed charge sheet, you have
Page
not
10.
filed.
You also see the page 10 of the impugned order.
Okay.
Page 10, you also. This indicated the sections, my lord.
Sir,
341.
I need to know the allegations also.
My lord.
What are
My humble submission, my lord. These petitioners, my lord, petition number 1 and 2, they have arrested. So far, others are granted anticipatory bail. Now, someone has been issued because 307 has been added. Their apprehension, the master may not grant bail, my lord.
That's why, my lord, another code near bench of this honorable court, my lord.
That
Sushila Devi.
Susila Devi and what are
Yes,
the
my lord, this order,
what are the two?
this order may kindly pass,
judgments?
my lord.
No problem. You go there.
My lord.
Now, where are the other judgments? Susila Devi and another?
Satendra
Satendra
No, how do you some?
My lord. Only application that.
Until is also there, but
And out of 10 petitioners, my lord, one, two petitioners are not there in bail.
They are arrested and released on bail. That was
Released on bail.
yes, lekha is that. Lekha is that.
Susila Devi and
how would it feel?
A cognizance has taken on 2019.
There was one judgment.
Ebe summon aschi na.
If higher offense is added,
He has to surrender to the court
and he will be enlarged on bail. That's not a but what was the judgment I wanted to?
Yes, right.
I could have incorporated that also. Satendra until I okay. The grievance of the petitioner is challenging the cognizance order dated. Order dated 22/1/2029.
19.
Passed in GR 2019. Passed in GR case number 221 of 2018 by JMFC Pipli, whereby cognizance for offence under section so has been taken. The counsel for the petitioner submits. The counsel for the petitioner seeks to withdraw this petition to raise all these points before the court below at appropriate time. At this appropriation. However, he further submits that initially these present petitioners were enlarged on anticipatory were granted concession of pre-arrest bail at the stage of investigation. The initial FIR was in the initial FIR. The offense under section 307 was not invoked. However, after investigation, charge sheet has been filed. A charge sheet has been filed against the petitioners for various offences, including the offence under 307. Therefore, he appears that once he appears before court, he may be sent to judicial custody. The apprehension of the petitioner is unfounded in view of the ratio laid down by the Honorable Supreme Court in Susila Devi and Satendra. Therefore, this court is not inclined to interfere in this matter. Petitioner is given liberty to appear before court and move appropriate application. Application relying upon the judgment above judgment supra. Allowed. Please. Yes. 59.
My lord, in item 59, the affair was lodged on 26/2023 on the incident.
What are you challenging?
Order of cognizance.
Why?
As because the affair and the 161 statement does not establish the case alleged, and the allegation is under 356B, my lord. If my lord will peruse Annex 1, that is the proof of marriage, and Annex 2 is another agreement between the petitioner and the opposite party, wherein if my lord will peruse page 19, para 1, my lord may. Both the parties will believe and treat each other not less than husband or wife. And
when you married?
Yes, my lord.
When you are married?
My lord, fortunately, I have
15/10/22.
Yes, my lord. And based on this
affidavit?
Hello?
Affidavit is before marriage?
Yes, my lord.
Before marriage is affidavit?
It is 1/7/2022, my lord.
1/7/2022. Marriage is?
15/10/2022.
15/10/2022. This affidavit is before marriage?
Yes, my lord.
Do you do this country recognize prenuptial agreement?
No, my lord.
It's a prenuptial agreement.
Yes, my lord. But
that goes to show what kind of relationship you have with your wife. I will not interpret.
No, my lord.
Why have you entered into this kind of before marriage? You enter into agreement. We will treat each other as
This
wife
like
and
and
husband.
that way.
What is it? Prenuptial agreement in India?
My lord, this is on basis of consent of both the parties.
Whatever the consent may be. Have you ever seen it? Prenuptial agreements in Indian
And after
society.
that,
But she is alleging 354 D that I have unwelcomed sexual
The very
gestures towards
fact,
her.
very fact that you have this kind of agreement goes to show that there is something. Cognizance is taken, go and face it.
yes, ma'am.
Why have you entered into this agreement before marriage? See the para 2 which you are reading. Para 1.
Not
Both the parties will believe and treat each other not less than husband and wife.
Yes, my lord. This
Marriage
is
has
done
not taken place.
conscious.
Marriage takes place after 5 months.
Yes, my lord. After this, the marriage has occurred, and now thereafter, my lord, I must place the fact. Thereafter, when
You have a difficult case, therefore.
my lord, when the petitioner approached the opposite party's family for marriage, the parents of the opposite party forced her to lodge this FIR, and this FIR is lodged on this fact only. Means the fact the FIR is on complete falsity, my lord. But my lord, if notice will be issued and a conciliation will be done, it can be resolved, my lord.
Are you still interested
Yes,
to marry?
My lord.
Still interested to marry?
no, already he has married, my
Huh?
lord.
Yes, I have
Okay,
married.
married, but what
Yes,
kind of
married,
marriage
my
is
lord.
this? This slip Brahmana Niyogi
And
Vishwamiti.
yes.
Who is Brahmana Niyogi Vishwamiti?
My lord, if she
What kind of marriage is this? What kind of affidavit you have filed? Before marriage, you have affidavit, prenuptial agreement.
between us,
Thereafter, you went to Brahman Niyog Samiti and got married. And the obviously the parents of the girl will be insecure about the daughter. So they filed an FIR. What to do? Will you marry?
Yes, my lord. I will
Proper marriage.
Yes, my lord. I will.
It seems you are in a relationship with this girl.
Yes, my lord. And if my lord will peruse the
Because you have annexed some what you call the WhatsApp messages.
yes,
and
my
all.
lord. On the date of incident, they had very good talks with each other. So
yes.
how can it can be presumed that 1 year after FIR will be lodged?
Let us admit the submission of my learned brother. But that doesn't mean that your lordship will, if your lordship will have a glance to the 161 statement
No,
and as well
no, I am not on anything.
Yeah.
He doesn't have a case.
No.
But having said that, just see the age of the petitioner. He is 25.
Yes, ma'am.
Age of the girl is 24. They are in relationship admittedly. It looks like.
Yes,
they-
but that doesn't mean that by the taking this process agreement and the petitioner is always heckling and ill-treated to.
He has created many documents against himself. And still the fact remains that he is in love with that girl.
Yes.
But
So let us
after getting marriage, my lord, thereafter also the petitioner started to.
I'll tell you, this marriage is problematic. Is the marriage is also in Brahman Samaj something. That is also not recognized.
No, not
So
recognized.
that is the reason the parents may be bit insecure about the girl.
No, my lord, now the petitioner has married, but
You married
yes,
somewhere
my
else.
lord.
No, I am not. I am married to this girl only.
He says that you married somewhere else.
No, no.
To whom? এই লোক আপনার କରିଛନ୍ତି?
Again.
କରିଛନ୍ତି?
এইটা
I have to gone through properly, my lord. Let me
Just see, we will explore.
Yes, my lord.
And just issue notice. And
Yes.
stay for the proceeding. Why I am staying for the reason that if it is aggravated and everything is spoiled. I am staying it, but this side of the vacation I am putting it. Bring her if you are really in relationship. We will find out the way and finish it. Okay.
Sorry, ঠিক আছে।
Right down,
Move
right down. The petitioner has seek basis of this court under section by invoking inherent jurisdiction, whereby inherent jurisdiction on the ground that the petitioner is in relationship, love relationship with opposite party number 1, and they have also married on 15/10/2022. Before marriage, there was an understanding, written understanding which is placed on, which is placed as an exception to this petition. The petitioner has also relied upon the WhatsApp message between between him and opposite party number 2, which reveals that the petitioners and the opposite party number 2 are in love relationship. The petitioner is a 25-year-old, whereas the opposite party number 2 is 20-year-old girl. Keeping in view the peculiarity of this case, I am of the considered view that the matter could be settled between the parties. Therefore, issue notice to the opposite parties in the internal proceedings arising out of so this stage. Are you on bail or what?
Yes, my lord, 141 mm. By the police.
You are the only accused.
Only accused, and my mother was also impleaded, but she has been she is no more an accused in charge.
Keep it this side of the case. You should file a, in fact, by relying upon all these things, you should file a habeas corpus petition. Your wife may be under the clutches of her parents. It appears because the photograph which you have filed and you have seen it.
I have seen
Photograph and all.
Yes.
And the kind of relationship they have, it appears that the girl is under pressure from the parents. Yes. 60.
May I please, your lords? My lord, two CLMC, my lord. The one is CLMC 1433 of 2024. I think my friend not appeared in this case.
Yes.
Not appeared. 14333.
I'm not included. I'm not going to.
No,
DBA.
implemented, but he will not appear in this case.
You have a wife.
Yes, ma'am.
In second matter, he
But
for
the
the
first
wife.
matter that has come for the first time. That
First
in that case, notice has not been issued.
Second matter notice has been issued.
Notice has been issued, madam. Entry order has been passed, and in between, madam, already.
Why don't you try and settle this?
Yes,
I will send it to mediation.
Yes, your lords.
madam, already in 3 time, madam, mediation.
High Court ro heni na.
Mediation failed.
Outside mediation jo kono.
Mediation can take place anytime. Even if it is failed, you can try. Because it is
My Latin friend is denying because of the I am the wife and I am having a child. I am taking care of that child. That
want to get rid of her.
My lord, I am paying, my lord. Till that, my lord, per month 15.
I will not interfere if you have that attitude. That I will not settle.
Sorry,
Wife, there is a child.
my lord.
It is easy for you to get rid of her. But what will happen to the child and wife?
My lord, so many times we had tried to take the wife, my lord. So till that, my lord, he will not ready.
It is always willing and ready to go.
My lord, kindly again send to the High Court mediation center.
High Court mediation.
My lord, my lord.
The marriage, the dispute is arising out of a matrimonial discord. The parties, after notice, the opposite party number 2 has appeared through counsel and in the scope of settlement.
One thing, your lordship. My lord, the CLMC 3802 by 2022 disposed the matter as because already we are paying regularly monthly maintenance and the case is posted for evidence of the present petition, my lord.
Against the interim order, they have preferred this.
My lord, till it, my lord, continue. We have.
And in that case, interim order was.
Till that, my lord, we are paying maintenance to the opposite party. In this case, my lord, just target the case or dispose the matter. CLMC 3802 by 2022, my lord.
3802. This is against an interim.
125 CRPC. And the another application 1433 of 2024, that is DV case.
So you want that the 3802 can be disposed?
Dispose of.
Supposing your lordship is sending into the mediation center, everything will be settled.
What I say is, it is against interim order.
Yes.
Main matter is already there. Interim order, as per interim order, will keep on paying. I will dispose it formally. First matter, I am sending it. 3802. 380. This matter is arising out of an interim order passed by the passed by interim order dated 10/6/2022, passed by the family judge Jagat Singhpur, directing the petitioner to pay interim maintenance to the opposite party number 1 and the child.
8,000, 8
for the petitioner.
8 plus 7,000, 15,000.
In total 15,000.
Yes,
ma'am. The petitioner is ready and willing to continue making such payment till the final disposal of the application under section 125 CRPC. In view of his statement, the present petition is disposed of with a direction to the learned court of
George Family Court, Jagat Singhpur.
Family Court also to dispose of the application under section 125 CRPC moved by the opposite party as expeditiously as possible.
Applies your lordship.
As possible. And so far as the other matter 1433 is concerned, this matter is arising out of a matrimonial dispute. The on notice to the opposite party number
This has not been issued.
the opposite party number 2 is appearing on advance notice. There is a scope of out of court settlement in this matter. So the parties are directed to appear before the Orissa High Court Mediation Center on 14th of this month. 14th of this month.
14th May, June, May. June.
Through council and through council. Then you can ask for time.
Yes, ma'am. There are date to be fixed.
First order, let it be 16.
13th, 13th election ସେଟା ପାଇଁ କହୁଛି.
Election ଅଛି ନା ସେଟା ଠିକ ଅଛି 17th କର 17th you appear through council and seek it. The coordinator of the mediation center is directed to fix appropriate date and explore the possibility of settlement and place a report before this court. Urgent.
Entry order.
Instead of opposite
button number 2 is lordship में से opposite button number 1.
One opposite.
Entry order is opposite button 2 is the man. Entry order is 9th.
In the meanwhile, the proceeding before which court?
George Family Court.
State.
Oblige lords.
ଏଇଟାରେ ଏଣ୍ଟ୍ରି
ଜଗତସିଂହପୁର ନୁହଁ ଏଟା ଆଉଟ କୋଟି
ମ୍ୟାଜିଷ୍ଟ୍ରେଟ୍ ପାଖରେ ଅଛି
ପେଣ୍ଡିଂ କୋଟି
pending SDGM Jagat Singhpur.
in DB case number 2 ठीक है
oblige lords.
ନାଇଁ ଏଥିରେ ଯୋଉ ଅର୍ଡରଟା ହେଇଥିଲା ସେଥିରେ ତାର ମେଣ୍ଟେନାନ୍ସର କ'ଣ ଏଇ ଅର୍ଡରଟା କ'ଣ ହେଇଛି ଆକ୍ଚୁଆଲି ମୁଁ ଜାଣିନି ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆସିଛି କେସଟା ଆକ୍ଚୁଆଲି କିଛି ଯଦି ପେମେଣ୍ଟ ପାଇଁ ଥିବ ଲର୍ଡସିପ ମେ ସେ ତାଙ୍କ
ମିଡିଏସନ ପଠେଇଲା ବେଳକୁ ଯଦି if you don't stay the proceeding
your lordship may stay that but supposing the financial implications are there supposing the direction has been given to pay something and your lordship is in staying the matter then nothing will be paid by the
what was the order they have?
Yes, that was true.
There is no order for payment of maintenance manner.
So what is the order? I do not know actually this was not
order.
If in this case manner
give a copy to him.
Just yes, because of the first time it has come, it was tagged
give
with
a copy to him. If you have any problem, you mention it.
My lord.
Okay.
Give lordship may say the copy.
Everything those.
Yes.
Lordship may say copy of the order may get in the
copy of order you will get. Yes.
61.
Yes, 61.
Order implemented is the FIR dated 15/10/2018 at page 12. FIR is under section 498A, 294, 506.
Yes, what? Why it should be cost?
4 declared. The the final report has been filed, as can be seen from page 26, my lord.
Yes.
The section 4 of the BP Act has been dropped.
Yes.
As nothing was found in the inquiry. Subsequent thereto, my lord, on the same allegations, the another CMC DV case has been filed, which has been decided in favor of the husband.
Yes.
And as against the wife, no allegations have been substantiated.
34 and charge sheet has been submitted my lord, on 25/2012. Now my lord and senior has submitted this petition for pursuing of the affair. And earlier my lord, regarding the interim maintenance my lord, earlier the CRLMC 1734/21 and 1 CRLMC 258721 has been disposed of by the orders regarding the interim
Maintenance.
So my lord and friend has also included the party to the opposite party. Let me issue notice to the opposite party.
Issue notice. Next. Next.
62.
62. Yes.
May I please, your lords?
Yes.
But in this case, my lord, there is a petition in this case, my lord challenges the FIR, my lord, registered under section 279 and 304A IPC, my lord, because of the accident occurred, my lord, on 12th March 2024, my lord. And the informant, my lord, the FIR, my lord, alleged that while his brother-in-law returning from court at about to 10:30.
FIR is lodged and investigation is still going on.
Pardon?
Investigation is on, na?
Investigation is on, my lord.
So at this stage, how can I cross?
What happened, my lord? This is the offense, my lord, that is bailable, my lord. But what happened, my lord? I have taken instruction, my lord, the 4th of this month, my lord. And he was arrested and forwarded to the court below, my lord. And since there was the deceased person was the member of the bar of Sambalpur. That is why, my lord, nobody appeared on behalf of the accused.
304A. 279.
Yes. 279. Both are available.
Available. Why is her in the custody?
Since nobody appeared on behalf of the accused person, that is
court has to see.
Court has, but
Whether the
court
advocate appears, no.
Court sent to the judicial court.
How can
But
how is it can't be
so far as my instruction is concerned, my
instruction, forget about instruction. The courts are also, you can't set the eyes because they are bailable offenses. Where have you said that in your petition?
Madam.
Where have you stated that in the petition?
Petition, my lord, was
I will not go by your oral this thing. You have to tell all these things in the affidavit.
No, petition long before petition was filed, my lord.
You file an affidavit. Come tomorrow.
My lord.
Tell all these things. I'll direct immediately to release him in the bail.
My lord. Let's put
File an affidavit. I'm simply adjourning the file affidavit.
For the day after tomorrow.
You have to give detail when he was produced, how he has been taken into custody because a member of the bar is involved. All these things you give in detail. And then I'll seek explanation from the magistrate if he has taken him to custody. If it is bailable offense, how can he take somebody send it to custody? It is a liberty after all.
Bail is a right.
Bail is a right. You give it detailed affidavit tomorrow.
Day after tomorrow, my lord.
Day after tomorrow.
The instruction may be taken by the friend.
You give affidavit, sir. I will not only release, I will seek explanation from the officer if he's this thing. You can't play with the liberty of the people like this. Yes.
64.
May I please, your lordship? Online. I am online, my lord.
Yes, yes.
My lord, by the order dated 7/2/2024.
2024. What is this order?
My lord, your lordship has quashed the entire criminal proceeding on the ground of compromise, my lord.
On the ground of?
Compromise. Settlement. Amicable settlement between the parties.
Where have you said that you have settled?
My lord, my lord, kindly see paragraph 3.
Para 3.
The parties are present in court.
Paragraph
being
3 of what?
identical. My lord, paragraph 3, my lord has observed that the parties are present in the court and being identified
Paragraph
by
3
the
of what you are reading?
my lord, page 15, my lord, annexure 2.
Okay. Yes.
They have also filed the self-attested copy of their Aadhaar cards before this court to establish their identity, which are taken on court and subsequently your lordship has quashed.
Yes.
This order was filed before the learned court below.
Yes.
So lordship has glanced to page 10 under annexure 1.
Yes.
My lord, kindly see last 5 lines of page 10, last 6 lines. Accordingly, the accused person, namely such and such, are acquitted from the charges punishable on such and such, and they are discharged from their bail bonds. Thereafter, my lord, what the learned court below, the next page, the learned court below has not released my seized articles. The learned court below says, my lord, kindly see the page 11, last 4 lines, first paragraph. 4 months after the expiry
It
of
only
appeal
says that
period.
wait till appeal period. What is the big deal about it?
My lord,
Why have you come?
where is the question of appeal, my lord? What provision appeal is there?
We don't know. State may go also.
My lord, as per the my lord, consent of the opposite party and the consent of the advocate appearing for the state and your lordships, the matter was amicably settled and quashed. Where is the question of my lord appeal, my lord? 378 says when an order of acquittal is passed, then the state can ask the public prosecutor to appeal against the acquittal.
Okay.
File an application. This is not the. He has to.
You should have moved an application saying all these
Without
things.
filing any application,
My
what
lord,
is this? This is the order.
my lord,
passed.
your
So you
lord,
have filed an
lordship
application
has
to release the above articles.
no. Why I will file application for release this?
The lordship say on the basis of the lordship's order, the entire proceeding has been passed. That is why on the basis of that, this order has been passed. So you prefer an application.
କେମିତି ହବ କେମିତି ଭାଇ? Maharaj Babu, କେମିତି ହବ when on the consent of all parties the proceeding have been quashed? What is the question of appeal?
What Mr. Maharaja is saying is why don't you move an application before the court below? Saying all these things. Why have you come here? That's what he says.
If your lordship observe it,
Let
that
counsel for the petitioner submits that on the intervention of this court, why its order dated 7/2/2024, while allowing CRLMC 2360 of 2023, the entire criminal prosecution launched against the petitioner and the consequential proceeding have already been quashed. Therefore, in the light of the aforementioned judgment of the order of this court, the impugn order passed by the trial court, not releasing the seized article and not releasing seized article is not sustainable under law. He seeks liberty to move appropriate application apprising these facts before the court below and pray for release of all the seized articles, without waiting till the appeal is till the appeal period is over. With the petitioner is granted liberty to move appropriate application for the court below on the same ground, and if such application is moved, same shall be disposed of as expeditiously as possible. With this observation, the petition is disposed. Yes. You are absolutely correct. There will be no. But see, the problem is the procedure says Even if it is dropped, you have to wait till appeal period. So routinely he passes the order. You move application. No problem.
But that is the thing. He is routinely passed
These
that
are
order, but
routine
there
orders.
is no provision.
Somebody will come and say that, see, he has passed the order, not waited for appeal period also. So the trial courts are, by abundant caution, they say that wait for 5. I will issue notice, it will take 4 months. What is the use of it?
When the informant is appear before your lordship and he has no objection at all, there is
Anyway, now you move formal application. Yes.
66.
66, my lord, that.
This is the matter.
Yes,
where is that SLP?
that SLP order.
You have mentioned the SLP.
Yes, I have mentioned that paragraph
Order
number.
not order.
Order ta देई नहीं, but I have mentioned that paragraph 7.
Number ଦେଇଥିଲେ ତ ଆମେ କାଢି ଦେଇ ପାରନ୍ତୁ ନା
Number ଦେଇଛି paragraph 7 paragraph 7 ରେ ଅଛି
ଦେଇଛନ୍ତି
ଆଜ୍ଞା
ଏଥର ଦେଇ ନଥିଲେ ଯୋଉ ଇଏରେ ଦେଇ ନାହାନ୍ତି
କଣ what is this?
my lord, this is that my lord, against the order passed, the judgment passed by this honorable court in CRLMC number 1825 1826 of 2023 13. These petitioners have moved the honorable apex court, my lord.
I just the query is whether this matter
Yes.
is arising out of 205 application.
No, that is a different matter altogether.
Why we have listed it? I have discussed with Mr. Ragada also. Why the matter is listed is if the Supreme Court has passed any order relating to
connecting to 205, then
I can't alter.
Malad, I would have definitely brought it to the lordship's notice.
We can't take chance.
Because the whole.
But 2 to 3. But during course of investigation, they have these petitions have been arrested. They have taken to custody and released on bail, my lord. After submission of charge sheet, but they have to appear before the court and regularize their previous bail, my lord. They did not appear, my lord, and file case before this honorable court. Thereafter, my lord, this honorable rejected their petitions. Then went to Supreme Court and Supreme directed to approach the concerned court, my lord. That is the order, my lord. Thereafter, they have preferred another criminal revision, my lord. That is criminal revision 231 to 23, my lord.
Why don't you go for a single day?
Single day.
And sign it and come.
That is the whole difficulty.
No, one day also you can't.
My lord, a man of 72 years old, he is suffering from various ailments. My lord.
And who will appear for you?
My lord,
There is no lawyer for you.
The lawyer will appear, my lord. No, bail bond we have filed, my lord. It is only bail bond surety have been given at the time of my release on bail, my lord. On the date of yes. ସେଇଟା ତ ମୁଁ କହୁଛି ତାପରେ your lordship knows, my lord, 205 can be, my lord, I filed an application under section 205.
What he is saying is procedure is in while the matter is committed, you have to give an undertaking, file bail bond, saying that I will keep on.
That I will.
Another thing, my lord. All the papers will supply to him, my lord.
Yes, supply. It can be supplied through my advocate, my lord. This is a, my lord, very usual procedure where, my lord.
Continue their previous call. The matter cannot be, my lord,
communicated.
That is the law, my lord. And so far the co-accused person in this present case, they have appeared, my lord, regularized their bail and their case completed.
କହିବାକୁ ଦିଅନ୍ତୁ ଆପଣ ତ ଖାଲି କହୁଥିବେ ଆଉ କଣ my lord 205 application, your lordship knows, my lord, when a 205 application is moved, my lord, and allowed, the accused can be represented, allowed to be represented through a lawyer till his physical presence is absolutely necessary.
You can be bound by the earlier bond which you have given.
That can be.
121 offense is there, my lord. Raising war against the government of India, my lord.
No, 121A is under
death, life imprisonment there, my lord. This type of cases,
that may be true, my lord. I am not.
370, even if 370, my lord, they have to regularize their bail, my lord. Then only, my lord.
Who says no?
Otherwise, magistrate, my lord.
That can be, my bail bond can be accepted through my advocate, my lord. If necessary, we will appear through VC, my lord.
Bail bond देवे ना
bail bond sign करेगा मैं दबू. It can be accepted by the court through my lawyer.
I'll tell you one thing.
Accused statement time
let us strike a balance. In so far as the petitioner number 1 is concerned,
yes,
he has to go once, and so far as 2 and 3 are concerned, they will appear in VC.
So registrar to enter throughout
One day you fix the date. You go and sign it. Go and sign it because see the allegations are very,
Procedures are there. Procedure has to follow.
I will only modify to that extent. 2 and 3 will appear through VC and by lawyer, and 1 will appear one day. You tell me the day.
ସେଇ ଗୋଟାକ ବି ହେଲେ କଣ ଅସୁବିଧା ହଉଛି ହଜୁର?
To strike the balance.
ସିଏ ଖାଲି ତାଙ୍କର କଥାକୁ ରଖିବା ଆଉ କିଛି ନାହିଁ because your lordship knows my lord.
Raising
War against the
No, my lord, there is absolutely no allegation. Allegation is your they want to connect it with that, my lord. Your lordship, I have read today there is an allegation because I was carrying some cash. We are the chairman, vice chairman, and your lordship knows, my lord, that GIT
doesn't mean that you will carry cash in the Naxalite affected area. Cash.
Aগে cash ମୁଁ ନଉଥିଲି ମୋର
Where from you got the cash?
cash ମୋର କଲେଜରେ ମୋର ଇନଷ୍ଟିଟ୍ୟୁସନରେ cash ସବୁ
I don't know. They are saying that it is Naxalite.
there is ample evidence on record to show that I have withdrawn it from the bank.
So I modified it. I'll modify it accordingly.
modify କରିକି ସେଇ ଗୋଟାକ ସେ ତିନି ଜଣ ଯାକ appear କରନ୍ତୁ ଭିତରେ appear କରନ୍ତୁ registrar ଆଉ ପୁଣି ସିଏ he has to regulate the entire my lord
two owners will not go, the registrar will go.
ସିଏ ତ ପୁଣି ସେଇ ତ ମାନେ କଲେଜ ଟାକୁ ଚଳଉଛନ୍ତି ସେ ମାନେ ୟୁନିଭର୍ସିଟି କୁ ଚଳଉଛନ୍ତି ସେ is the registrar of the university
And I belong to that area. Raigada and it takes.
your lordship knows what is GIT, what a huge institution it is.
Ego.
ଇଗୋ ସେଇଟା ଆଜ୍ଞା ସେଇମାନେ ସେଇଆ କହୁଛନ୍ତି ଜଣେ ଦେଲେ ଯାଉ
ବହୁତ ଡିସାଇଡ୍ କରୁଛି
ଜଣେ ଦେଲେ ଯାଉ ଆଜ୍ଞା ସେ ଦି ଜଣଙ୍କର ଯଦି ସେମିତି ଆକ୍ସେପ୍ଟ ହେଇପାରିବ why not this man also ସବୁ ସେମାନେ they are the actual Naxalites.
State when he can go. Tell me the date in the morning or first hour he'll go and do it.
mate I have to take instruction that way.
What instruction? We're not waiting for instructions.
Ne mate puni kebe jai ମୋର କହିବା କଥା ଅଛି ଦି ଜଣ ଯଦି appear କରିଲେ ତାଙ୍କର bail bond accept ହେଇପାରିବ why not the third?
You know, in this
what is the
country sitting prime minister also went to the court.
Yes.
that is there
and private engineering college carrying cash in the Naxalite affected area.
ଆଜ୍ଞା ତାମାନେ ଆଉ କଣ ସେମାନେ ଆଉ ତାଙ୍କର ୟୁନିଭର୍ସିଟି ଟା କନଷ୍ଟ୍ରକ୍ସନ କାମ ହବନି
war against the state. He has an ego issue, he will not go.
your lordship will find our statement have been recorded our statements have been recorded by the police where we have specifically said that we are carrying this money to give it to the carpenter for the purpose of bringing materials for construction work of the university. That is there. They are saying that they could not justify why they are carrying this amount. That is why they want to connect me with the Naxalites. That is
32 page ତାଙ୍କର while rejecting ଏଠି ଲେଖିଲେ 1 ରେ କହିଲେ 1 2 3 4 5 6 7 8 9 10
last to 5 line the present accused persons
205 CRA has to bear in mind 1 रे the nature of the case as also the conduct of the person summoned. If the useful purpose would be served by requiring the personal attendance of the accused. Third, whether progress of the trial is likely to be hampered on account of absence. In the present case, FIR is registered in the year 2008, final form submitted 2013. Since then, the record is lingering for appearance of the present accused persons.
It will stay CRLMC re. CRLMC re further proceeding was stayed by the order of this honorable court. And where is the once it was stayed, where was my question to all the questions?
Get the copies and then the same day he will receive the petition number 1 will receive the copy for all the accused and they'll go and other 2 petitioners will appear in VC. Yes. And through council 370.
Belmondo देवे
Belmondo पे साइन करके दबो वकीलों ने कि दबो कौन is there any मतलब they are the मतलब these are very famous personalities of the locality मतलब there is no question of their absconding or going out of the
209 my lord before passing order my lord can see 209 my lord section 209 that is the procedure. Commitment of the case to the court.
Why are we wasting time?
That is the normal rule.
Small matters.
That is why the honorable
I
apex
have
court
done
has
it.
said
I will modulate. Okay. Next 67.
ସେଟାରେ ତାହେଲେ one ଯାଇକି appear କରିବ।
One appear କରିବ and will receive copy for all the three.
ଓକିଲ ତ କପି ରିସିଭ୍ କରିପାରିବ ହଜୁର ସେଇଟା ଗୋଟେ ଯାଇକିରି ଜଣେ
And your brother lawyer, one of your brother lawyer in that locality will be benefited.
no he is being benefited otherwise also.
Otherwise also he will benefited.
that is not a question.
Next 67.
ତାହେଲେ
ଗୋଟେ ଲାଇନ ଅଛି ଖାଲି 2009 ଟା ଦେଖିବେ ଏ ରେ commit after complying with the provision 207 or 208 paper ଯଦି ହବ case may be the case court of sessions and subject to provision of the code relating to bail, remand and accused custody until the commitment has been made. ଏଇ ଯୋଉ bail bond ଦେବା ସେଠି ରହିଲା କଥା
এইগুଡାକ ସବୁ has been dealt with by the honorable apex court in many decisions.
I know, no problem.
And the honorable apex court has said at the stage of accused statement he will appear, my lord.
Do it.
Accused statement time re to as it is we have to go.
not this type of cases.
Any type of there is no bar under section 205.
There is no question.
205 ଆগে କୋଉଠି categorize କରିନି ଯେ କୋଉ offense ରେ ହବ କୋଉ offense ରେ ହବନି.
Yes. Next.
67.
The Belgium matter, my lord.
Yes.
Warrant has been issued on 4/8/2022. Bail was granted on 4/12/2018.
500. Yes. Next.
68.
Next.
That really can be taken off on 14th minute. 14th minute.
No, what is this?
There is a case minute where I have challenged the order taking cognizance passed under section 306 of the Indian Penal Code minute. Last occasion minute I had submitted.
Next. Then I'll
14th minute.
14, 15 मुझे देख ले लो सही हुई ठीक है
69.
Please, your lordship. And this is Belgium matter. NBW issue on 26/6/2023. Petition release on bail 10/12/2010.
67.
69.
500, huh?
Obliged.
Yes.
70.
May I please, your lordship? This is the best of Belgium matter.
Yes, madam.
Annexure, see the annexure 4, page 23, copy of order of issue of NBW.
When NBW was issued, your dates are confused.
26/7/2017.
26/7/2017.
NBW.
12 lecture anyway.
See the page 6.
LR 22/7/2016.
16. 1000.
My lord, see the page 6. Thank you, sir.
71.
500.
May I please, your lord? My lord, the Belgium matter.
Yes.
Petitioners are already bail on by the order dated 5/9/2019 page 17 and NBW issued on 2/4/2024 page 19.
24.
My lord, 2/4/2024 NBW.
Yes. 500.
Oblige, your lord.
72.
Yeah, please, stay of NBW, my lord. Earlier, he was on anticipated interim bail, my lord. On 10, released by the police on 10/1/2017, and charge sheet was submitted on
6/3/2024 NBW. 500. All these matters I am giving, Mr. Maharaj. In all these matters I am giving date of 30th June. 30th June. That's vacation is on. अभी तो जमीन भी है.
Which penalty? The cost.
You want to pay more?
No.
Yes. 73.
My lord, Belgium matter, my lord, NBW order dated 22/2/2024. My petition was on earlier bail, my lord.
Bail କେତେ ତାରିଖରେ ଅଛି କହୁନାହାନ୍ତି?
Bail.
ସେଇଟା ମୋ knowledge ରେ ନାହିଁ. Receipt. Instruction receipt.
Bail कर दियो NBW कर दियो NBW.
My lord.
NBW is 22/2/2024.
My lord.
But how many cases? Why other cases are listed? Criminal name.
ସେମାନେ ଅନ୍ୟମାନେ ଯାଇଛନ୍ତି ବେଲ୍ ରେ ଯାଇଛନ୍ତି ଅନ୍ୟ ଯୋଉମାନେ ଆସିଥିଲେ ସେମାନଙ୍କର ଅଛି।
ଠିକ ଅଛି।
ନା ଆପଣଙ୍କର ଏଟା ଛାଡିଦେନି ନା
ଅଲଗା ଅର୍ଡର କଣ ଚ୍ୟାଲେଞ୍ଜ କରିଥିଲା?
Criminal MC number 4605/23. ଆଉ ଗୋଟେ 3615 of 23.
24
ଆଉ ଗୋଟେ 24. What is this?
ଏଟା କାହା କହିଛି?
26 ରେ 11/11/2014 କୁ ଚ୍ୟାଲେଞ୍ଜ କରିଥିଲେ ସେ ଅର୍ଡରଟାକୁ।
ଏଇ ପିଟିସନ ର ଚ୍ୟାଲେଞ୍ଜ କରିଛି ତ?
ହଁ ସେଟା ଅଲଗା ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରିଦେଲା 11/11/2014
ଚତୁର୍ଭୁଜ ଦିଗଲ
ଆଉ ଜଣେ ବେଲ ଯାଇଛି ସତ୍ୟମ
ନାଇଁ ଅଦର କୋ ଏକ୍ୟୁଜ ପର୍ସନ୍ସ
ଆଜ୍ଞା
ଆପଣ ସେ କପି ଗୁଡା ଆକ୍ଚୁଆଲି ଦବା କଥା
ମୁଁ ଦେଇଛି ଯୋଉଗୁଟା ମାଗିଥିଲେ ଡିଫେକ୍ଟ ସେଇଟା ଦେଇଛି
ଠିକ yes
74
ମାନେ କୋଷ୍ଟ ମାଇଲ
700 yes.
My lord, NBW issued on dated 15/12/2014, my lord. The present petition was released on bail and dated 22/5/2013, my lord.
Okay. 14, huh? 1000.
My lord.
75
75 my lord, here the 41A notice was issued on 9/9/2019 and that was complied, and thereafter cognizance was taken and NBW issued on 5/7/2023.
The petitioner was before the police had issued 41A notice during the investigation, and however due to absence in the court, the NBW was issued
On 5/7/2023.
23 500.
76
76 miller same person, another case that is NBW issued on 6/7/2023. Say 41 notice.
41 kori kar do 500. Yes.
500. Oh,
77 77
NBW
NBW 27/6/2018.
yes. Bail that's the whole difficulty. So casual.
Bail date
27.
Okay.
bail date का
NBW was issued on 27/6.
That we would see.
bail date का किनको
21/6/2011.
11. 11 or 1000. There are many people.
I am 5%.
So 500.
5, yes.
500 each.
Obliged.
500 each कर दियो.
78
Madam, please, Lordship. Extension of time, date of surrendering, madam.
Huh?
Extension of time for date of surrender.
केवे दिया है तुला? केवे पीरा
date
6/9/2021.
नहीं. You are supposed to surrender
By 6 weeks, my lord.
6 weeks.
My lord.
another 2 weeks maybe.
2 weeks is the yes. By
Another 2 weeks
order dated 6/9/2021, petitioner was directed to surrender before the court below within 6 weeks. The petitioner is seeking extension of time for another period of
कितने okay
2 weeks, my lord.
2 weeks. Further 2 weeks time is granted for the petitioner to surrender before the court below, and they will remedy as per the law.
80
80 my lord. So I pray for after vacation, item 80.
After vacation.
80.
Why interim order you have taken?
In terms of stay of the further proceeding, my lord.
Huh?
My lord, I have prayed for the commencement of the criminal proceedings, so also the cognizance order, my lord. Notice has been issued, my lord. He has received the notice. Track report is there. He is not appearing. Your lordship will let him appear, my lord, open or to either land dispute and between the brothers.
Yes, sir.
Let it come after vacation, my lord.
Yes, interim order to continue.
yes 81
1 week adjournment will be given so that defects may be removed within.
You have taken so many days. 1, 2, 3. This is 4. What are the defects? 81, na?
81.
81.
81
So many defects. Why are you not hearing? You have taken date on 8/1/2024. You have taken 7/2/2024 again taken 15/3/2024 again taken. Now again you are asking. 1 week by the petitioner. Petitioner has taken time for curing defects on 8/1/2024. And the matter was again listed on 7/2/24 and 15/3/2024. Defect pointed out by the registry has not yet been cured. The counter petitioner seeks one more opportunity by way of last and final opportunity. 1 week time is granted. Leave the matter on 20th. It made clear that if defects are not cured, the matter shall be dealt with on the agenda. Yes.
82.
82, may I please the lordship? No, I have before lordship with a limited prayer. Here, my FIR was lodged after filing complaint case. Investigation is done. Charge sheet was filed. Then I filed protest petition. After filing protest, the court accepted the same and directed the IO to complete the investigation. Despite the direction of the learned court below, investigation has not yet been completed. That's why my lord, this court was pleased to issue notice.
You are the informant.
I'm the informant, my lord. My lord, kindly have a glance. I will take.
Which is that order?
That, my lord, 7/12/2021 first order, my lord. That is at page 35, my lord.
Where is that law? Which part of in?
But perhaps, my lord, in that connection at that time, your lordship's order has been complied, and regarding that, the concerned IAC has given instruction that the subject said, it is intimate that the accuser term case get so and so. Investigation, the complainant has been sent with a notice under section 921 of CRPC to produce documents towards financial transaction and documents in support of his allegation. Regarding fraud, since sincere steps have been taken to complete the investigation of this case at the earliest. My lord, this was received by this office at the 24/8/2023. So in between, my lord, 8 months has already been.
That is what I have issued notice to know. See, there is a specific direction.
Yes.
Why this is not compliant?
My lord, my lord, may I pray, my lord? Even, my lord, earlier the order was passed by learned court below trial court. If you also will please enough to direct that I have to complete the investigation within a span of 2 months' time, everything will suffice.
I'll give that.
My lord, because my lord, kindly have a glance to page 36. Order is very clear.
I know, I have seen 32, page 32.
36, my lord, actually. 36, first order was passed. 7/12/2021. Relevant portion at page 37.
36,
Yes, my lord.
Yes.
Relevant portion at page 37. Court considering directed the send the extract of this order to the concerned IAC. Yes.
37,
my lord.
Okay. Yes. Yes.
Now you are known that.
No, it has not been. It has not been completed because my client called me.
37 you are ready.
Yes, my lord.
Yes.
Last portion, my lord.
Considering the circumstance.
Yes. Consider circumstantial case and relying the observation made by the Honorable Court on the said facts as also taking into account prayer of informant. This could hereby direct the prosecution agency for further investigation of this case and to submit the report accordingly. The petition hereby stands disposed of. Thereafter, my lord, the last order sheet I have with me of the year 2023, there also direction again given at page 38, my lord, 9/1/2023.
Head of the petitioner is agreed by the fact that despite the specific direction of the court below to the police to complete the investigation and file complete the further investigation and submit a report. The police has not yet submitted the report by completing the investigation. Mr. Shogat Das, land counsel for the petitioner, pointed out from the order dated 7/12/2021, 21, which reads as under last of page 32, last considering last. Despite the aforementioned specific direction made on 7/12/2021, nothing has progressed, and the police has not completed the further investigation and filed the report as directed by the court below. Therefore, we seek indulgence of this court. Taking into consideration the facts of the present case and submission, Mr. Rahul appears for the case and submits that in the year for instruction.
And instruction, we have received, my lord, for 25/08/23.
25/08/23, he had received instructions whereby the police had instructed him to say that all sincere efforts have been taken for completion of the investigation. But surprisingly, Mr. Sogat Das submits that despite the said instruction furnished by the police to the Director Counsel for the state, nothing in the ground has taken place. Taking into consideration the aforementioned submission at the bar, I am of the considered view that the police, which police?
Police Malik,
Keonjhar
PS.
PS.
The IIC Keonjhar
Town
Keonjhar PS.
Town PS, my lord.
Police station.
Koili, Town PS, Koili, my lord.
Do well to see that the investigation in the further investigation in the present case is completed within a period of 2 months and file maximum period of 2 months and file the report before the court below in accordance with law.
Oblige, my lord. My lord, that is Keonjhar Town PS, my lord.
Keonjhar Town PS.
Oblige, my lord.
83.
My lord, disposed. Yes.
For 2 months time.
Yes, my lord, approved.
Yes.
83.
Yes. What is that?
294, 323, 506, 376, 2N, my lord. 2N, my lord, compromise affidavit has been filed, but parties are not, petitioner is not appear.
And the matter was listed on 2/2/2024 and 18/3/2024. Adjournment was sought. When the matter was matter is called today, none it is for the in the interest of justice and event. Could it रख दियो? Could एक कुछ रख दियो?
84.
84, your lordship, I pray may be taken up as the last item on behalf of Mr. Anupam Rath. He is on his legs at another court.
That last occasion, the lordship directed to obtain the instruction about that civil case number, civil sitting.
That order we have on
Miss case number 3 of 20.
Similar. That we have not yet opened or obtained.
Obtained?
No, my lord.
And
On 24 letter was issued. Next week.
Mr. Vivekanand Bhuya, Special Counsel to PID, submits that as per order dated 16/4/2024, he could not obtain the instruction. Seeks one more week. So,
your lordship also directed to obtain the order sheet by which the
you place it next week.
Oblige.
Vacation for the
85.
Next week, your lordship.
See and the matter was listed on 3/1/2024. At the request of the council, the matter was again adjourned to 6/2/2024. On that day as well, the petitioner sought adjournment. Again, the matter was listed on 13/3/2024. On request, the matter was again adjourned. When the matter was taken up on 20th March 2024, the counsel for the petitioner short time to file fair copy of impugn order along with along with the order passed in the earlier proceeding in CRLMC number 2908 of 2010. The said order has not been complied. When the matter was called up today, none appears. In the interest of justice, by way of the last and final opportunity, this matter is listed on Puri. And it made clear that no further adjournment shall be given, and the matter will be decided on that day. Yes.
86.
My lord, I am in VC. Your lordship may permit in VC.
Yes.
My lord, may kindly see the order dated 19/3/24.
Yes.
Like this order, your lordship had issued notice to the opposite party number 2, who is the complainant in the court below. My lord, the stamp, the registry says that notice has returned undelivered.
Address?
P2, I am appearing.
No. Yes. There is an appearance, no problem.
I am appearing for opinion number 2. Your lordship may fix for here. I will file my wakalatnama in the counter. I am having it here. All right.
Item number
86.
Mr. Enters appearance for opposite party number 2 and file the wakalatnama, which is taken on record. On the Mr. Mishra further submits that you file response to the petition, release the matter on check. Yes.
My lord, the interim order to continue.
Interim order to continue.
87.
Your lordship is fixing a date, my lord.
We'll fix the date.
All right, my lord.
Yes.
87.
May I please, your lordship? My lord, one application is filed in 138 proceeding, wherein, my lord, the present petitioner is the accused.
Yes.
But to send the, my lord, the complaint signature found in the complaint petition under Annex 1.
What is the check amount?
My lord?
Check amount.
Check amount is 7,60,000, your lordship.
You issued the check.
No, my lord, that's a different aspect. My point is, your lordship may kindly see the complaint petition. Your lordship will find that.
What is the order you show me?
Order impugned is, my lord, I submitted one application to send the signature of the complaint petition.
Show me the
And
order. What is the reasoning?
Reason, my lord, it is shown that the default is committed by me, my lord, by taking adjournments, and it is a only application to prolong the matter. He has not, the Law and Trial Court has not assigned any reason thereof why, my lord, the signature will not be sent. That is not there. Your lordship may kindly see, your lordship may kindly visualize the Annexure 1, page 9, the signature of the complainant, Pavitra Raut. Your lordship may kindly see signature.
1.
Page 9.
9.
Page 9, page 10, everywhere at the right side, my lord, the signature is there.
Pavitra Raut.
Pavitra Raut.
Okay.
Even if your lordship will find at the affidavit portion, that is the my lord, page 13, your lordship may kindly see. He has sworn affidavit, page 13. Your lordship may kindly see he has deposed before the court, Annexure 2. The signature is available. Completely different, your lordship. Your lordship may kindly see. Annexure 2 at the right side. And also your lordship will find at page 15, at the last portion. The signature 2.
Where is the photocopy of check?
Check, my lord, the signature of the complainant will not be found. Signature of myself will be found. I challenge, my lord, this complaint petition has
I
not.
want to know who has filled it up.
My lord?
Who has filled up the check?
A check is a different aspect, your lordships. My point is, my lord, check is issued, allegation is check.
I know, your point is in the complaint, the signature found by the complainant. Complainant signature is different from the signature he has
Available in the
examination.
Yes. So obviously, my lord, the person of the complainant, the real complainant, my lord, must be present before the trial court. But here the complaint petition is filed by somebody else. So if, my lord, the complaint petition has not been filed by him, because the signature is completely different.
Page 21 is also may kindly see.
20.
This is all his please.
ଟିକେ ରୁହନ୍ତୁ ଆପଣ ତ କମ୍ପ୍ଲେନ୍ ପରେ ଆପଣ ତ ଷ୍ଟେଟଙ୍କର କ'ଣ ଏତେ ରୋଲ୍ ଅଛି ଦେଇଛି ନା
हाँ 20
अरे रुहतु मु कहि सारे
नहीं
आपण कहबेनी मु मना
complaint played in
यू हैव ए राइट टू
great
से
mischief by filing the false
मु
case
कहि सारे मु
against the accused person only to harass him. Hence, the prayer before this court to send the signature of the complainant to the handwriting expert to unearth the truth. Let the counsel for the accused persons orally.
You have a right to say.
Stated that the accused person intentionally committed the offence and the accused persons have also not appeared before the court on the date of posting of.
But it is the allegation made against the present petitioner. I have taken so many adjournments. But fact remains what application I have filed and what is the reason I have shown. Nothing has been assigned, even a single word. Why it will not be sent for handwriting experts to examine whether the signature found in the complaint petition is whether it is same with regards to that evidence affidavit.
Kind of you have other remedies.
Hello?
You have other remedies.
Only my lord, expert, handwriting
Not
expert.
necessary.
There is no other remedy.
Not necessary. You say that he has manipulated the signature and all. See section 340 of CRP.
My lord.
You resort to that.
No, 340 CRPC, my lord, I will not get any benefit out of the complaint
It's
petition.
not.
Your lordship may kindly see.
See, the mandate provides the 138 NI Act cases has to be completed within 6 months. And you have been avoiding it. NBW has issued. You have deliberately avoided it. And by moving this application, again you want to prolong it.
No,
if you are so serious, file 340 and prosecute him.
Your lordship may direct that handwriting expert even if to give the report within 15 days. So nothing.
No.
My lord,
You move 340 if he according to you, if he has manipulated document.
Why I have a case
criminal in the
so,
proceeding.
your lordship, for initiation of 138 proceeding, limitation is prescribed. And 138 ABC is there. If my lord,
you are trying to defeat the 138 proceeding on this fashion.
No, your lordship may kindly see.
According to you, he has committed a crime. Has he not committed a crime?
My point is not that. My point is the complaint petition which has been filed by the complainant as alleged.
Where is your application where you say that?
Your lordship may kindly see. I have put a question to him also. Your lordship may kindly see.
Where is the application?
Application is Annexure 3, page 18.
You have or the better remedy. You have to file it.
No, because if my lord, the signature in the complaint petition is not the signature of the complainant, then ultimately the case will go of him.
He has, according to you, he has committed a crime.
No. That is not. No, not at all. I say this is not a complaint petition of him. This petition, because the signature, whenever it is not of him, it is not his complaint petition. So ultimately, I will succeed.
Where have you said that in the application?
You lordship may kindly see. The complainant have filed the above said fact, false case against the above led accused petitioner which has no base at all. The complainant have filed the above case falsely in a false signature. You lordship may say kindly see in a false signature in the complaint petition and false signature in the affidavit on the date of filing of the complaint petition. Para 2. So this complaint as per the law is not a complaint.
Where is the question you have asked him?
31.
Page?
Your lord, page 17.
Okay. If he says that it's my signature, then gone.
No. He has said it is not a fact. So it will be my lord, truth has to come. It will be my lord recognized whenever it will be. There is a provision to send it for handwriting experts. If my lord, the signature found in the complaint petition is not of the complainant, ultimately the complaint goes.
If he says that it's my complaint, then it is maintainable. What to do?
No. If my lord, the handwriting expert will say the signature is, your lordship may see the signature of the complainant in the affidavit.
Who is disputing?
So it is not his signature.
You are the accused. You may say that you are the accused.
Yes.
138. According to you, if he has somebody else is impersonated.
Yes. Yes.
In filing the complaint.
Then my lord,
he
complaint
has
goes.
an offense for that.
That is not. I don't bother whether offense is committed or not. I bother, my lord. This is not a complaint.
In the witness box, he says that my signature.
My lord, may kindly please. Therefore, it has to be tested. Whenever he says that it is my signature and this is my signature, both doesn't tally. So ultimately, my lord,
you can't find defense out of this.
Otherwise, ultimately, my lord, the handwriting expert will show whether it is his signature or not. If it is, it will be found.
What will happen?
But the complaint will go. The complaint will go, as per the definition of the complaint, it will not be said to be a
If he
complaint.
says that it's my signature, then it's a complaint is maintainable.
No,
He is not complaining.
my lord, whenever my lord, the signature will be verified by the handwriting expert and saying that it is not his signature.
Unnecessary finding, you know.
No, my lord, your
Defense out of
lordship,
it.
there is a provision to send the signature of to
There is
the
always
handwriting
a
expert.
provision.
So whenever my lord, there is a provision to send it for handwriting experts, and it will be tested that it is not his signature. Ultimately, the complaint will go. Your lordship may say that within 15 days or 10 days, signatures may be tested.
Where is the check? You have issued the check.
But that is I have denied that I have not issued all these things. That is the subject to.
Where
Right.
is the, what you call the reply to your legal notice? The presumption
that
of
is-
right, then you
that-
deposit 20% not to be disbursed to the complainant. I will issue notice.
Yes, your lordship. But the
143 says you have to deposit.
Yes.
The deposit it will not be disbursed subject to petitioner depositing 20% of the check amount. What is the check amount?
7,60,000.
Means 1,60,000.
1,54,000. No,
2
your
lakh.
lordship, it will be 1,52,000.
Subject to petitioner depositing 20% of the check amount. Check amount. Check. No, the petitioner is facing the complaint. Petitioner is an accused in a complaint case initiated by opposite party number 2 under section 138 NIA for allegedly for alleged dishonour of check of rupees 7,60,000. Let it comes for the Mr. Mahapatra, that accounts for the petitioner, submits that the where perusal of the complaint, the signature appearing in the complaint petition and the signature appearing in the statement recorded by the court below, before the court below, signature of the complainant appearing in the complaint case and the statement before court below are quite different to the naked eye. Therefore, he had moved an application before the court below to send the both the signature for to the signature to the handwriting expert. He submits that if the signature in the complaint case found to be not the signature of the complainant, then the complaint case itself fails, being not maintainable. Although there are other remedy available to him under the code of criminal procedure, but Mr. Mahapatra insists that the veracity of signature appearing in the veracity of signature of the complainant appearing in the complaint goes to the root of the matter. Therefore, he insists that the matter should be examined. Subject to petitioner depositing 20% of the check amount, issue notice to opposite party, retainable on circle.
Further proceeding.
In June stay.
Deeply.
Yes.
89, 88.
89, I'm done.
88. 88.
That's 88. Yes.
Here, your lordship, I have filed for modification of order dated 25/4/2024. In that inadvertently, your lordship, interim order passed, interim order dated 28/2/2024.
Yes.
Has not been extended.
No, sir. At the request, please the matter on sanction to continue.
Pardon me, Lord.
Right now,
Pardon me, one.
while issuing notice to the opposite party on 28/2/2024, this court had passed an interim order interim order staying the further proceeding in GR case number 1113 of 2021 pending in the court of JMFC Rural Cuttack. The matter was again listed on 25/4/2024 at the request of the council appearing for the parties. The matter was adjourned to 29/7/2024. However, the interim order passed earlier on 28/2/2024 was not directed to be continued. Therefore, the petitioner has moved the application. Move the application. Let the matter be listed on 29th July 2024 as directed, and interim order passed on 28/2/2024 shall continue in next appeal.
Okay.
Yes.
Pardon me, Lord. In this case, I am for the opposite party. Your case is a counter case. The opposite party also filed a criminal case by the CRLMC number 1120 with item
Yes.
2020. 23 with item.
Anyway, this matter is already adjourned to 29th July.
But
Interim order was not continued.
my Lord, one thing I pray, my Lord, can I refer this matter before the High Court Mediation Center? Because case is a two Agnati brothers.
Brothers?
Yes, my Lord. Matter is installing a SC.
ଦୁଇ ଭାଇ ଭିତରେ କଣ
ଆଜ୍ଞା ଗୋଟେ ଏସି ଇନଷ୍ଟଲ କରିଛି ମୋ ପ୍ଲଟ୍ ଉପରେ ଆଉ ସେ ପାଣିଟା ବି ମୋ ପଟକୁ ଛାଡୁଛି
whatever
ମୋ ପଟକୁ ବି ପାଣିଟା ଛାଡୁଛି ଦିସ୍ ଇଜ ଦ ମ୍ୟାଟର
both the
cases my lord
the petitioner is the dispute is dispute is arising out of a
installation of AC installation of AC.
Why should you write that? The petitioner and opposite parties are the brothers.
Two Agnati brothers.
And because of misunderstanding, the FIR has been lost. Cross FIR has been lost by both the parties against each other. There is a scope of settlement in this matter. Therefore, and the joint request of the council, the matter is referred to mediation, High Court Mediation Center, Odisha High Court Mediation Center. Both the parties are directed to appear with the mediation center on 15th of this month, date 14th of this month, and the coordinator of the mediation center is also directed to fix a date for exploring the possibility of settlement and file a report for the outcome of the mediation by next appearance. 29 days.
Copy of their CRLMC petition. I may be separate copy.
Take the copy. Give the copy. Yes.
I am 89. I am sorry.
My lord, I am in VC, my lord.
Deposit must be within a specific time and it shall not be, my lord, disbursed in favor of.
Sorry?
The deposit I will make, it must be within a time and that should not be disbursed in favor of.
Within a week. The 20% within a week, and the same shall not be disbursed. Why don't you go to mediation center and send? Shall not be disbursed to these.
And urgent copy matter tomorrow is posted for judgment.
138 as if something something big is going to happen.
Yes, judgment by. Yes, posted.
I know judgment by.
That's urgent certificate.
See, now you are paying 20%. Once you are convicted, you have to pay 20% of the.
Not be convicted. And complaint will not be considered to be a complaint. If I will succeed.
You today I don't have a time, but you don't have a case. You have other remedies.
340.
Further, I don't want to waste time. Further, you fight 340. That's a better idea. Yes.
89.
My lord, I am in VC, my lord. My lord, initially 5 persons filed CRLMC petition 273 of 24, challenging the addition of them as accused persons by the learned Session Judge Ganjam Baharampur. That your lordship may kindly see now order dated 8/2/2024.
Yes.
In this, your lordship and paragraph 6 directed taking into consideration the nature of allegation against the petitioners
And for the present case, the petitioners are protected for 6 weeks so as to enable them to surrender to the jurisdiction of the trial court and seek appropriate remedy available to them under law. But initially 5 persons had come up. Thereafter, a modification was filed by IA number 570 of 2024. 4 persons moved the modification application, and your lordship on 14/3/24 passed this order.
Yes.
On 14/3, paragraph 4, taking into amendments made in the application and the fact that there are certain developments, the petitioners are granted liberty to file a fresh petition if so advised, and the protection granted to the petitioners while order dated 8/2/24 is extended for a period of 1 month. Here, 4 petitioners, only 1, 2, 3, 4 moved this application. 5 did not move application because 5 had moved a anticipatory bail application which has been rejected. That is a fact. I don't dispute it. 4 petitioners moved. Thereafter, your lordship may now take up IA number 856 of 24.
Yes.
856.
856.
856 or 9?
856
856 ଟା କାଇଁ?
से IA नंबर जोटा दीटा कॉपी देछि दीटा IA भितर गोटा IA होछि 856.
IA नंबर किछ पढनी तो?
You tell me what you want.
Yes. Now your lordship may kindly turn. The charge sheet has been final charge sheet has been filed where I have been given a clean sheet. But pursuant to your lordship's order dated.
You have been summoned under 319. Where is the question of charge sheet now?
Yes.
My lord, I'm coming, man. My lord, IA number 14, your lordship may kindly see order dated 14/3/24. In 14/3/24, pursuant to the order dated 14/3/24, I was permitted to move an application before the learned court below.
Right.
My lord, now your lordship may kindly turn to page 8 of that IA number 856 of 24. Order dated 2/4/24.
Yes.
My lord, there what mistake was done, the counsel who was engaged by the present, these 4 petitioners mistakenly withdrew that petition which was filed for bringing certain developments. I only pray your lordship may permit me to file a fresh petition before the session judge, bringing all these facts.
Is there any res judicata?
Yes, my lord, because I have withdrawn it, mistakenly the council has withdrawn it, now it is not being entertained. That is the problem.
Can it be attended?
No.
Lordship may kindly see. One application filed by one advocate. He has got an order. Rightly or wrongly, lordship has passed the order, accepting that it is right or it is wrong. Somebody has changed. Now the advocate changed. File a miscase. Now this order is wrong. Your lordship may modify.
No, I am not
Is it
seeking
permissible?
modification. Mr. Maharaj,
Is it
please wait.
permissible?
No. What he
Please
says
wait.
that the application was moved and withdrawn.
Withdrawn.
So what wrong in that?
It was not
He
rejected. It
may
was mistakenly
withdrawn.
withdrawn.
So can it be?
Where have you moved another application before the court saying that mistakenly you have
My
moved?
lord, I have not moved, but he will not entertain because there is an
Ah,
order
you
that-
on the apprehension that he may not
Yes.
do it, so therefore you file it. What
I
is
only,
it?
I only pray your lordship may permit me, I'll move a fresh application before the court below.
No, my lord.
Let him
It's a case of
consider all
three to
merits.
two.
Council for
My lord,
the seeks to withdraw the present application to avail remedy under law. Application is
My lord,
dismissed as withdrawn with liberty.
my lord, in the
Do whatever.
meantime, warrant has been issued. They want
Yes.
to nullify your
My lord,
lordship's
I
order.
only
Whatever
pray-
permissible under law, he will do it.
My
My lord, I only pray your lordship
actually,
may-
fact has not been properly placed.
Don't move. Applications are after application getting
Yes.
creating some confusion. The
Yes.
trial court will
Yes.
get confused and do
My
something
lord,
wrong.
the advocate's mistake should not be attributed
Yeah,
to the client.
Mr. Bose, what you should have done is this application appears to be on the your apprehension only. How do you
Yes.
know that the trial court may entertain, may not entertain? You move application. If it's rejected, then come.
My lord, I only pray now one thing. Your lordship may protect me for a period of 15 days.
No,
because-
no.
Listen,
We raise serious objection to
Don't
that.
do that. Don't do that.
Yes.
Substantive
All right.
petition you file, I can understand.
Yeah.
No. Next.
My lord, I'll file a fresh petition. Let him consider on its own merit.
I have written that. Don't do it.
Yes.
19. Yes.
Oh, 19. I'm on the VC method. Item 19.
Yes.
I'm on VC.
Yes, Mr. Mohan.
Yes. My last occasion, Lordship has issued notice. Postal endorsement is no such address.
Yes.
Postal
Then
endorsement,
you
no.
file fresh address then.
Address is not found.
Let the council for
Address is not
seeks
found.
to furnish the fresh address of
Fresh
opposite party
address,
number 2.
yes. Fresh address.
Fresh notice may be issued or for a period. Okay. Next.
91.
My lord, 91 extension of time to surrender. Your lordship was pleased to pass the order on 50.
Why are you taking time installmentally?
Some few days, my lord, because the last order, my lord, that the PO was on leave.
You are supposed to appear?
15 days, my lord. From 15/4/2024, this order was passed.
Which paragraph? Which paragraph?
Paragraph 5 of the lordship's order.
You wanted to surrender before the jurisdictional court within 15 days.
Within 15 days.
Right now. By order dated 15/4/2024, the petitioner was directed to appear before the jurisdictional court within 15 days. And 15 days and seek remedy available to him under law.
Another
he seeks extension of the time for surrender.
As your lordship.
2 weeks?
Yes.
2 weeks. 2 weeks time is further granted to the
Extended,
petitioner to appear and avail the order. Avail the benefit of the order dated 15/4/2022.
Yes.
Another matter of parity may be maintained because one of the co-accused persons have already.
In the guise of extension of time, don't ask and
ମୁଁ ସେଦିନ parity କଥା କହିଥିଲି କିନ୍ତୁ ଲେଖା ହେଇନି parity ଟା
don't do that.
One of the co-accused.
Don't do that. You sought for, you are asking for extension. I have given extension and you want something.
Because Lawrence court below was pleased to allow the bail application of the present another co-accused person. Court below.
If parity is there, parity is there. Nobody can say no parity.
ମୁଁ ଖାଲି parity word ଟା ଟିକେ ରହିଲେ ଖାଲି parity should be maintained.
You have moved an application for extension of time. I have extended.
ସେଦିନ ଆଜ୍ଞା କହିଥିଲି parity କଥା co-accused ଯେହେତୁ ଯାଇଥିଲେ
That's
ଲେଖା ହେଇପାରୁନି.
That's not fair.
ଆଜି ମୁଁ ଆଜ୍ଞା ସେଇ କଥା ପାଇଁ
You move a separate application.
ପରିସ୍ଥିତି ଜଟିଳ ହେଇଯାଇଛି।
Saying that parity should be maintained. I can understand.
ସେଇଥିରେ
Your
ଲେଖିଛି ଆଜ୍ଞା
application, what is the prayer?
prayer ଆଜ୍ଞା ମୁଁ ସେ ଲେଖିଛି ଆଜ୍ଞା facts petition and ଦିଟା କଥା ଲେଖିଛି parity plus extension.
Extension I gave, that you should be happy. In the earlier order, I have said everything.
ହଁ ସବୁ ଲେଖିଛି ଖାଲି parity ଟା
You will, I have said that you will take the benefit of that earlier order.
ଆଜ୍ଞା
Parity is written there.
ନା parity ଲେଖା ହେଇନି ଆର୍ଥ
ठीक है, चलो next.
first order କୁ parity ନାହିଁ
92.
Yes, 92.
92.
490 case.
Yes.
Notice ଯାଇଥିଲା। ହଁ ବାସ୍ ବାସ୍।
You are filing? 498A. Yes, madam. Will you settle? Huh?
Settle.
Who is for a petitioner?
My lord, I am appearing, my lord.
You are appearing?
Yes, my
I
lord.
am sending it to mediation. Go to mediation and settle it.
My lord.
ठीक है?
My lord.
जहाँ mediation में जाके
Matrimonial dispute. The petitioner is taking passing up to the FIR.
Our party is present.
As a party is there. What does he want?
He is saying that need not be necessary to send the mediation and the matter has been compromised.
Alright.
Party is present.
compromise ହେଇଯାଇଛି। affidavit କାଇଁ?
Affidavit for the
affidavit
for compromise ହେଲା divorce ହେଲା
ଆରେ affidavit ଟା ଦିଅନ୍ତୁ।
ହେଇସାରିଲାଣି ନା ହବ
99 item no
1 minute one matter.
okay my lord
First senior to junior.
yes
May I pray one matter 94 below?
Yes.
Yes, I am not praying today, it will take time. May I pray for the day after tomorrow below?
Day after tomorrow, sir, it may not be possible because last hour.
Tomorrow below?
upon due to
Monday.
Monday.
Let it be Monday.
Item
94 Monday.
My 96 same similar prayer. Why is your lordship take up the matter but it is not? In the last hour it usually entry order to go to, I'm sorry.
Entry order will come.
In my case there is no entry order but I want the early disposal.
Which one?
96.
96.
Any day next week your lordship convenient. I pray only on early.
I've submitted a written order of submission. Why is it taken off?
See, 1-2 meters is heard, then the board is not moving. That is the problem.
No, it will not take a lot of time.
The very fact that you are there means it will take.
No, I don't think. So far as this particular matter, it will not take a lot of time.
What, we will try.
Yes.
14th we will try this.
My lord, my lord, item number 99 can be disposed of. It's a small prayer, your lordship.
Wait 1 minute. Dispose of, I'll dispose it.
Item 97, madam.
105.
Senior to
105, that's a covered matter.
105.
Last time that is the OPID matter. Previously an order is there. And the second case has been registered against the same company, same person, and the same order
Needs to be heard.
Yes, my lord, Supreme Court confirmed that separate cases are maintainable. Against that, Supreme Court direction, they have come again.
Date would be short.
interim order.
No. Supreme Court confirmed that the separate cases are separate. ଆପଣ ବୁଝିନାହାନ୍ତି
Petition ଟା ମୁଁ କରିଛି
ମୁଁ ତ କହୁଛି କୋଉଠି ଆପଣ why taking
It needs to be heard.
Petition, what is my petition?
I am ready.
This matter was connected, firstly, previously it was registered, second FIR. ताको challenge करूँ मैं एठी High Court रे. High Court कौन कले? Because ये tag कर दिया, ताको ये कर दिया. Against that order, EOW went to Supreme Court. Supreme Court ultimately कले नहीं, that has to be registered as a separate case. When it is registered as a separate case, same year OPID Act pass है previously, and our prayer is pass karo. This is the point, and we don't set Supreme Court wrong, and we don't challenge the order of Supreme Court. Our point, only exclusive point, is against the same accused, same company, the 6 OPID Act has been passed, and it arises of the same thing, and as everything is same.
You are developer.
My lord, 6 OPID is not maintainable.
You are developer because of that judgment of the coordinate bench.
My lord,
Which is pending in Supreme Court.
Which one?
The one which is.
Yeah, that is pending. That is pending. My point is that one in my case, yeah, I have annexed it. In my case, I have been that case also. I have been this 6 OPID Act has been passed. Here
Still,
also,
I think it needs hearing. 20th.
No.
20th.
My lord, not 20th. 20th election vote ଅଛି ମୁଁ ବଲାଙ୍ଗୀର vote ଦଉ କାହିଁକିନା 17 I will be in Supreme Court ମୁଁ 20th ରେ vote ଦେବି any date I don't object, interim order there.
Interim order, he's opposing. For interim order, I have to hear. If there would not have been opposition, I could have.
Simple.
But again, today I can't hear.
Within what I said, my lord, within 2 minutes, what I said, if it is wrong, I don't need any interim order. ମୁଁ କହୁଛି it is covered matter. 14th.
Yes.
Item 97, my lord. Item 97. Matter lastly 6 to 16th for argument, my lord. Only prayer to recall the witness 311 petition has been rejected. Last occasion, my lord has allowed, but accused has not been made as party. That's why petition is adjourned. I have filed accused has been made party and notice has already been served. They are appeared. Only sir.
Who is appearing for? 97.
Item 97.
Who is appearing for? Are you opposing?
Only some medical documents to be exhibited.
Are you opposing?
97.
He is opposing.
Prosecution has filed 311 petition which has been rejected on the ground of delay only, man.
I understand, but he is opposing. He has a right. You have implemented him.
Yes.
Now he has come, then he has a right.
Matter fixed.
Because he is accused. He has to face the blunt.
16th final was posted to 16th. 14th it will be listed higher.
How many matters? See, today, how many matters are listed? 110. I am not able to reach 110.
8 तारीख थला केस लिस्ट है पहले
सब मैटर तो से
एंट्री मॉडर में पास अर्जेंट मैटर आर्गुमेंट पे मैटर अछि
see I am loath in giving entry order. I know what happens.
सर आर्गुमेंट पे अछि से क्लोज कर दे
किछि होने the court has enough power to
আমি সেই পিটিশন গ্রাউন্ড রে हजुर मते देइतले परमिशन टू फाइल पिटिशन फॉर अर्जेंटमेंट
शॉर्ट कर देखि 20 तारिख 21 तारिख ଦେଖିବ
ଆଫ୍ଟର ଭ୍ୟାକେସନ ର କିନ୍ତୁ ମତେ ଆଡଜର୍ନମେଣ୍ଟ ଦେବା ପାଇଁ ଗୋଟେ କୋର୍ଟ ଯାହା ପ୍ରିଭିୟସ୍ ଅର୍ଡର ହେଇଥିଲା ସେଟା ରହ ନହେଲେ ଦେବେନି ଆର୍ଗୁମେଣ୍ଟଟା କ୍ଲୋଜ କରିଦେବେ।
adjourn to July, June, first week. Then counsel for the petitioner submits that he would 97, right? He would move appropriate application
For
before
adjournment.
the court below for seeking an adjournment owing to the fact that the matter is subjudicial before this court.
My lord,
What to?
may I,
100, my lord.
may I, 99, only limited prayer, your lordship. I'm not on the merits of the case. There's a application moved by before the court below by the IAC who is the investigation to decide an issue. My lord, only that because the vehicle has been handed over to a wrong person, so therefore he has moved an application to take the on the direction of the court below's order. The vehicle has been handed over, so therefore an application is moved, which is at flag A of my petition. 99.
99, I'm appealing for opposite party number 2, my lords. There are certain facts which are required to be got into, my lords, this case, my lords. We need to file a counter in this.
No, no, I'm not. So I'm not on the merit, your lordship. I'm saying my lord may dispose of the matter with a direction that there's an application moved by the IAC before the court below. That has to be decided. Only I'm not saying that on the merits. I'm not arguing anything right now. I'm saying that this is flag A. There's an application.
Why I'm saying,
I'm for the petition. I'm not on the merits. I'm not arguing.
Why I'm saying, my lords, he does
If I
have a
under-
locus
if I-
standi.
That's
If
right.
I understand, then only I can pass the order.
Yes, my lord, my kindly see. I'm saying an application has been moved before the court below. The IAC, the restoration of the JCB machine to its true owner, Lakshmindra Jena. That is the application been moved. So I am saying that this application may be dispersed. Direction may be given to the.
No, my lords.
This matter is arising out of what?
My lord, what has happened? And my vehicle was been taken by this by giving a fake false documents. This vehicle has been taken released by the court below to the owner.
That this matter is under suspicion, my lord, because this Lakshmindra Jana, the petitioner, earlier he took that JCB under a agreement, my lord.
No, sir, my lord friend is my Lakshmindra Jana is the true owner of the vehicle.
Why can't
Yeah,
people make
Maybe
it?
permitted.
Yes, sorry, sir.
My lord then keep it because my lord then keep it because I'm not saying, I'm saying my lord dispose of this matter as an application will be moved.
What was
No,
your
my lords.
application before court for which you have got?
I am not moving an application. I have not moved an application. An application
I'm
was
asking something else.
my lord.
If you have patience to listen.
My lord.
I have patience.
No,
I have patience. Okay, I have developed that.
I know.
What I'm asking is,
My lord.
whether you had moved an application 357, 450.
My lords, yes, my lords. He had
What just
indeed
meet? Just
I'm asking some question.
my lord, I had moved an application
Which was rejected.
which was rejected for which I have come here.
Therefore, you have come.
Yes.
In the meantime, what you are trying to say is, the IO has moved some application.
Yes.
To court relating to that.
That
You want that application should be
disposed of by the court below.
on that basis. I can dispose of-
Disposed of them because with the court below.
One
Yes.
minute, I understood.
Yes.
What-
457 application was first filed by the petitioner in the court below, my lords. That was rejected. Then he filed a criminal revision. That was also dismissed, my lord. He has not challenged that order at all, my lord. This is a petition that was filed by us, the opposite party number 2 in the court below. And interim, my lords, measure.
What I'll do is,
my lords.
the application which the IO has moved,
Yes.
I will give a direction to decide in accordance with the law.
Right.
Without being influenced by any observation.
My lord. My lord, in that light, disposed of this
I'm not
matter.
making any.
Right. I'm not on the merits. So therefore.
Very simple.
But my lords,
Why are you making so confused?
It is in the flag A.
Yes, my lord.
Simple.
I'm saying,
Right on.
I'm the singing.
Right on. The petitioner is agreed. अरे, The trial court will decide on its own merit without being influenced by observation made by.
Yes.
You have any doubt?
my lords, let it be taken up tomorrow otherwise, my lords.
Young man, he has some doubt.
Let it be taken up tomorrow, my lords.
No, now you have to apply your brain now.
My lords, the point is that my humble submission is that he does not have a locus standi to fight in this case because he has not challenged that criminal revision that was dismissed, my lords. Here, we had filed an application in the court below and an interim, my lords, possession was given of the JCB vehicle in our favor, and we have, after that, with due compliance with the conditions, we have already returned it is with the custody of the court, my lords. Now, how does he have the locus?
He is the petitioner. He came challenging.
Yes, my lords, but he has not challenged the criminal revision which was dismissed, my lords. He had first applied 457, my lords, in the court below. That was rejected. Then again, he had filed a criminal revision that was dismissed. He has not challenged that order, my lords. What local standard does he have that he will file this case, my lords, and object to the application that is, my lords, passed in our favor? That is my whole case, my lords. A counter is
my
needed to
lord,
file.
what he says is correct. In this
My lord, I am therefore I'm saying.
1 minute,
My lord.
Mr. Trivedi, try to understand.
My lord.
There is an order in his favor.
Yes.
Releasing the vehicle in his favor.
Right.
A right has already been accrued.
Right.
If I allow you allow this application to be considered, means his right is.
My lord, 1 minute. My lord, this application has not been given by me. It is being filed by the IIC who has investigated.
IIC is not interested. He's saying no.
My lord, kindly see have the look at the flag. It is
right
there.
which is accrued in his favor may be diluted.
My lord, that is what the investigation. That is what the investigation.
Adjourn, clear. I understood.
My lord, that is what, because
I might not have understood, but what to do?
No, my lord, your lordship has understood very clearly.
There is a release order in his favor. You are trying to upset it by.
No, I am not trying to.
1 minute. You are litigating here. Meanwhile, what had happened is IIC has moved, IO has moved an application. You are banking upon that.
No.
To upset it, finding.
No. The reason for moving the application is that because in my an FIR was lodged against the person who has fraudulent my signature. Therefore, in investigation, it is found that the documents which was relied upon by this person, so therefore it is been fraud. So therefore, an application is moved by the IO.
We'll
I am
file
not saying.
we'll file a counter.
The only thing is that I am not on the merits.
IO is behind you, and he says no.
No, my lord. My lord, only problem is that because of the pendency of this petition, the trial court is not moving on this application because of the pendency. So therefore I am saying that my lord may dispose of this criminal mischief. Withdraw will be different because no, my lord may then keep it.
Withdraw. You withdraw without prejudice. And whatever right he has.
No, my lord. If I withdraw means then I have a right to challenge. He cannot say me that I don't have a legal standard to challenge an order.
I will simply say, I am not interfering in this matter, and the application moved by the IO will be decided independently without being influenced by.
My lord, that in that like disposal.
What do you say? Now, without being influenced means this, I am diluting this order, which is there in favor. No, it's very difficult.
My lord, then keep it. Then I'll satisfy your lordship. How this? What is the story behind it also?
It's very difficult. Yes, next.
Under 106, my lord. Conviction matter under section 138 of NI Act, my lord.
Yes.
And dispute has been settled, my lord.
Where is that?
My lord, I pray, my lord, and Monday, my lord. Both the parties will present, my lord. 106, my lord.
Land counsel for the petitioner submits that this dispute is arising out of a complaint under section 138 NI Act. The parties have settled the dispute. They would be appearing before court on next date of hearing. Reach the matter on 15th.
Yes,
Monday.
Monday.
Monday, my
13th.
My lord, item 100, my lord. 100 matter has been settled. Money has been refunded. And
where are they?
They are, my lord, on virtual court. It is 5 o'clock. It has been closed.
Yes. For the opposite party, my lord. Last occasion, your lordship has been directed to appear on virtual court. Now, opposite party has already appeared today as present. And if your lordship say, then
where is he?
She will come.
Influence करना है तो कौन आपको 25 lakhs केमी देले चेक कर देले ना ड्राफ्ट कर देले
20 lakh RTGS कोले 5 lakh draft
नहीं आपको श्योर ना थी 5 lakh कौन देले कैश रे
affidavit ଦେଇଛନ୍ତି
कैश ଦେଇଛନ୍ତି
नहीं कैश नहीं
आओ
RTGS 20 lakh RTGS को चले draft rate 5 lakh
ड्राफ्ट नंबर ଦେଇଛନ୍ତି
आया
नहीं कहीं ड्राफ्ट नंबर कहीं दी
The first page.
फर्स्ट पेज रे कोड लिखते if you have given 25 lakhs you should have written na
No, less.
where have you
That is the money receipt and agreement is there. In that I have mentioned.
On
20 lakh.
That is the instance of opposite party number 2 FIR number so and so FIR nahi 1cc case na 1cc case Once is converted to.
No, no,
One
once is
CC case
once-
870 of 2022 was registered against the petitioner. Where are the petitioners?
Not present because.
Why? They are VIP.
No.
Then?
No, se কথা নাই ধরা যে পলিটিক্যাল লোক তার নমিনেশন ফাইল করার ଥିଲା ଆଜି ତାର ଲାଷ୍ଟ ଡେଟ୍ ନୋମିନେସନ ଥିଲା ହଜୁର
ଆମେ ସବୁ free ଏତେ ସବୁ ବୟସ ପାଞ୍ଚଟା ନାହିଁ।
ନାଇଁ ସେ କଥା ନାହିଁ ହଜୁର ସେମିତି କିଛି ନାହିଁ ଯେ ଆମେ ଆଭଏଡ କରିବା ପାଇଁ କୋର୍ଟକୁ ସେଇଟା କିଛି ନଟ୍ ମାଇ ଇଣ୍ଟେନସନ
I will impose a cost of 10,000 rupees to be deposited to bar.
No.
Because of absence. You can't have the luxury. Accused means accused. He has to come. You can't have the luxury of not coming to the court. And lawyers, judges, and everybody will keep on working till 5 o'clock. Give 10,000. Right. The allegation against the petitioner is the petitioners are not present in person today. However, the petitioners are how many petitioners? Petitioner is not present in the court today. However, he is being represented by his counsel. Letter counsel for the petitioner submits that the petitioner is he's contesting or what?
No, my lord, not contesting.
He's
The proposer
political activist. Due to ongoing election, he could not present in the court. However, he has made good the payment of rupees 25 lakhs to the complainant. The complainant is present through virtual mode and represented by her counsel, who identifies her, and she has also filed a self-attested copy of her Aadhaar card. On query from the court, she submits that the dispute was pertaining to 22 lakhs, whereas she has got 25 lakhs from the petitioner on settlement. She has received 20 lakhs through RTGS, and for 5 lakhs she has received by way of bank draft. The opposite party number 2 has also filed an affidavit dated 30/4/2024, which is taken on record. In the affidavit, she interiorly stated that after receiving the settlement amount of 25 lakhs, she has no grievance left against the petitioner. The counsel for the petitioner has also placed on record a money received and an agreement by which the parties have settled their dispute. Mr. Ragada and Mr. Mahapatra appears for the Mr. Ragada and one CC case. Opposite party
Brahmanand Das.
Sorry, Mr. there is no problem. One CC case. Since the dispute is inter-se party dealing with the financial issues, and they have settled their dispute amicably, and opposite party number 2, who is the complainant in the case, is not willing to prosecute the petitioner anymore. Therefore, the present case is squarely covered by the judgment of the Supreme Court in Gyanchan so and Quas. Next paragraph. Since the petitioner being an accused in a 1 CC case is not present in the court today, he is burdened with a cost of rupees 10,000 rupees. Then you pay, you are a politician, you have a lot of money.
ଏମିତି 3 ଲକ୍ଷ ଟଙ୍କା ଦେଲାଣି ଆଜ୍ଞା 3 ଲକ୍ଷ ଟଙ୍କା ସେମାନେ ଘର ଭଡା ପାଉଛନ୍ତି ଆଜ୍ଞା ନେଇକି 19 ମସିହାରୁ ଘର ଭଡା ମାସକୁ 15,000 ଲେଖା ଆଉ ନାଇଁ ହଜୁର ପାସ କି 1000 ଗୋଟେ ପନିଶମେଣ୍ଟ ପାଇଁ ଖାଲି କୋଟା କହୁ ଜଷ୍ଟ ଫର ଲର୍ଡସିପ ଦେଇପାରିବେ ବହୁ କଷ୍ଟରେ 25 ଲକ୍ଷ
criminal cases are not quashed in the absentia. This is the law.
ନହେଲେ ଆଉ ଗୋଟେ ଡେଟ୍ କୁ ରଖନ୍ତୁ ଆସିଯିବ ସେ
5,000 ପାଇଁ ସିଏ
କାଲି ରହୁ ନହେଲେ ପରଦିନ ରହୁ
କଣ ପାଇଁ
ପ୍ରେଜେଣ୍ଟ ୟୁଲ୍ ବି ପ୍ରେଜେଣ୍ଟ
ବାହାର association ଦଉଛନ୍ତି
ଏତେ ପଇସା ହଜୁର ଦେଇପାରିବନି 25 ଲକ୍ଷ ବହୁ କଷ୍ଟ ଧାର ମାର କରିକି ଆରେଞ୍ଜ କରି ଦଉଛି ହଜୁର ବେକାର ଲୋକଟା
What kind of
ନାଇଁ ହଜୁର ବହୁତ ଡିଫିକଲ୍ଟ ରେ ଅଛି ଦେଇପାରିବ ସେ ଘର ବିକିଥିଲା ଆଜ୍ଞା ତାର ଅସୁବିଧା ଥିଲା
okay, make it 3,000. 3,000. Okay. 3,000 to be paid to the High Court welfare. ठीक है? बस. Okay. Next. ଆଉ ଦିଟା ଖଣ୍ଡ ମ୍ୟାଟର ରହିଲା ସବୁ
ଆଉ ଟିକେ କମେଇ ଦିଅନ୍ତୁ ହଜୁର
10,000 ରୁ 3,000 କରାଇଲାଣି ଆଉ କମ
ସେ 3,000
नो प्रॉब्लम दियନ୍ତୁ next 102 yes 102
the cognizance causing no proceeding
everything
other accused persons are there na
qua the petitioner obviously qua the you can't do that
proceeding cause ହେଇଗଲା ଅନ୍ୟ ପାସ୍
नहीं you qua the petitioner always first of all the other accused person are not party and the accused who is party is not there is this qua the petitioner very carefully right now yes next
May I please, your Lord, sir? I am for the petitioner.
yes what do you want ma'am adjourn
Adjournment.
entry mode
Opposite party is not filed their counter.
yes yes next
102.
103
ଆଉ ଗୋଟେ 104 ଅଛି ବୋଧେ
103 103 ବି adjourn କରି ଦିଅ
104
I am appearing for the petitioner.
I have instruction my lord to appear on behalf of Opinot 2.
yes
Just I am filing Bhaklatna my lordship. Otherwise I will also keep
not
it.
authorized to step in for opposite party number 2 and 6 time to file the reply adjourned okay.
Interim order to be continued.
Interim order if any
102 रे entry matter.
Interim order mean adjournment was if he will
No,
speak.
no, interim.
नहीं पूरा लिखा है जी adjournment যদি check करी
102 रे भी entry matter ଅଛି.
Lord and counsel
102 रे भी entry matter ଅଛି. It
the petitioner would move before the Lord and trial court for an adjournment.
The interim order to continue.
oh that same arrangement
107
same
Deep log lights.
1 minute I am coming to 105 adjourn 106 107 दियो की आसनांती
Your lordship I am present 107
Small distance, 2 by distance matter.
no who is the petitioner here
yes your lordship and the petitioner
yes okay offense
307 and 326
Other allied offense are there, my lord. But a conviction under section 307 and imprisonment 7 years.
have you seen this
what does
have you seen this judgment
no I have not seen it.
କହି ଦିଅନ୍ତୁ
ସେଟା ଦଉଛୁ ଟିକେ viewer ଯାଇପାରିବେ no matter what happened in this case actually they have not got the instruction but I have got the person in custody instruction call for shortfall from the IAC his custody is 14/10/2002 26/9/2003 then in the appeal period 10/8/2004 to 30/8/2004 these are terms ଥିଲା 3 years near about 3 years
କେତେ ସମୟ କେତେ ରହି
3 years ପାଖାପାଖି
3 years ରହି ସାରିଲେଣି
3 years ପାଖାପାଖି ରହିଥିଲା ସେତେବେଳେ during course of investigation and during trial period
offense
offense
307 and 326
307 326 ଏଟା କନଭର୍ଟ କରିକି ପିଓର ଛାଡ଼ିଲେ ଚଳିବ କିନ୍ତୁ କନଭିସନ ଯିବନି କନଭିସନ ରହିବ revision dismiss melody recipe converted to lesser offense and
Mr. Raghunar
there is a problem your lordship
the petitioner go to date दियନ୍ତୁ petitioner was in custody
since 14/10/2000 what happened another thing he's saying that after disposal of the appeal my lord and pendency of this revision he's saying that he has been arrested that is term ସେଟା ଜାଣିବାକୁ ପଡିବ
arrested in this case
ସେ କଣ
ଏଇ କେସ ନା କୋଉ କେସ ରେ
yes lordship this case your lordship 7/8/2011 your lordship NBW was issued
1 minute
After-
1 minute
yes
ଏଇଟା ଲେଖି ଦା ଫାଷ୍ଟ ରେ କୋନ କେତେ
ସେଲା 14/10/2002 26/9/2003
3
then 10/8/2004 to 13/8/2004
4 ଏଠି କଷ୍ଟଡି ଥିଲା Land Counsel or the petitioner submits that during the pendency of the revision petition also, he was taken into custody on.
Your Lordship, custody got the news. Order to LCR, the
He was arrested.
Your Lordship, 7/8/2011, Your Lordship, NVW was issued against the convict, Your Lordship. Whether he is arrested or not, I have no.
NBW should छोड़ो ना, छोड़ो।
18 थी।
नहीं नहीं।
18 2011
ठीक है। तो ऑलरेडी अंडरगोन करी ताली स्लिप कर दो, ऑलरेडी अंडरगोन करी तो क्लियर कर दो, चलो ठीक है। ये जजमेंट साथ रखियो मत दे दो। ठीक है।
I have also given some names, my lord. Your Lordship.
I give some names, those who can be amicus curiae,
My lord.
and really can assist her.
How you will चाहे वो रहता
मोबाइल नंबर दे देना 883 बोल ठीक है 8 कर दो
जान दे दो ना
any revision
ये instruction also
हाँ no problem
Beg pardon, my lord. Item number 110, Your Lordship. Your Lordship.
Yes.
Your Lordship, appoint me as a amicus in this matter, my lord. In this case, Your Lordship, the LCR is not received, my lord. Your Lordship.
You are the amicus.
Amicus, my lord. I am for the. This
I am reserving the judgment if we've been writing. Whatever you want to say. Okay.
Item number 110, Your Lordship.
I know I am reserving this judgment. You give a written submission.
My lord, grateful.
And please contact with Mr. Ragada. He is giving a judgment. Today he has given a judgment.
My lord.
Whether that can be utilized in your case or not, you tell me.
My lord.
In written submission.
Judgment
in 110.
एक इस तरह से हमें reduce कर दो ही जाएगा 7
सब reduce करी खत्म करो.
There is alternate
period of custody.
Period of custody, my lord, almost.
You give in writing.
My lord, I will give in writing.
Give in writing so that we can discuss.
Because my lord, LCR is not
99 maybe
available with the
next week
record.
candidate. Next week. Next
19,
week.
yes.
Next week 19.
99 next week.
Your lordship, my small request, my lord, in this case, the LCR is not there, my lord, in this record. The SDGM sent dispatch a letter to this honorable court, your lordship.
LCR asini.
LCR is not there. And the two
980
depositions are met.
110 LCR asini.
My lord, two depositions are matter, my lord. Maybe the petitioner will acute with that matter.
110 लिखो. Mr. T.K. Sahu, learned amicus, submits that LCR in the case has not yet been received, so therefore he can't effectively assist this court and request for call for the LCR. LCR would call for LCR and list it before this vacation. Urgent.
Urgent. Your lordship, the letter of SDGM, learned SDGM is there. He mentioned something, my lord, in the letter. Your lordship may kindly peruse before passing the order.
कौन कौन
I say flag A रे अछि कौन लिखि जंदी मो तो जानि flag A रे अछि
वाला पर कोड वाला पर लिख दो
remark column there is endorsement that release and read some problem there. They are not able to locate.
But my lord.
Your suddenly 1 year period. This is common under this under this decision. Disposal आज कर लीजिए.
Mr.
Sahu.
My lord.
Mr. Ragada and Mr. Maharaj has given a judgment.
My lord.
They say that you are covered by that judgment. And it's very difficult to locate the record, it seems.
My lord, the learned SDGM dispatched that letter.
Yes.
So, my lord.
So therefore, read that judgment and tell me tomorrow so that we will.
No, tomorrow, my lord. Your lordship
Tomorrow.
may kindly post this matter
Give
tomorrow.
it tomorrow.
Just I am sending the.
Yes.
My lord, 99, maybe with a liberty to move application can be withdrawn also. 99, I'll move an application for the, with a liberty to move application. No, my lord, keep it tomorrow or next week also. I'll do the same, make the same prayer that can be disposed of on that day.
Liberty to?
Move an application there before, because it's the pendency of this petition is creating problem there actually.
That is the problem. But when it is his petition. He wants to withdraw. Who can stop?
With liberty to move an application. Only liberty has to be granted.
Please it tomorrow.
Milo. Deeply obliged.